You have your lordship's kind leave to mention. I know, my lord, your lordship deprecate
Monday.
such practice.
Monday. If you want leave granted.
My lord,
No further mentioning. No.
extension of interim order.
No. Monday.
My
Yes.
lord, may I take a leave, my lord?
No, leave granted. I've told you, don't mention, leave granted.
I know, my lord, your lordship deprecates.
For judgment, item number.
I'm putting it in the first week of May. All right.
My lord, urgency is, my lord, 25th April is the auction date, my lord, at 10:32. My lord, can it
When did you receive the notice?
my lord, just
When did you receive the notice that it is going to be on 25th?
my lord, just notice received on 19th, my lord.
19th. Very well. On 27th. Yes.
My lord,
Call
I
on the
know,
list,
my lord,
For judgment, item number 1.
I am for the state lordship.
However, in any view of the matter, the petitioner is entitled to a final order by the respondent number 4. The respondent number 4 shall hence consider the effect of Kalyani Samanto Mondal as decided by the Supreme Court on 1/9/2021. Within a period of 6 weeks from date, the petitioner shall be heard in the proceedings. The respondent number 4 shall take into account the allegation made by the petitioner with reference to violation of Article 14 of the Constitution to the extent of similarly placed persons being granted certain benefits which have been denied to the petitioner. It is made clear that the respondent number 4, Director of Employment, shall pass a reasoned order within the time directed without being influenced by any of the views expressed by the court. A copy of the reasoned order shall be made available to the petitioner within a week from the date on which the reasoned order is passed. It is also made clear that the court has not gone into the issue of the petitioner's eligibility for nomination to the concerned post. WPA so-and-so is accordingly disposed of in terms of the above.
Grateful lordship. Deeply
Grateful,
obliged.
Item number 3.
Lordship, this was my writ petition. I wish to withdraw the same, Your Lordship. At that point, the DRT presiding officer was not sitting in office, Your Lordship. Now he's back. So we're pursuing the remedy in the DRT.
That's my number 427.
Learned counsel appearing for the petitioner seeks to withdraw the writ petition on the ground that the DRT is functioning. Stop. The writ petition counsel submits that the writ petition had been filed when the DRT was non-functional. Stop. Next, WPA 5649 of 2023 is accordingly dismissed as withdrawn. Interim orders, if any, shall stand vacated.
Grateful, dear Lordship.
Item number 4.
My lord, this appearing at my instance, my lord, lordship usually, my lord, releases.
Yes.
My lord, for this petitioner, lordship usually releases, my lord, the writ petition. These are previous orders passed by your lordship.
Yes, this matter is released from my list. Stop. Similar orders were passed in other matters involving the parties. Stop.
Grateful one.
Item number 5.
Mr. Shuddhaswata Banerjee is on his legs. Mr. Shuddhaswata Banerjee is on his legs now. There's a matter, my lord, yesterday, lordship was pleased to feel.
Pursuant to matter direction, the STO is present, the BDO and the concerned deputy magistrate is also present.
Where are they?
But she is the STO, my lord. My lord, will kindly have a look on the structure. Your Lordship was,
Who are the others who are present?
my lord, the BDO, concerned BDO, who had ordered the demarcation,
Yes.
and the concerned deputy magistrate, who had instructed at 1:59 to my lord, us. All of them are present, Your Lordship. My lord.
Very well. And who had ordered the demolition?
My lord, in terms of, my lord, what I gather, my lord, from them, my lord, in terms of the order dated 29th, my lord, what has happened, my lord, on 21st, this matter had appeared.
Yes.
My lord, when 21st, this matter had appeared, my lord, hearing notice was again given on 29th. My lord, the petitioners were directed to appear on 29th, on 21st of March.
Yes.
On 29th, my lord, the petitioner admitted that yes, there is an encroachment and we'll remove it by ourselves.
Yes.
So, my lord, my lord will kindly take note of these structures. This is absolutely, my lord, according to them, my lord, what I have gathered, my lord. My lord, because this was absolutely of a temporary nature, my lord, and there was an admission by the petitioner to remove,
By the second petitioner.
by the second petitioner, my lord, to remove the structure by himself. My lord, no order needed to be passed declaring him unauthorized, my lord, eviction, my lord, encroacher, because he himself admitted to be that. That is also pleaded in the writ petition, my lord. My lord, on let us, my lord, segregate two issues.
May I just, I'm sorry, but today he is not reopening the hearing. This is not, this Your Lordship has called upon them to come up and answer why they've acted contrary to the law and with malice in law. The answer to Your Lordship's query, who has passed the order? It's Subdivisional Magistrate Jongipur. Today, my learned friend, because his clients are here, are not going to reopen an order which has been passed yesterday by Your Lordship. A full-fledged hearing for over an hour was granted to both the parties. He came and considered that what has happened is incorrect. Today, just presence of two parties here who have passed the order can't make the court relook an order which has already been passed on facts which were admittedly contrary to law.
Subject to, my lord,
Who
correction
is
by
Mr. Chatterjee? Who is the person who said that line in Bengali that we will let you do whatever you want, we will see? Who is the person who said
may I
that?
inform, this I have not.
Well, it's been told to my client, it was the BDO.
Lord, if my learned friend could, Lord, he said he had the video recording of it. If he could, Lord, even today, yesterday, Lord, I had put in my efforts to assist the court. Even today, Lord, I'll have the same endeavor. My learned friend says because my clients are here, I'm trying to.
No. Mr.
shift-
Chatterjee, I will keep that argument aside.
My lord,
Just answer my question. That's all. Who said that let the court do whatever you want? We will
My lord, will
demolish that
kindly
structure.
first appreciate, my lord, today, my lord, I was not present in the site, my lord. I have to rely on whatever they say, my lord.
Yes, of
They are
course.
saying,
That just answer the
video,
question. That's all.
video says, my lord, who was present at the site, he says no one said that. If my lord, my learned friend could please assist the court showing it.
Mr.
thanks to-
Banerjee, file an affidavit to that effect.
I'll file an affidavit to that effect.
File an affidavit to that effect, stating which person said that.
I'll do that.
That let the
I'll-
court do whatever the court wants, we will demolish
I'll
it in the
name the
meantime.
person.
Because I will put that person behind bars.
I'll do that.
Because this has to be done. I will
Absolutely.
just put that person behind bars.
Absolutely.
Because they don't realize the power of the court.
Absolutely. My lord.
And what happens, the consequences of subverting legal processes.
Absolutely. My
My
lord,
lord,
absolutely.
one more thing, my lord, I must bring it to Your Lordship's notice. Despite this order that was passed at 2 o'clock, my lord, from 3:30 p.m., this is what has continued to go on till 7:30 p.m. This is today morning also, this is going on. Despite an order that was passed,
What is going on?
my lord, I'll show to Your Lordship the photographs. There are excavators. The same photograph is there. I'll show one to my learned friend. Scooter tag key. This is still going on. My lord, Your Lordship will find there's a man in a pink colored shirt at the right corner. That's my entrance to my house.
This is the
This is the entrance to my house. This is my poultry farm. And just look at the condition of the land in front. The land has been completely grazed. And this is yesterday from 3:30. And I indicated, that I will not have to serve a copy of the order because Mr. Chatterjee was appearing. This is going on despite yesterday's order.
No, the photographs don't give a time though.
Lord, I'll affirm an affidavit.
No, there's an issue, my lord. May I, my lord?
When did you communicate the order,
No,
Mr. Chatterjee?
immediately, my lord, immediately.
What
No.
is immediately? What time?
Whenever your lordship, the moment your lordship has passed the order, my lord, I am informed. My lord, may I? Lord, there are three aspects of the matter. First and foremost is, my lord, if there is any attempt to overreach the orders of this court. First and foremost, my lord. Second, my lord, on merits. There is third issue, my lord.
Mr. Chatterjee, I am not concerned with the merits arguments now.
Absolutely. my
The only argument
This
which
will
is
not-
before me
this-
is, please let the court finish.
Hello.
The only argument which is before me is whether 1962 Act, it is not about this court. As I said, it is not about me or this court. It is about whether you are following the law.
Absolutely.
The 1962 Act lays out a procedure under 456, under 345, whether that was followed, and whether, number two, whether the respondents, after knowing that a writ petition has been filed and has been kept at 2 p.m., went ahead to demolish. That is, those are the 2 points, and there is no argument which I'm going to entertain on merit.
Second
Now.
point, my lord, second point. First on the second point, my lord, according to my lord, will kindly take it that whatever I am submitting, my lord, that's on instruction, my lord. I cannot look into whether actually what they're telling is, I have to take that to be sacrosanct. Lord, the BDO says the mail was sent to the BDO's office. Official address of the BDO at 10:51 a.m. The SDO was never served with a copy of the writ petition.
Doesn't matter.
Now, my lord,
If only one official is served, that is enough.
absolutely.
There is no requirement to serve all the respondents.
I'm not saying, my lord, there is no any requirement to serve
So
all.
whether the SDO got or not is absolutely irrelevant.
My lord, according to the BDO, my lord, the mail was served to his official address. My lord, during such time when the mail was served, already the demolition proceedings was being carried on
So what?
at the site. No, my lord,
Even if the demolition is started, it should stop immediately.
my lord, when he came to my lord, kindly give me 1 minute.
My lord, while he takes instructions, this has been demolished by the BDO. It's available from the impugned order where SDO directs the BDO to go and demolish.
Mr. Chatterjee, I am directing Mr. Banerjee to file an affidavit. I want to know
Absolutely.
who said
Absolutely.
that let the court do whatever the court wants, we will demolish the structure.
Absolutely.
I just want that on affidavit, and that person will go behind bars.
My lord will give
For
me
what?
one opportunity. My lord, again, my lord will kindly know that the officers will exercise. My lord, I am an officer of the court. My lord.
And Mr. Chatterjee, I don't have to tell you the 1962 Act
Absolutely.
and
my
the
lord.
provisions. It sets out a procedure. Whether a person comes and gives admission, that is different. But your 1 minute, please. Your clients, they give one notice to the Trinamool MLA, the other to the BJP MLA. What, for hand-holding?
I'm
To
telling you.
sanction an
My lord,
illegal act?
Again, my lord, I am on instructions. My lord, whatever I am submitting, my lord, my BDO says whenever, because they are the public representatives, whenever
The
my lord, he says he can
messages,
file
the
an affidavit.
messages given to the Trinamool and BJP MLAs is to send a representative that you stand here, we will do whatever we want.
My lord will see it's
It's
just
kind of a political blessing.
maybe read that letter once more. দাঁড়ান, চুপ করে থাকুন। বিজেপি আছে, তৃণমূল নেই, ওসব একটু কিছু হয় না। Maybe read the letter, my lord. Maybe read the letter dated 18th of April 2023. Deployment to the officer in charge, Suti Police Station, Murshidabad. Subject, deployment of police personnel for final demarcation and layout for construction of Shushasto Kendro at such and such. As per ordered by the subdivisional officer, Jongipur, dated 29th March 2022, the undersigned likes to inform that the final demarcation and layout for construction of the Shushasto Kendro under such and such will be held on 19th April 2023 at 11 a.m. You are requested to deploy police personnel for completion of government work peacefully. The details land is mentioned herein below. Lord, I have not requested, please, my lord, for possibly, my lord, my learned friend had urged this to bring it to your notice.
Then why have you given,
Merely the
please,
copy way
Mr.
forward.
Chatterjee, why will you give copy of that notice to the
Lord,
two
it-
political functionaries? Why?
I'll explain, my lord.
Does the act require you to do
No, my
so?
lord, but
Then
my lord, it is my instruction that whenever any eviction, because these are public, my lord, premises, whenever there, my lord, he says he has record. I have not gone through, my lord. He says he has records of last 50 letters. Any letter of this sort of importance where public at large might be affected, a copy to the public representative has been sent. My lord, this construction, proposed construction is of a Sushasto Kendro.
doesn't matter.
No, my lord, that is the
Mr. Chatterjee, whether it is Shushastho Kendro, whether it is Shastho Kendro, doesn't matter.
It-
You just have to follow the law. That is all.
Today it doesn't matter to us, my lord. For this court, it doesn't matter it is a Sushasto Kendra or it is a toilet.
Mr. Chatterjee, no. I am absolutely clear in my mind. Whether it is a health center, whether it's a rehab center, whatever it is, you have to follow the law. That is all.
Absolutely. I mean,
That
there's
is
no
all.
dispute on
And that
that.
has not been followed in this
I
case.
cannot dispute that. my
Mr.
lord.
Banerjee, you file an affidavit by Monday, please.
I'll do that. My lord, in the meantime, your lordship will kindly grant a stay of what is going on in front of my premises.
If the demolition is continuing, then
My lord, your lordship will have a look at the picture, my lord.
yes, the BDO, the SDO, and who else is present in court?
And the deputy magistrate, my lord.
And the deputy magistrate, all of Murshidabad are present in court. Stop. Learned counsel appearing for the state respondents submits that the structure was demolished by reason of an admission made on the part of the second petitioner. Stop. It is also submitted that counsel also seeks to argue the matter on merits. Stop. Next. Since serious issues have been raised on behalf of the petitioners, let these allegations be recorded in an affidavit, which is to be filed on 24th April 2023. Stop. List this matter on that date. Stop. Next. It is also made clear that if the demolition is continuing as of now, there should be a stay of all further activity in relation to the demolition until the court hears out the matter on the returnable date. Stop.
My lord, should I have an opportunity to deal with the affidavit?
By Monday, if you have the time.
My lord, may I pray for some time?
No, by Monday. Mr. Banerjee, give him the affidavit on Sunday, please.
I'll try and give him an advance copy on Sunday.
As an informal gesture, please do it.
Yes, yes. Advance copy.
May I have 1 minute of my letter? Just one.
Personal appearance is dispensed with.
My lord, your lordship, there was another direction to pay an amount of 80,000 by 12:30. My lord, we have brought the check. I have brought my SDO has brought a account pay check. Lord, may I, my lord, hand up? The BDO concerned BDO has brought it, my lord. My lord, may I hand up without prejudice to my rights of condition? Because
Without prejudice.
I'm saying
That's
this,
a direction of the court.
absolutely, my lord, to direction of,
Absolutely, with
Lord,
prejudice.
my lord,
Yes,
may I-
the check of
may I-
rupees.
may I, my lord?
There is no without prejudice.
me-
It's,
my-
I am going to issue suo motu contempt against your clients.
Lord,
What do you
my
mean
lord
without
will- Your
prejudice?
lordship will appreciate. Your lordship, I have not, as on date, my lord, I have not taken your lordship to the merits of the matter. The court has not,
You can't.
I-
As of now, you can't.
as
Mr.
of
Chatterjee.
now. Now, my lord, this cost was imposed on the pretext that this act was not followed properly. My lord,
Mr. Chatterjee, please, please. Yes, the check of rupees 80,000.
my lord,
The respondents, comma, who are present in court, comma, are directed to hand over the check of rupees 80,000 to learned counsel appearing for the petitioners. Stop.
my lord will kindly withdraw these lines because she says she doesn't has the approval for it, my lord. My lord will kindly delete this portion of it. Let them, my lord, if they hand over the petitioner in terms of my lord's order, they will very well, otherwise, my lord, they will face the music, my lord.
What approval? Approval for what?
My lord, since this fund needs an allotment, this, my lord will kindly delete this paragraph, my lord.
Delete which paragraph?
Last paragraph that your lordship has recorded that the check has been brought and handed up to the petitioner.
They will hand over the check to the petitioner. What should I delete? Call on the
They-
next matter, please. Ask her that I will put her in jail.
Well-
Ask her not to make these submissions in court. Next.
Item number 6.
May it please your lordship. Number 5.
Lord, I beg to appear on behalf of the petitioner. No, my lord, the petitioner, she is an aspirant, my lord. She has appeared in the preliminary examination as conducted for the West Bengal Judicial Service.
Mr. Bhattacharya, microphone.
She has appeared in the preliminary examination,
Yes.
but in connection with, my lord, the West Bengal Judicial Services. No, my lord, I will not take much time, my lord. I'll, my lord, beseech my lord to come straight away.
Mr. Bhattacharya, the law only, please.
Yes, my lord, the law, my lord, the guidelines were laid down, my lord, in Malik Mazhar's case, my lord. The timeline and the guidelines. Now, paragraph 7 to Malik Mazhar. Hi, please.
Public Service Commission will agree.
Now, my lord, PSC Ashani,
The Public Service Commission is the answering respondent.
we have
Needs to
effected
be-
service, my lord. Where is the
When did you serve them?
My lord, yesterday, my lord was pleased to grant leave, my lord. We have effected service
How
yesterday.
have you served them?
My lord, hand service, my lord. All the respondents have been served by hand, my lord.
By hand?
By hand, my lord.
Very well. Yes. What is the case?
No, my lord, in a nutshell, my lord, now the preliminary examinations, one of the petitioner appeared.
This you said was a judicial service
Yes.
examination? Yes. Of
No.
which year?
My lord, for the present year, my lord, 2022, my lord, the examination was on the 23rd of March, 26th of March, 2023. 27th of March, they come out with the key answers. Initially, there was the first set of the key answers. Now, thereafter, my lord, at page 63, they came up with another key answer sheet,
Mr.
my lord.
Bhattacharya, don't say they. Tell me who
My
is
lord, it's the
meaning.
Public Service Commission, my lord.
Yes.
So on 18/4/2023,
Page 63.
63, my lord.
Yes.
My lord, these are, my lord, the key answers. My lord, why I am referring to this? Sheet টা দাও। আরে my lord কে দেবো এটা? হাতে লেখা sheet এরকম ভাবে যশোরকে দেওয়া যায়? My lord, I have made a compilation to make it more lucid. Other side এর জন্য দাও। No, my lord,
How many petitioners before the court?
one petition. Only one petitioner.
Yes.
No, my lord, there are two aspects, my lord, insofar as, my lord, the grievances are concerned. First is, my lord, there are 6 key answers, my lord, which are wrong. The wrong answer has been earmarked. My lord, we'll find it, my lord.
There are 7 answers which are
I'm
wrong.
sorry, my lord. 7 wrong answers, but there is one heading on the left, and on the right hand side, my lord, it's arbitrary award of marks. So 7, my lord, the answers are wrong, my lord, in the key answer.
Yes.
But I can show the questions, my lord. My lord will find it at page
No, but Mr. Bhattacharya, I can't understand the chart. It says, look at this, look at the left-hand column, please. It
Yes,
says, for example, question 48, the second one.
yes, my lord.
Correct is section 34 IPC. That is the correct answer.
No, my lord, kindly takes page 43, my lord.
Because I can't follow the
No, no.
chart.
Question 48 is at page 43. Now, question 48 is section 34 of IPC. There are 4 choices. Creates a substantive offense, that is A. B is a rule of evidence. C is both A and B. And D is neither A nor B. Now, the key answer states, if my lord kindly takes page 63. Now, serial number 48 on the second column.
Yes.
Now, it says that neither A nor B. That is the key answer. This is again set A, my lord. The
1
question,
minute. You're looking at page 43,
my lord,
question 43.
page 43, question 48.
48.
Madam.
Yes, yes.
And the key answer,
Is neither A nor B.
well, the key answer says that neither A nor B will be the correct answer. But my lord, it is both A and B, my lord. Is a rule of evidence, my lord. That will be the right answer.
Very well.
So, my lord will find that at page 63. My lord, thereafter, if my lord kindly takes page 47, question number 81. Now, the question was, for a suit to enforce a right of preemption, the period of limitation under Article 97 of the schedule is, now there are 4 options. A is 1 year, B is 2 years, C is 3 years, and D is 12 years. Now, in the key answer, they have my lord earmarked 3 years to be the right answer. Whereas my lord, the correct answer will be 1 year.
Yes.
So thereafter, my lord, kindly take page 48, question number 91. The question is, Article 6 enshrines the provision conferring rights of citizenship of certain persons who have migrated to India from Pakistan. Which one of the following provision is incorrect? Now, there are 4 choices. A is he or either of his parents or any of his grandparents was born in India as defined in the Government of India Act 1935. B is such person has so migrated before 19 July 1948. C is such person has so migrated on or after 19th of July 1948 and he has been registered as a citizen. And D is such person has got married in India. Now, against this question 91, they have earmarked A as the right option, completely ignoring the fact that the question was that which one of the following provision is incorrect, not which of the following provision is correct, because this is the correct provision. So D would have been the correct answer, but they have earmarked it as A. So, my lord, these are, my lord, the mechanical action and non-application of mind, my lord. I am on, my lord, the question of arbitrariness, my lord. But this is one aspect, and thereafter, my lord, the other aspect is, my lord, now there are 6 questions, my lord, that is against the right-hand column, my lord. 6 questions.
Yes.
Now they
You're
have, my
referring
lord,
to the chart.
in the chart, my lord.
Yes.
Question 53, question 70, question 3, question 73B, question 98, question 150, and question 181. Now they have decided, my lord will find, if my
No,
lord
so
kind-
these, you have segregated these 6 questions as the correct answer. And
No.
your correct answer doesn't match with the key answer.
No, they have said that irrespective of persons attempting or not attempting,
Yes.
1 mark will be awarded to all for these 6 questions. Now, my lord, insofar as this particular examination is concerned, now this particular examination, my lord, will find that at page 31, it has been stated that there is a negative marking system, my lord. My lord kindly takes the third last, my lord, box, my lord, at page 31. So it states that there shall be negative marking for each wrong answer to multiple choice questions, MCQ type, which will also be printed on the top of the question booklet.
Where are you seeing that,
But
Mr.?
page 31,
Yes.
the third last box, my lord, deduction of marks.
Yes, yes.
Yes, it states that there will be a negative marking for persons attempting, my lord, the questions. Now a decision has been taken. My lord will find it at page 6.
No, so Mr. Bhattacharya, are you saying that this was not done? That there was no negative marking for the
No,
wrong
my lord, what
answers?
they have now, my lord, what was the object, my lord? The object is, my lord, Malik Mazhar lays down, my lord, the Supreme Court has laid down guidelines, my lord. Then, my lord, it has to be, my lord, the preliminary examinations, the view is, my lord, the same will act like a stainer.
The same will
There-
act like
A stainer, my lord, they will.
yes.
My lord, there are 8 vacancies, my lord, insofar as, my lord, the general category is concerned. The ratio as per Malik Mazhar's case is 1:10 against each of the vacant posts. So there will be a total of 80 candidates who will be qualifying
Yes.
at the final stage, my lord. Now the object of, my lord, the preliminary, my lord, may I just place this Malik Mazhar's, my lord, the relevant paragraph, my lord. Of course. It's
10 candidates for each vacancy.
2008, volume 17, Supreme Court cases, page 703.
Yes.
Yes, my lord, the relevant paragraph is, my lord, this paragraph 7, subpara D, my lord. It lays down the timeline also. Yes. And if, my lord, kindly turns overleaf,
Paragraph 7.
7, my lord, 7D, my lord. If, my lord, kindly turns overleaf, my lord, page
Yes.
710, my lord will find, my lord, the ratio that I was referring to. My lord will find it against serial number 7. That is, the ratio of 1:10 of available vacancies to the successful candidates be maintained. But it's against placitum B, my lord.
Yes.
Now, my lord, this is the object, my lord. Now, my lord, what I say is, my lord, that the very object of maintaining the standards in the procedure initiated for selecting candidates to the West Bengal Judicial Service, now that is being completely, my lord, frustrated owing to severe non-application of mind, my lord, by, my lord, the Public Service Commission, respondent
Where
public service.
does it say that 1 mark will be awarded to
My lord will find it, my lord. Kindly takes page 64 of the key answer, my lord. 64 at the bottom, my lord will find it has been specified, my lord, against the asterisk, my lord. 1 mark will be awarded for the question to all the candidates, irrespective of attempt.
So this was part of the examination paper, or this was given later on?
No, these are the key answers, my lord. This
No,
came
no,
out.
I'm saying that this inserted after it was discovered that several of the key answers were wrong? Or was
My
it
lord,
part of the examination?
But there was first one key answer sheet, my lord, which was initially published, my lord, on the 27th of March.
No, I'm saying that did the authorities, did the Public Service Commission insert this to make amends that there were several wrong key answers, or was it part of the original
No.
examination paper?
Wrong key answers were not corrected, my lord. 27th of March, they came out with the first key answer sheet. Now, there were, my lord, mistakes in that. Those were pointed out by way of representation. Now, thereafter came, my lord, the second key answer sheet dated 18th of April, 2023. Now, in this second key answer sheet, my lord, now they have, my lord, embarked on this particular procedure. And, my lord, what has happened, my lord, in the process of correcting the wrongs pointed out, now, my lord, they have, my lord, also committed the blunder of, my lord, taking wrong answers as the correct ones. That is the first category, my lord, that on which my lord, just stressed on, my lord.
And have they done the negative marking or not?
My lord, negative marking is the rule, my lord. Persons who will be attempting the questions, my lord, if the questions are
No, because
answered,
that is inconsistent with giving 1 mark whether you attempt or not. That is why I'm asking you.
yes, my lord, for only these particular 6 questions. Those are only for, my lord, I have attempted 5 out of the 6 questions.
Yes.
Out of these 6 questions, my lord,
So you
for
got
which,
5 marks.
for which 1 will be awarded, they have said. I have attempted 5. Now, insofar as, my lord, this particular condition as the way it is.
Mr. Bhattacharya, this 1 mark will be awarded for the question to all the candidates, irrespective of attempt, would be restricted to the wrong key answers?
To the arbitrary key answers, my lord, that is question 53, 70, 73, 98, 150 and 181.
So 5 or 6?
6.
6.
My lord,
Very
I
well.
am before your lordship, my lord.
How is it contrary to Malik Mazhar?
My lord, the object is, my lord, this is nothing but a screening process. This is nothing but a screening process, my lord.
Yes.
My lord, persons appear in the preliminary examination. My lord, thereafter, my lord, my lord, the ratio has to be maintained, my lord. On the basis thereof, my lord, a cutoff has to be ascertained. That is the screening process. And thereafter, finally, my lord, the successful candidates will be appearing in the written examination, the final examination. Now, my lord, if this is done, my lord, as has been attempted to be done, my lord, now, my lord, that frustrates the very object, my lord, of Article 14 of the Constitution of India. The Constitution of India, my lord, Article 14 is basically an admonition addressed to the state authorities, my lord. And the state authorities are basically, by virtue of Article 14 and the principles analogous thereto, they are supposed to apply.
How is it discriminatory?
But this is discriminatory because of the fact, my lord, that irrespective of the, my lord, since, my lord, the concept is about negative marking, my lord, as I place, my lord, reliance on page 31. My lord, persons
Yes.
attempting and taking the risk, my lord, are being, my lord, placed on the same footing as the persons who have not taken the risk, my lord. But this will, my lord, to an extent, my lord,
Risk of what?
but a risk of attempting the questions. But there are, my lord, let us suppose, my lord, there are 10 questions. Now, out of 10, my lord, there are.
If you know the right answer, you know it. What do you, why will you take a risk?
My lord, if I do not know the right answer, I will
Yes.
not attempt. Because if I do not attempt, there will be no negative marking. But if I attempt, 1 mark will be deducted. If I get it wrong. Out of 10 questions, my lord, suppose I know 8 answers to the 10 questions, answers of 8 of them are known to me. So I attempt 8. 8 are answered correctly. I secure 8. Remaining 2, I do not attempt because I do not know. I get 8 out of 10. Now, if I take the risk and I attempt the remaining 2 and I give wrong answers, so I will not be getting 8. I will be getting 6 because 2 marks will be deducted for attempting.
So you're saying that instead of 6, they will get 10.
But instead of 6, suppose, my lord, persons who have not attempted, my lord.
Yes.
Let us suppose, my lord, these 6 questions.
Mr. Bhattacharya, let me ask you the questions so that I can clarify my own understanding.
Well.
There are 10 questions.
My lord.
The candidate who knows 8 will attempt 8 questions and get 8 out of 10.
My lord.
The candidate who knows 6 will get 6 out of 10. But if attempts 8, out of which 2 are wrong, will get 4.
4.
Will get 4 out of 10.
Yes.
All right. By this additional mark, you are trying to say, I need to understand this. You are trying to say that for a candidate who should have got 4 because of the 2 wrong answers, now will get 6.
Exactly so, my lord. Exactly so, my lord. Because, my lord.
Then how are you at a disadvantage? Because that candidate would have got 6, you would have got 8.
No, my lord. I may not have attempted, my lord, other questions. Please. But I may not have attempted, my lord, the questions which the other candidate has attempted. And that other candidate, my lord, may not have attempted the questions which I have attempted, my lord, being, my lord, 5 out of these 6 questions, my lord, where 1 mark grace has been, my lord, earmarked to be awarded to all and sundry. Now, my lord, I say, my lord, that this is, my lord, offending the very object which has been sought to be achieved.
What is the object?
But the object sought to be achieved is, my lord, maintenance of the, my lord, 1:10 ratio, and, my lord, a screening. Because, my lord, otherwise, my lord, the very process, the very procedure of a preliminary examination, my lord.
No, why will the 1:10 ratio not be maintained, Mr.
No, my lord, the
Bhattacharya?
screening will be impacted.
Because you're saying there will be more candidates.
Yes, the screening will be impacted, my lord. This is the procedure, my lord.
How will it be impacted? Be specific, please. How will the screening be impacted? There will be more number of candidates.
There will be more number of candidates, my lord. So
because of the more marks.
there will be more marks. Persons not even attempting will be getting the benefit of 1 mark, which will be given to the persons who have attempted.
But isn't the only the candidates who have got the most number of marks will be taken? The maximum number of marks will be
My
taken.
lord, the maximum number of marks, my lord, will not be a correct reflection of the merits in that event, my lord, because persons who have not attempted, my lord, they will also get, my lord, a 6 marks grace, my lord. Suppose, my lord, I have attempted 10 out of 8 questions.
Yes.
8 out of 10 questions. Suppose the other one, someone else has attempted 6 out of 10 questions.
So you're saying that the 6 grace marks will tip the balance and make it,
Yes.
may make it more than a candidate who has attempted the right answers.
My lord, because out of 10, my lord, if I attempt 8, including, my lord, these particular 6 questions, my lord, and the other 2, my lord, I give wrong answers. Now my marks will be deleted. Whereas, my lord, the other candidate who has not attempted these questions, but answered the others correctly, my lord, now they will get the benefit. This is just, my lord, a hypothetical situation, my lord, that I am trying to explain. So, my lord, the entire balance or the entire purpose, my lord, is getting frustrated. And this is, my lord, apparently an instance which is glaring of non-application of mind, my lord, which is manifest, my lord.
Mr. Bhattacharya, what is the stage of this judicial examination?
My lord, we are awaiting, my lord, the publication of the results, my lord. It can be
This is
published
the
at
West Bengal judicial examination?
West Bengal Judiciary, yes, my lord,
West Bengal judicial examination for 2022.
2022.
And this test was conducted at which stage? You're saying screening. What is
My lord,
screening?
26th of March, my lord, the preliminary examination was
This is
conducted.
a preliminary examination.
Preliminary, my lord.
After which, after this stage, what is the next stage?
My lord, the mains will happen, my lord, after, my lord, this earmarking and calculation of this 1:10 ratio.
Main examination. And after that, what is the stage?
Thereafter, the interview is there, my lord, where there will be a nominee, my lord, of the Honorable High Court also, my lord, one of the sitting honorable judges of the
Very
court.
well. After the interview?
And after the interview, my lord, the appointment process will be as per the merit list, my lord.
Very well. So Malik Mazhar comes at a much later stage.
No, Malik Mazhar lays down, my lord, how, my lord, the preliminary also has to be done, my lord.
Which you did not place. You placed 7.
No, I placed, my lord, I was indicating, my lord, no, the entire process, my lord, underwent a change, my lord, after Malik Mazhar's case.
Yes.
Because these were basically in the nature
But
of
where does
guidelines.
it say that you cannot do this, you can do this? Where does it say that?
No, my lord, regarding, my lord, the awarding of grace marks, my lord, no, there is no reflection insofar as Malik Mazhar is concerned,
Yes.
my lord. Malik Mazhar just
It's
laid down
only
the
with
process,
regard to the vacancy.
but it is only the timeline and the vacancies, my lord.
Yes.
Now that is what Malik Mazhar, the timelines has also been flouted, my lord. I will not be, my lord, relying much on that, my lord.
Yes.
Now, my lord, I made a representation, which is there at page 65.
Yes.
And I pointed out, my lord, the discrepancies. Because admittedly, wrong answers are earmarked as correct, and correct persons answering correctly, my lord.
This is the name of the petitioner at page 65.
Yes, my lord.
I thought it's a misspelling.
No,
Yes.
no.
Yes.
Even I asked my learned advocate on record a number of times. So he also said that, no, that is the name.
Very well. Yes.
And we all are anxiously waiting for rains, actually, in Bengal.
That's absolutely what I was intending to say, you know.
Yes.
Well, this representation was made, my lord. No, my lord, that has not also been taken into consideration. My lord, ideally, my lord, but the honorable court, my
It
lord,
was made when?
it was made on the 18th, my lord. Where is the date?
18th of which month, Mr.
18th of,
Bhattacharya?
I'm sorry, my lord, 18th of April, my lord, 2023, when the, my lord, key answers were published, my lord. The revised key answers were published. May I just place the representation?
No,
Very.
I've read it. Yes. So what is the prayer, Mr. Bhattacharya?
My lord, I will be, my lord, ideally praying for, my lord, intervention of the honorable court, my lord, for setting things right, my lord. I will not say that quash everything or.
What, setting things right? What? How?
My lord, the Public Service Commission, my lord, should be taken to task, my lord, and
How? I'm asking you.
my lord, the key answers should be corrected, my lord. And this particular decision, my lord, this has to be revisited, my lord, regarding, my lord, awarding of, my lord, marks to all and sundry, my lord, irrespective of, my lord, them not attempting it, my lord. So
And the results have been declared?
no, not yet, my lord.
Not yet.
Not yet, my lord.
When are they due to be declared?
My lord, it can be declared at any point of time. It can. Acha, yesterday in the evening, my lord, the schedule for the main examination has been published.
Yes. What is that? Show it to me, please.
Yes. গতকাল publish করেছে? আচ্ছা। Final examinations will be starting from the 4th of May
Where does it say that?
my lord, the second page, my lord.
Yes.
The program is there. So it commences from the 4th of May. And the process will get over on the 13th of May.
It doesn't say 13th. Where does
No,
it say?
13th is, my lord, the last date. My lord, the third page, my lord, will find the examination in compulsory and optional subjects will be held on and from 4th May 2023 to 13th May 2023 at examination halls of the Public Service Commission, West Bengal in Kolkata.
Mr. Bhattacharya, do this. You come back on Monday
My lord.
and you communicate this order on the Public Service Commission.
Yes, yes.
Because I need to hear them.
Yes, yes, they are
their-
very much essential.
Yes. Because I don't think Mr. Chatterjee will be able
No,
to
no,
say anything for the state. Yes, the petitioner before the court appeared for the West Bengal, what is it called? West Bengal or state?
No, this is the Public Service Commission. It was
West
the
Bengal Judicial-
Service Examination 2022.
West Bengal Judicial Services, within brackets preliminary, close brackets, examination 2022, which was held on 26/3/2023. Stop. The revised answer key, according to the petitioner, the revised answer key was released on 18/4/2023, on which date the petitioner also made a representation to the Public Service Commission for corrective action. Stop. The grievance of the petitioner is awarding of 6 grace marks despite for attempting 6 questions, irrespective of whether the candidate gives the correct answer against those 6 questions or not. Stop. Learned counsel appearing for the petitioner submits, next paragraph, Koro, that the awarding of 6 grace marks, regardless of the correctness of the answers, was inserted at the time of publication of the second key answers, which was on 18/4, is that correct?
My lord.
18/4/2023, by reason of 7 of the key answers being found to be incorrect. Stop. Is that correct, Mr. Bhattacharya?
My lord, only one small fact, my lord. 6 grace marks awarded to all irrespective of attempting or not attempting.
No, already been awarded.
That is the decision. That
Very well. Then why is it 7 on the left side of the chart?
No, 7 are, my lord, the wrong answers.
Very well.
And 6 are, my lord,
Yes,
on the
yes,
right hand side. My lord. Yes.
Yes. Next, council submits that since the preliminary examination is should preserve merit, the awarding of 6 grace marks to candidates who may not give the correct answers will tilt the balance against those candidates who have given the correct answers. Stop. Next. Since the Public Service Commission is the answering respondent and are not represented in court today, despite being served, lists this matter. Mr. Bhattacharya, when do you want to come back? Lists this matter on 24th July 2020, 24th April 2023. Stop. Council is requested to communicate this order on the Public Service Commission. Stop.
And my lord, in the meantime, my lord, let it be expected, my lord, they do not come up with the results, my lord, as that will create third-party rights.
That is, my lord, will kindly then consider the prayers for interim orders.
But let there be an interim order for
Let there be no interim order, my lord. If they have waited this long, my lord, let them wait for 18. They have filed the writ petition on 20th. They have waited at least 2 days. Look, before
Yesterday I was here before your lordship, and I prayed for leave.
My
to
lord
move
will
it yesterday
kindly
only.
take into consideration the
Yes,
balance of convenience. and
since the matter, since the PSC has not appeared today, and the court has kept the matter. No, Kerala, since the matter is being kept on 24th April 2023, only to hear the PSC, it is expected that the PSC will not take any steps till 24th April 2023 in respect of the concerned examination.
Grateful, Your Lordship.
We are grateful. my lord.
Grateful, Your Lordship.
Next.
Item number 7.
Item 7, my lord, yesterday, your lordship,
Understand, microphone,
my
please.
lord, yesterday, your lordship granted leave. And there is extreme urgency involved in the matter because the auction under challenge is scheduled today and to be fixed at 3 p.m. Now, my lord, the facts remains that an auction was called by M Junction, a third party, on behalf of Damodar Valley Corporation. The auction relates to sale of plants and machineries of Damodar Valley Corporation. The reserve price is 180 crore and EMD is rupees 12 crore. Now, this auction was published in February 2023 and the date firstly fixed was 23rd March. On 23rd March,
23rd March was fixed as what?
for bidding, online bidding of the auction.
Yes.
Now, my lord, by 15th, all documents are to be made over and within 19th, EMD amount of rupees 12 crore was to be paid. This was done by my client.
Don't say 15-19, which month?
My lord, 15th March of 2023.
Yes.
Now, my lord, on this date, 23rd March, the auction was deferred. It didn't take place and the date was deferred by M Junction and Damodar Valley Corporation, fixing 6th April 2023. Within 4th, they said, my lord, that we should deposit this EMD of 12 crore. This was also complied with by my client.
No, your client, why would he deposit EMD? Successful bidder?
My lord, successful compliant of terms and conditions, only those were directed to submit those security deposit.
Why would your client submit? Must have been the successful bidder.
Yes,
Otherwise,
yes, yes.
everyone can't be called
Successful
upon.
bidder. I'm sorry. Successful bidder.
Yes.
Now, on 6th April, before 6th April, they asked me to, within 4th, to deposit that amount. This was done. On 6th also, it was deferred. And it was fixed on, my lord, 21st.
Yes.
That is today at 3 p.m.
Yes.
On 17th at 8:30 p.m., my client got this communication, which is at page 157. Kindly have a turn to, my lord, 157, 58.
Yes.
By this communication, my lord, without assigning any reason, page 158 is the relevant page. We regret to inform you that as per instruction received from DVC, organization has not qualified in techno commercial evaluation of sale of decommissioned and machinery of Bokaro Thermal Plant B units total capacity of 60 MV due to non-compliance of the shortfall of QR document mentioned in e-catalog. This QR documents mentioned in
No, the auction you're saying is supposed to be held today.
today.
Then this is the 17th, who is for DVC?
My lord, yesterday your lordship directed me to serve a copy. We have through email communicated them.
Email is not good.
My lord, but
Email is not good. No. You should have given it through some other mode.
we have also
Email may or may not be seen.
within 1 day they will not get it, my lord, because yesterday the leave was obtained and the jurisdiction created is Kolkata. My client is of, my lord, Aurangabad, Bihar.
Aurangabad,
17th
Bihar. Then why are
the
you coming to
jurisdiction is created at Kolkata.
How?
Because Damodar Valley Corporation has registered office and page 40.
I can't understand. Microphone, please.
My lord, Damodar Valley Corporation.
I am putting it on Monday because I can't hear. You don't know how to use a microphone.
My lord, your lordship may kindly, my lord, registered office of Damodar Valley Corporation is at Kolkata. The tender notice itself indicates that
No,
all
but
dispute.
I don't understand. If the auction is to be held today, you're saying, then how can your bid be rejected? What is due to be held today?
My lord, online auction where the auction is to be handed over from 3 p.m. to 4 p.m.
Show me the schedule, please. Show me the schedule.
162. Page 162. কিভাবে সার্ভিস করেছো বলো? বলে দাও। Respondent is there? One Union of India. One respondent is appearing. I do not know, my lord, for whom. I am for the Union of India. Respondent number
No,
1.
please. 162.
162. That is date E-line online forward auction will commence on 21st at 3 p.m. Last date of pre-bid and my lord, it is fixed on. Page 161, it was deferred.
On 21st April.
21st April. Today,
21st April is today.
today, my lord,
And last date for submitting pre-bid security is 19th.
19th.
19th was on Wednesday.
Yes, my lord. On 17th, 8:30 p.m., this communication was made. One day he took to come at Kolkata and immediately be prepared and filed. Brought it to your lordship's notice yesterday, my lord. Your lordship have been kind enough to allow us to file it.
Yes, so what is the arbitrariness?
Now, my lord, this QR code, which they say has not been complied, there
Yes.
is no scope of saying at this stage. This QR code, which lays down financial capacity of 51 crore, has been submitted long ago. It is only those candidates who have successfully complied with the terms and conditions twice were brought to notice and the date were fixed for holding auction. Therefore, it does not allow new bidder to come in. Your lordship will find at page 162, no new bidder shall be allowed to participate. On both the earlier two occasions, that is on 23rd and 6th April, it is only the successful bidder who were complying with. Therefore, there is no question to travel and go ahead with that.
No, where does it provide that the techno-commercial evaluation will be done? Which date? Where will I get this? Because you have been rejected in the techno-commercial evaluation. Which schedule provides for this date, that when this is going to be done?
Page 165 is the document which will show that my clients complied with. And pursuant to this
Can't you
compliance,
understand the court's question?
I'm sorry.
Show me a schedule which will indicate when the techno-commercial evaluation is supposed to be done or was supposed to be done. Show me that document, please. It's not a question of whether your client
no.
complied with it, because I
For
will not
that,
get
my
into
lord,
that
your
question
lordship,
now.
For that, your lordship has to look to the first document, that is page 18, which was by this in February, it was fixed on 23rd March. This itself stipulates this.
Page?
Page 18, that is the tender document. This is of February 2023.
No, where does it say this is all in March?
Yes,
So this is the final schedule which was being maintained.
yes, this is the
Yes, show me the date.
page 18.
Show me the
Auction,
date.
my lord, your lordship may look to the criteria for participant. Please refer to qualification criteria and the document of it to be portal is 15/3/2023. This was the date of my lord submission of the document. The date fixed was 23rd. On that date, simply it was deferred and fixed to 6th April. Before, while it was deferred and fixed on 6th, they invited that within 4th, we have to deposit this EMD, which we complied with. Page number.
Can't you understand the court's question? You have been rejected in the evaluation. Show me the date on which the evaluation was supposed to be done. Show me that date.
Page number. Page number. Page 161. Below, your lordship may kindly turn to page 161. This is only 3 lines Only 3 line it refers to. Page 161, your lordship will find revised date of EMD submission is 4/4/2023. This EMD is, my lord, a subsequent act after it is done. It has not been mentioned in that way, but it shows that EMD is to be deposited on 4th. The date of auction says, my lord, 6. Therefore, before, my lord, the EMD is submitted on 4th, this has to cross, my lord. Only after this compliance,
So
one
you're saying
has
the,
to.
the evaluation was supposed to be done before 4th.
Before 4th. I'm grateful to your lordship, my lord.
So then why are you challenging the evaluation? On what basis?
I am not challenging the evaluation.
Then what is the interim order you want?
My lord, the interim order which I want, my lord, that twice after this was made and complied with, they have deferred it. On 17th, they eliminate it on the ground of QR. QR compliant has been made previously before 4th, when it was scheduled to be held on 6th. On 6th, because it did not take place, because it was the act of the respondent authority, they simply deferred from 6th to 21st.
So are you challenging the deferment?
Yes, my lord, because now there is no scope on their part on 4th when we have complied with all, and it was deferred by them because it was to take place on 6th itself.
Show me the service, please, on
Service to
DVC.
my lord, I have email diye diyecho na. We have also, my lord, communicated through email because one day.
Show me the service.
And to Union of India by hand, my lord.
Yes. The Damodar Valley Corporation, comma, who is the answering respondent, which is the answering respondent, comma, was served with a mail yesterday, i.e. 20th April 2023, that the matter informing DVC, recording that the matter has been mentioned before this court and is due to be taken, that the matter was mentioned before this court on 20/4/2023 and has been fixed for hearing today, i.e. 21/4/2023. Stop. Next, no one, however, appears for the DVC. Stop. The Union of India is represented. Stop. Next. After hearing learned counsel appearing for the petitioner, comma, it appears that the date of the auction floated by DVC was deferred from February to March and then to April. Stop. A schedule placed by council shows that the e-auction online forward auction, page 162, will commence from 3 p.m. today. Stop. The petitioner is aggrieved by communication dated 17/4/2023 by way of a mail stating that the petitioner is disqualified in the techno-commercial evaluation, page 158. Due to non-compliance and shortfall of QR capitals documents mentioned in the e-catalog. Stop. Next, list this matter on 24th April 2023. Stop. The petitioner shall communicate this order on DVC. Stop. having found that the petitioner has made an arguable case, at least prima facie, comma, the respondent DVC is permitted to proceed with the e-auction, but shall not take any adverse decision against the petitioner until the matter is heard out on 24th April 2023. Stop.
May I submit, my lord, that without prejudice, may I be allowed subject to final order to be passed by this honorable court?
No, I can't say that. Yes, next. Shop,
The petitioner will be at liberty to communicate it, because through email we will be communicating without.
I have given that liberty. Didn't you
I'm
hear the order?
grateful to lords.
But by mail is not effective. That is why I'm telling you.
Grateful to lords.
Item number 8.
Item number 8, my lord, I appear on behalf of the petitioner, my lord.
Yes.
Lordship might recall, my lord, this matter relates to a dispute for rejecting my monetary claim
Yes.
by West Bengal Handicraft Development Corporation, in short known as
Yes,
Monjusha.
yes, I remember.
And my lord, the last order Lordship has passed before I address, my lord, on 11th of April 2023. One thing has gone down wrongly. I think this is my mistake, because Lordship has dictated the order in open court. I should have pointed out. My lord, kindly come to that order of my lord, my lord.
Yes.
Internal page 2, my lord. Lordship has recorded, according to the counsel appearing for the petitioners, that the petitioner should get the entire amount of 3.97 lakhs for the time supplied to the hospital at Nandikram. The petitioners appeared to have admitted to short supplies as well as delay. My lord, there was no admission on account of short supply. Only thing, my lord, what we have said, there was delay. And the document will demonstrate that, my lord.
Very well. Yes.
Now, my lord,
May I have?
Lordship, they have
File my
filed their
affidavit
affidavit,
also.
my lord. Only thing what remains, my lord, may I file my reply, is whether I am entitled to interest or not. And the other thing, my lord, what they have done, my lord, during the pendency of the writ petition, they have cancelled all contracts. That they cannot do unilaterally, arbitrariness and high-handedness apparent on the face of it. But possibly that I cannot challenge in this proceeding, because I have not made that claim. So I would be seeking my lord's liberty, my lord, to initiate appropriate proceeding against that. But for interest, I think I am entitled to that. This is the only thing what Lordship has.
Interest on
3.97. Yes, my lord, one thing Lordship has recorded, that they have deducted 10%. Straightway, my claim is 3.97. If the 10% is deducted, it can't be 47,000. It has to be, my lord, 39,000 and all. So I'm entitled to more. Now, my lord, let us see, my lord, what case they have made out. I submitted before your lordship that on instruction that my client, my lord, that they have received the money from the state of Nandikram. Lordship has said, my lord, that they would file an affidavit, and obviously the authority is the state who has paid the money. They will indicate the fact whether payment has been made or not.
You are appearing for the state?
He is appearing for Monjusha, my lord. Now, my lord, state had chosen not to file any affidavit. Now, kindly, my lord, come to the affidavit of Monjusha once.
Yes.
They have not. I'm sorry, my lord.
Yes.
My lord, they have not indicated the payment which they have received. What they have said, that they have taken a board resolution of deducting 10% penalty, and that is why from the total billing amount, they have deducted 10%, which is actually not 10%, I think 13%. Now, kindly come to, my lord, one averment of their affidavit in opposition, my lord. Page 7, my lord. My case is that if you have received money, then you have to pay. Because there's only delay, and subsequently reorder was placed and I supplied the goods. Kindly come to page 7 once, my lord. Line about 10 or 12 from the bottom, sentence starts with since. Lordship has got it, my lord. Work order was indicated, then the word since.
Yes.
My lord, since those orders were cancelled for non-supply by the petitioner, the payment in respect thereof were withheld to decide the issue of imposition of penalty by the board of directors of answering respondent. In view of the board of directors having decided on imposition a penalty of 10%, the balance amount after deducting penalty, goods and service tax, tax deductible at source has been paid by the answering. So what they refer to the board resolution, they don't disclose how much they have received it. Now kindly come to the board resolution. This is their board resolution. My case is slightly different and I have made out a case in my writ petition on oath.
Move the
I'm
mic.
sorry,
Yes.
that you have received the entire money. So the payment sheet or the bank details would have cleared the entire position and the state affidavit. Kindly come to the last annexure, page 21, page 20. They refer to the board resolution only. They may take it, my lord.
Yes.
But the question is slightly different. Page 20, last annexure. Kindly come to first, second, third paragraph.
Yes.
The said Joyram Enterprise failed to execute the supply within the stipulated period. So there was delay, and I admit that there was delay. Several telephonic conversations had been made, they had been referred to. Then they say it was stated, next paragraph, it was stated that the failure of Joyram from executing the supply have negatively affected the goodwill and reputation of Monjusha. And they record certain facts, my lord. Thus, the management needs to decide to levy a penalty on Joyram Enterprise in this board meeting, which will be deducted from its due amount. This is because the payment of its dues have been upheld. The board, after discussion, passed the following resolution: that a penalty of 10% on the supply value shall be levied on the vendor suppliers who fails to supply products within the stipulated time for the smooth functioning of the business of Monjusha, and the vendors shall not be allowed to work with Monjusha for a period of 1 year. Though they say 1 year, but kindly come to, my lord, the document which they have sent to me, page 11. They have cancelled it for all times to come, my lord. Page 11. Which I will be challenging, of course, my lord. A state wing, my lord, a state authority cannot do that, but not in this petition, my lord. Page 11.
Yes.
That is 5th April 2003. Kindly see the vindictiveness on their part, my lord. After I claim this, with reference to purchase order dated so-and-so, issued by our corporation in favor of you with instruction to supply hospital items, DH Nondigram, within 20th October 2022, but you failed to supply the same within the stipulated time. Ultimately, the orders were cancelled by the DRS Nondigram, which has negatively affected the goodwill and reputation of our corporation. A show cause letter has been issued. Then, my lord, they say, last sentence, thus the management had decided not to continue with any further order as you do not have a locus standi. I'm an empaneled, my lord, supplier, my lord, to complete this supply within the stipulated time. And this date is 5th April and the board resolution is 25th March. They quote the board resolution and record certain facts, and that has been quoted exactly from the board resolution. This is the only stand, my lord, they have taken. Now, my lord, kindly, my lord, come to once, my lord. I will not show you anything from my reply. I'm a small scale industry, my lord, a proprietor, my lord. Kindly come to, my lord, page 13 once. This is the objection which they have raised of my writ petition, my lord. Page 13.
Of your writ petition? Yes.
They have, my lord, stated to my client, your organization has been entrusted with the job for supplying hospital items, so-and-so, DRS Nondigram. Then, my lord, the important thing is the purchase order, lordship would find. They say, but those products were not supplied by your firm within the delivery date, and all these orders were cancelled by the authority. What they don't say, that subsequently, in respect of the purchase orders, I have supplied, and I will show. Now, my lord, in the next page.
No, so they say that the orders were cancelled.
Cancelled.
So then if the orders were cancelled, then what did you supply?
I supplied because next page, kindly come to 9th January. Reorder was placed, and in respect of the same purchase order, I had supplied. And that is why, my lord, they have made payment. Payment itself indicates the fact that the supply has been made. They're not paying it from their own pocket. Obviously, they have got it. That's why they paid 3,50,000. 9 January. This is my letter, which Lordship has quoted in my Lord's order, my Lord. I accepted, my Lord, truly. I, Shondipon Nath, the proprietor of so-and-so, hereby comply with the show cause letter. That's the show cause letter. There is a various causes for non-supply of 3 items. I indicated the materials. The most relevant cause was the Durga Puja ceremony. So I did not able to collect the product from the market and also from other sources. Also, I tried to make the product from factory, but due to short time and also for vacation, I can't do. I really apologize, sir, for the unavoidable situation. But sir, I talked to DRS Nandigram authority about the situation because I always look after my company's reputation, which I represented. DRS Nandigram understood the problem. And they assure me to order those items, and I made the reorder from DRS on the aforesaid items. That is important. There was no allegation of short supply, only delayed supply. Next page, page 15. Is the order, purchase order, my lord. Now, my lord, tax invoice, page 15, page 16. Now, my lord, kindly come to page 17.
Page 15, 16 is what? Evidence
Page
that
15
you
and 16, my lord, is
purchase order
orders.
after the reorder.
my lord,
Because page 14
Yes.
talks about a reorder.
yes, date is important. 4th January is the complaint, 9 January, then the reorder on 13 January.
Yes.
And the purchase order, Lordship has noted, my lord, at page 13,
Yes.
purchase order number 231211B4 HDM. And this order, my lord, supply has been made, my lord. I have handed over a bunch of documents, my lord, on the last day. Probably Lordship has, my lord.
Yes.
Just the three challans, my lord, which would depict the fact, my lord, actually, my lord, the supply has been made.
Yes. Where do I get the date from? 8/2/2023.
8/2/23. I'm grateful to your Lordship. The mattress cover, coir mattress, and the slipper BI color.
So you're saying that these challans were after the reorder?
Yes, certainly, my lord. Otherwise, my lord, why would they make payment? My claim is 3,99,000. Monjucha has not paid it from their own pocket. Only dispute right now, apart from the dispute that you cannot cancel unilaterally, is whether I'm entitled to the total amount or not.
So what is the balance you're looking at, Mr.
My lord, 3,97,000 plus 350, which admittedly they have paid, proving the fact that supply has been made. They refer to the imposition on penalty on the ground of delayed supply and loss of reputation.
No, what is the balance?
Balance is about, my lord, 47,000.
47,000.
47,000. This is what I, my lord, claim. Now, my lord, state could have come and say actual amount has been paid or not. They have chosen not to do anything.
Yes.
And my lord, I am a small businessman.
Yes.
If otherwise they have received it, they should pay. And they have not disclosed any document.
Yes. What is the evidence that they have received it?
There is no evidence. I can't, whether they have received. Apart from, my lord, the assertion which I have made in the writ petition that you have received nothing. They should have come forward, my lord Monjusha, saying this is the payment received. Kindly see, I have received this much and I have not received the entire money. They have not chose to do that. What they did, my lord, on the contrary, they refer to their board resolution.
Yes.
Board resolution will not say anything. You may take a resolution.
Yes.
That could have been sorted out the entire issue.
Yes.
State could have come and pointed out, why should I suffer when I've actually supplied? And second thing, my lord, the tax invoices, though the dates are not matching, my lord, page 17 onwards, this all refers to the same purchase order. Page 17 onwards. Though the dates are not the same, but the same purchase order. 2312, page 17, page 18, page 19, page 20. Dates are before that, I must say. But the other documents which I handed over to you, my lord, would show that the supply has been made. And there is no dispute about short supply, only the delayed thing. And the rest, my lord, regarding cancellation, kindly grant me liberty, my lord, I would challenge that. You can't do it. Can't do it in this writ petition because again, I have to file an amendment application. I don't want to do it. And their vindictiveness. I'm an impaneled supplier. You accept my supply. The moment I file a writ petition for not paying me, first you took the point, you can't agitate this issue because it's a monetary claim. On the next day, after knowing what the law is, you say all your work orders, whatever has been given to you will be cancelled unilaterally. A state authority.
Very well. So the arbitrariness of the cancellation of work orders that you will.
Give me liberty, I will. Of course, certainly
Yeah.
I will. And my lord, regarding one more thing, my lord, regarding the supply which has been made pursuant to the work orders, they should make payment only after receiving the money.
And that amounts to about 47,000.
No. 47,000, my lord, the 3,97,000 which they have received. And
Yes.
they gave me payment. This apart, there are certain work orders which I have executed
Yes.
prior to this cancellation. Payment is in the process. I say when you get the money, you pay me. That has to be done. Just because of the cancellation,
So what is 47,000?
47,000 is the deduction on account of imposition of penalty, which
That's
they say.
a 10%.
Yes. And the purchase order does not say anything about 10%. It says there will be penalty. On certain.
And what does the purchase order or doesn't the purchase orders don't give a quantum?
No, absolutely. Kindly come to this once. I was about to indicate you. Page 15. Nothing. Page 15. After the order, Miller, last few lines. The supply be made strictly according to the specification, measurement, quality, and finish as per the approved
Yes,
samples.
on deviation and non-delivery.
Correct. Absolutely. Your allegation is delay. Nothing to say, my lord. I have nothing to say. And you don't make out a case that I have not supplied you. Otherwise, you could have deferred or withheld. You say delay.
Yes.
This is what I have to submit.
But two things, my lord. At the threshold of this, when the hearing of this writ
Microphone,
petition was commenced,
Yes.
at the threshold, I had taken a point of maintainability. I have not given it up. On the last occasion, I had just brought to your lordship's notice certain subsequent events which had happened. Now, my lord, first, let us look at what is the scope of the challenge in the writ petition. What is the scope of the writ petition? As it stands today, the scope of the writ petition is that he has made supplies under purchase orders issued by Monjusha to him.
Yes.
And as against that, a sum of rupees 3,97,000 is due and payable by Monjusha, which has been withheld. The withholding, according to him, was arbitrary, and that is the subject matter of challenge before your lordship. Now, during the pendency of the writ petition, there are two things that have happened. One, the authority which had withheld the money has decided that as a result of non-supply, and I say this, my learned friend is very cleverly tried to merge non-supply under one order with supply under another purchase order and say that, oh, I have supplied this, so there is only delayed supply, there is no non-supply. And I'll show you that as a result of his non-supply of those three items, my purchase orders for those three items were cancelled by the DRS Nondigram. My learned friend has read out portions of documents by reading a part of a sentence and omitting the second part because it goes against him.
Yes.
So the first question is, my lord, A, whether his writ petition at the threshold for payment of money in a arising out of a non-statutory contract, where, my lord, there is a dispute as to whether he has supplied or not and whether his non-supply has resulted in loss to me, can be decided in an application under Article 226. Secondly, my lord, today the situation is that he is aware that a penalty has been imposed upon him.
Yes.
The order imposing the penalty has not been challenged.
Yes.
So the communication of 5th April 2023 is not under challenge. Thirdly, my lord, so far as the other imposition by the board resolution of 25th of March, that he will not be allowed to have any orders from Monjusha for a period of 1 year, that also is still today not under challenge. That, of course, my learned friend says he reserves his right to challenge it otherwise. Now, I'll deal with the facts first, and then I'll take your lordship to the judgments on request of maintainability. Kindly, I'll take my affidavit.
But I'm sorry, my lord, I thought maintainability point has been sorted out after they made payment. They have given it up. Because
No.
lordship knows the judgments, my lord, I don't have to say anything.
Yes,
ABL and the last Justice Joseph.
yes.
My lord,
You have
kindly
made
take-
payment when? Pursuant to the court's orders?
No, your lordship, there was no order for me to make payment.
After
I
filing
have
the
made
petition.
Yes.
I have made payment on 6th of April. Now, my
Yes.
lord, this is a this is a corporation, my lord. It has a board of directors. The rate of penalty has to be decided by the board of directors. The payment was withheld because the board of directors met on 25th of March. There was no other reason
6th
to
April,
withhold.
how much do you pay?
We have paid, my lord, a sum of rupees 3,50,559. That your lordship will find at page 12 of my affidavit.
Yes.
Now, my lord, the balance amount represents the 10% penalty tax which I have deducted at source, as I am mandatorily required to do under the Income Tax Act, and GST. Because if I deduct a penalty, there's a GST that is leviable.
Yes. Page
Now, my lord,
12, you said?
Page 12. This is the payment order.
Very well. Yes.
And my lord, page 13, he accepts that this money has been received. That's his email.
Yes.
Now, kindly, my lord, take page 14.
Yes.
This is, my lord, a purchase order dated 29 September 2022,
Yes.
which has been issued by me to my learned friend's client.
Yes.
Kindly, my lord, have a look at item numbers 8, 9, and 10.
Yes.
Now, my lord, kindly see below item number 8, below item number 9, and below item number 10, order number 2, such and such. This is the order issued by DRS Nondigram to me. The date is 28th of September 2022.
Yes.
Now, my lord, kindly take page 15, 16, and 17 are the 3 purchase orders for the items at 8, 9, and 10 of the purchase order that I have correspondingly issued to him.
Yes.
Now, my lord, kindly come to page 18.
Yes.
My lord, this is
Yes.
the cancelled order. This is the cancellation on the portal. There is no cancellation order. On the portal, it will show that the order has been cancelled.
Yes.
Now, my lord, kindly see below cancel order, there's a portion which is dark.
Yes.
In the third column, my lord, your lordship will see 2022-2023-5539/OR/CC/93. Your lordship will find this, and the next page, there are 2 more, are the 3 purchase orders issued to me by DRS Nondigram, against which I have issued him a corresponding purchase order.
Yes.
So, my lord, admitted position is that he failed to supply within 45 days. And the purchase order, so far as these 3 goods are concerned, were cancelled by my principal. Now, my learned friend tried to mix this up with the document at page 15 of his writ petition. This has been annexed, my lord. The items have been, I think this is a result of highlighting. But anyways, just below that, kindly see, these are items which have been supplied under a purchase order that I have issued to him, and the corresponding purchase order of DRS Nondigram is 5539 OR/CC 118 dated 6th January 2023. So the supply made by my learned friend's client, which he tries to pass off as supply under the earlier purchase order, is a supply under a completely different purchase order.
Yes.
I have shown unimpeachable document. Therefore, the facts which are before your lordship are, there was a purchase order. He did not supply within 45 days. My principal cancelled the purchase order. Now, my lord, kindly once again, come back to the document at page 14 of my affidavit in opposition.
Yes.
The supply be made strictly according to at the bottom, my lord.
Yes.
To the specification, measurement, quality, and finish as per approved samples. In case of any deduction from the payment of this corporation by the CMOH Nondigram due to deviation of whatever nature of quality, size, specification, etc., or non-delivery of articles. So, my lord, obviously CMOH Nondigram has not paid me for items which the orders they have cancelled.
So you're saying that you did not receive any payment for the cancelled
For
orders?
those cancelled orders, I did not receive any payment. Therefore, I became entitled to levy a penalty. Now, if he is aggrieved by the order imposing the penalty, he has to challenge it.
Yes.
That order is still not under challenge. Lastly, my lord, I just meet the point. My learned friend had cited ABL, and your lordship had asked me to look at the judgment of Justice Joseph. My lord, I will rely on both of them and, my lord, on Joshi construction. ABL says money claim under a writ petition can be made provided it is a consequential claim. A claim consequent upon an action of an authority, either recovering a payment or imposing a payment, being set aside. All the judgments, my lord, which go into that, yes, money claim is possible, there is a clear distinction made out, which is also noticed in Joshi construction, that if it is, what is the nature of the claim? Is it a claim merely for refund? Or is it a claim for setting aside an action of the government, imposing a tax or recovering a tax or withholding a payment illegally, and thereafter refund as a consequence of that? So Joshi construction makes a complete distinction between both of them, and Joshi construction has been taken note of in Justice Joseph's judgment, and in paragraph 83, I think, of 2023 judgment, again, my lord, it says that so far as claims arising out of breach of contract, those should not be gone into ordinarily by the High Court. Here, my lord, what is his claim? His claim is there is a contract, I have supplied, he has not paid. So non-payment of price for goods supplied is at best, my lord, a breach of a contract. I have now shown your lordship also that a penalty has been imposed. The criteria which enables me to impose a penalty has been fulfilled, because for non-delivery by him, my order has been cancelled. The question therefore is whether in such a situation, a further claim for deciding this question of whether I validly impose the penalty without the penalty being made subject matter of challenge in the writ petition can be taken up, one. Secondly, my learned friend has today talked about interest, my lord. There is no prayer in his writ petition for interest. Again, interest, my lord, would come only if he is able to show that there was non-payment and the non-payment was wrongful. My lord, may I start, my lord, first with
Not the interest point I give up.
ABL.
And I have not cited any judgment. Lordship has referred to. I have not cited any judgment.
No, on the very first day, my learned
So I
friend
just
cited ABL.
Interest point I give up. I'm not taking any.
Did you give a photocopy of ABL?
ABL, yes, I have.
Yes, দাও।
না, আমি cite
শুনতে
করিনি কি
পাচ্ছ তো?
করে?
ABL বলছি, শুনতে পাচ্ছ না?
Lordship has
Yes.
ABL is there, 2019 volume 16 SCC is there. It says contractual obligations.
Very well. Mr.
And also Justice Joseph,
Yes, Mr.
paragraph
Dev,
8.
you will have your chance.
I'm
Yes.
sorry.
My lord, your lordship will kindly take.
Paragraph 19 was cited.
Yes, ma'am. Paragraph 19 was cited.
Yes.
Says, therefore, it is clear from the above enunciation of law that merely because
Which paragraph are you saying?
paragraph 19 I'm placing first, and then
Yes.
I'll take your lordship.
Yes.
ABL. I'm placing paragraph 19 first, and thereafter I'll take your lordship to one other paragraph. Consubstantial laws of paragraph number. Therefore, it is clear from the above enunciation of the law that merely because one of the parties to the litigation raises a dispute in regard to the facts of the case, the court entertaining such petition under Article 226 of the Constitution is not always bound to relegate the parties to a suit. In the above case of Gunwant Kaur, this court even went to the extent of holding that in a writ petition, if the facts require, even oral evidence can be taken. This clearly shows that in an appropriate case, the writ court has the jurisdiction to entertain a writ petition involving disputed questions of fact, and there is no absolute bar for entertaining a writ petition, even if the same arises out of a contractual obligation and or involves some disputed questions of fact. Your lordship will thereafter see other judgments have been considered, and the law has been summed up in paragraph 27. from the above discussion of ours,
Yes.
the following legal principles emerge as to the maintainability of a writ petition. A, in appropriate case, a writ petition as against a state or an instrumentality of a state arising out of a contractual obligation is maintainable. Merely because some disputed questions of fact arise for consideration, same cannot be a ground to refuse and entertain a writ petition in all cases as a matter of rule. C, a writ petition involving a consequential relief of monetary claim is also maintainable. Might kindly mark the word consequential, because this has next been considered in Joshi Technologies, which is reported in 2015 volume 7 Supreme Court cases, page 728. Might kindly take paragraph Joshi, it is Joshi. No, no, Joshi. Wait. Lordship will kindly take paragraph 69.
Yes.
Paragraph 69. The position thus summarized in the aforesaid principles has to be understood in the it should be at page 766.
Yes.
The position thus summarized in the aforesaid principles has to be understood in the context of discussion that preceded, which we have pointed out above. As per this, no doubt there is no absolute bar to the maintainability of the writ petition even in contractual matters, or where there are disputed questions of fact, or even when monetary claim is raised. At the same time, discretion lies with the High Court, which under certain circumstances it can refuse to exercise. It also follows that under the following circumstances, normally the court would not exercise such a discretion. The court may not examine the issue unless the action has some public law character attached to it. Whenever a particular mode of settlement of dispute is provided in the contract, the High Court would refuse to exercise its discretion under Article 226 of the Constitution and relegate the party to the said mode of settlement, particularly when settlement of disputes is to be resorted to through the means of arbitration. If there are very serious disputed questions of fact which are of complex nature and require oral evidence for their determination, money claims per se, particularly arising out of contractual obligations, are normally not to be entertained except in exceptional circumstances. Further, the legal position which emerges from various judgments of this court dealing with different situations or aspects relating to contracts entered into by the state or public authority with private parties can be summarized as under. At the stage of entering into a contract, the state acts purely in its executive capacity and is bound by the obligations of fairness. State in its executive capacity, even in the contractual field, is under obligation to act fairly and cannot practice some discriminations. Even in cases where question is of choice or consideration of competing claims before entering into the field of contract, facts have to be investigated and found before the question of a violation of Article 14 of the Constitution could arise. If those facts are disputed and require assessment of evidence, the correctness of which can only be tested satisfactorily by taking detailed evidence involving examination and cross-examination of witnesses, the case could not be conveniently or satisfactorily decided in proceedings under Article 226 of the Constitution. In such cases, the court can direct the aggrieved party to resort to alternative remedy of civil suit. Writ jurisdiction of the High Court under Article 226 of the Constitution was not intended to facilitate avoidance of obligation voluntarily incurred. Writ petition was not maintainable to avoid contractual obligation, occurrence of commercial difficulty, inconvenience, or hardship in performance of the conditions agreed to in the contract can provide no justification in not complying with the terms of the contract which the parties had accepted with open eyes. It cannot ever be that a licensee can work out the license if he finds it profitable to do so, and he can challenge the conditions under which he agreed to take the license if he finds it commercially inexpedient to conduct his business. Ordinarily, where a breach of contract is complained of, the party complaining of such breach is may sue for specific performance of the contract if contract is capable of being specifically performed. Otherwise, the party may sue for damages. Writ can be issued where there is executive action unsupported by law, or even in respect of a corporation, there is denial of equality before law or equal protection of law, or if it can be shown that action of the public authorities was without giving any hearing and violation of principles of natural justice.
These are not relevant for you.
For
What,
me.
what are relevant, I've marked.
Yes. Now, my lord, kindly also see paragraph 70.11.
Yes.
Scope of judicial review in respect of disputes falling within the domain of contractual obligations may be more limited, and in doubtful cases, parties may be relegated to adjudication of their rights by resort to remedies provided for adjudication of purely contractual disputes.
Yes.
Now, my lord, this is taken note of by Justice Joseph's judgment. Justice Joseph's judgment, 2023. My lord, your lordship will see this entire passage has been quoted in paragraph 77.
এমপি পাওয়ার আছে কি তোমার কাছে? এমপি পাওয়ার আগে দেওয়া হয়েছে তোমাকে? এটা দিয়ে দিচ্ছি। দিয়েছি? Yes.
Paragraph 77, my lord, Joshi construction is quoted.
Page.
My lord, page 759. Now, kindly, my lord, come to paragraph 78 at page 761.
Yes.
In state of Kerala versus MK Jose, reported in 2015 9 SCC 433, the specific question with which we are concerned with, namely entertaining a writ petition in a contractual matter, and where the specific question was the validity of the termination of the contract, fell for consideration. We may notice the following. A writ court should ordinarily not entertain a writ petition if there is a breach of contract involving disputed questions of fact. The present case clearly indicates that the factual disputes are involved. Next paragraph, page 79. Thereafter, in the court in MK Jose went on to consider in detail the judgment of this court in ABL and found that it was a case where the court granted relief as the facts were absolutely clear from the documentary evidence, and it pertained to interpretation of such clauses of the contract of insurance. Then, my lord, paragraph 20 is quoted, which I may kindly be allowed to place. We have referred to the aforesaid authorities to highlight under what circumstances in respect of contractual claim or challenge to violation of contract can be entertained by a writ court. It depends upon the facts of each case. The issue that had arisen in ABL International was that an instrumentality of a state was placing a different construction on the clauses of the contract of insurance, and the insured was interpreting the contract differently. The court thought it apt merely because something is disputed by the insurer, it should not enter into the realm of disputed questions of fact. In fact, there was no disputed question of fact, but it required interpretation of the terms of contract of insurance. Similarly, if materials that come on record from which it is clearly evincible, the writ court may exercise the power of judicial review, but a pregnant one in the case at hand, the High Court has appointed a commission to collect the evidence and accepted the same without calling for objections from the respondent and quashed the order of termination of the contract. Now, my lord, kindly thereafter come to paragraph 82 at page 763.
Yes.
We may call out our conclusions in regard to the points that we have framed. Now, my lord, we
Only place the relevant ones, please.
yes, my lord. Kindly see paragraphs 82.1. It is undoubtedly true that the writ jurisdiction is a public law remedy, a matter which lies entirely within a private realm of affairs of public body may not lend itself for being dealt with under the writ jurisdiction of the court. 82.3, my lord, the mere fact that relief is sought under a contract which is not statutory will not entitle the respondent state in a case by itself to ward off scrutiny of its action or inaction under the contract if the complaining party is able to establish that the action or inaction is per se arbitrary. Now, 82.5. The contract, after the contract is entered into, there can be a variety of circumstances which may provide a cause of action to a party to the contract with the state to seek relief by writ petition. 82.6 million. Without intending to be exhaustive, it may include the relief of seeking payment of amounts due to the aggrieved party from the state. The state can indeed be called upon to honor its obligations of making payment unless it be that there is a serious and genuine dispute raised relating to the liability of the state to make the payment. Such dispute ordinarily would include the contention that the aggrieved party has not fulfilled its obligations, and the court finds that such a contention by the state is not a mere ruse or a pretense. I am specifically referring to this, Millard, because I have showed that I am entitled to deduct the penalty because he has failed to make the supply, which has resulted in my contract getting cancelled, my purchase order getting cancelled. That fact I have demonstrated by documents in the public domain. The vendor portal of the government shows that. Now, Millard, arbitration I do not want to show.
Mr. Bose, another 2-3 minutes, please conclude.
Yes.
Yes.
Those are, Millard, the paragraph 82 is the relevant paragraph, and those are, Millard, the ones that should be relevant to our case. So, Millard, the facts before your lordship are that it's a claim for money.
Yes.
Admittedly, I have made payment, which is a subsequent event, but I have deducted penalty. I was entitled to deduct penalty under the purchase order in the case of non-supply. Non-supply is admitted under the original purchase order, and that is also evident from the fact that my purchase order for the corresponding purchase order that I received from the DRS Nandigram was cancelled. Question of whether 10% is a valid penalty or the rate at which penalty has been imposed is just or fair is not under challenge in this writ petition. Neither is the question of my imposing a ban on him for participating in receiving work orders for a period of 1 year under challenge in this writ petition. As of today, Millard, nothing survives in this writ petition, even though the writ petition was originally not maintainable.
Very well. Mr. Deb, you come back next week, please. All right.
Very well.
And give a composite reply dealing with these 2-3 cases, whatever. So we can conclude the matter.
Lord, I can do it in 5 minutes. I leave it to your lordship. Just in 5 minutes. If lordship.
Not today. Come
Very
back
well.
next week.
May I come back on Monday, my lord?
Yes, you can. Learned counsel appearing for the petitioner as well as the respondent, answering respondent, have made their submissions on the including on the reply filed by the respondent, capital R, reply capital R. Stop. Counsel for the respondent has also placed decisions to revert to the point of maintainability raised in the first stage of hearing. Stop. List this matter on 24th April 2023 as prayed for.
I'm grateful to your lordship.
Item number 9.
My lord, I appear for the petitioner, my lord. Lordship was hearing that
Happening
challenge
on
to the,
behalf
my
of
lord,
the
change
state.
in management policy, my lord. Mr. Shobhushaji Chaudhary is leading me. He's unwell, could not come to court today. May I only pray lordship takes it up on Tuesday, my lord?
Yes, adjournment is prayed for on behalf of counsel. Now, learned counsel appearing for the petitioners prays for an adjournment. Stop. List this matter on 25th April 2023 as prayed for.
I'm grateful.
Item number 10.
Your Lordship, I appear for the petitioner, Your Lordship. On the,
Lord, I am for the respondents.
Your Lordship, we have prepared a note, Your Lordship. They had taken a point that there's an appeal which lies under section 9. And Your Lordship, our contention was that there's no appeal. As far as section 5A is concerned, there's no appeal provision as far as the act is concerned.
Yes.
So along with the judgment, Your Lordship, may I just?
Yes.
Your Lordship, for that purpose, Your Lordship, regarding section.
I can't
9,
hear you.
I'm sorry. Regarding section 9, Your Lordship will kindly, Your Lordship, take the judgment, Your Lordship, which is at page 47, Your Lordship. This is the full bench.
These are new judgments.
This judgment, Your Lordship, we had referred to, but the copy we had not given on the last occasion.
Page 47.
Page 47.
Where have you referred to this judgment in the note?
Your Lordship, this has been referred to at page 5, Your Lordship. The contention of the respondent, Your Lordship, and the reply, Your Lordship.
Yes, Yogesh Agarwal.
Yes, Your Lordship. Now, this is the full bench judgment, Your Lordship, of the Allahabad. Here, the division bench had held that an appeal is maintainable.
So you're relying on this judgment?
Yes, we are relying.
Yes.
Here, the division bench of Allahabad had held that an appeal is maintainable as far as section 5A is concerned under section 9.
Yes.
Now, they held that it is not. If Your Lordship kindly takes page 55, paragraph 18.
What is the you want to rely on the SCC online citation?
Yes, Your Lordship.
Yes.
2016 SCC online.
Yes.
Now, if Your Lordship kindly takes page 55, paragraph 18.
And the point was that 5A is not appellable.
Appellable and the writ is maintainable. If Your Lordship will see at paragraph 18, this decisions would indicate that the judgment of the division bench of this court in Sanjay Agarwal has proceeded on an erroneous principle. Parliament provided in section 9 an appeal against an order which has been passed under section 5 or section 5B or section 5C or section 7. Plainly, no appeal has been provided against an order of the estate officer which has been made under section 5A. The division bench in Sanjay Agarwal held that an appeal against an order under section 5A would be maintainable under section 9, and in holding this founded its rationale on the ground that otherwise a party against whom an order has been passed under section 5A would be remediless. This line of reasoning is contrary to the well-settled principle of laid down by the Supreme Court. This court, in the exercise of its jurisdiction under Article 226, cannot create the remedy of an appeal. The power and jurisdiction to legislate for an appeal lies in the legislature. Where the legislature has provided for an appeal against orders passed under certain specific provisions, but not against other orders, it would not be open to the court by a process of interpretation to expand the ambit of the appellate remedy. This exercise is impermissible. Moreover, even though an appeal has not been provided against an order under section 5A, the legality of such an order is subject to judicial review under Article 226 of the Constitution. And Your Lordship, paragraph 19, the submission which has been urged on behalf of the petitioners, however, is that there is no practical distinction between the provisions of section 5A and section 5B, and hence there could be no logical reason to restrict the remedy of an appeal under section 9 to the latter, but not to the former. On a close reading of the provisions of section 5A and section 5B, we do not find substance in the submission. Subsection 1 of section 5A contains certain specific prohibitions. These prohibitions are erecting or placing or raising any building or any movable or immovable structure or fixture, displaying or spreading any goods, and bringing or keeping any cattle or other animal on or against or in front of any public premises, except in accordance with the authority under which a person was allowed to occupy the premises. Where the provisions of subsection 1 are breached, subsection 2 empowers the estate officer to issue a notice for removal, and where the cause shown is not sufficient, the estate officer is empowered to remove or cause to be removed the building, structure, or fixture from the public premises. Similarly, if a movable structure or fixture has been erected, placed or raised, or goods have been displayed or spread, or an animal has been brought or kept on any public premises in breach of subsection 1, the estate officer is empowered to remove it or cause it to be removed. Section 5A and section 5B operate in clearly distinct areas. Subsection 1 of section 5B applies to a situation. So it goes on saying, Your Lordship, what section 5B says, and ultimately, Your Lordship, it is held. We accordingly answer the reference by holding paragraph 20. An order passed under section 5A of the public premises is not applicable under section 9 of the Act. And the decision of Sanjay Agarwal does not lay down the correct proposition of law. So, Your Lordship, the paragraph 18 clearly says, Your Lordship, the legality of the order is subject to judicial review under Article 226. So the contention of my learned friend that there is an alternate remedy and we have not availed of that alternate remedy is not correct, as section 9, under section 9, the order under section 5A is not applicable. I erect a judgment to show that the decision, the person who has to pass. Your Lordship, I'm led by Mr. Banerjee, Your Lordship, kindly pause.
Yes. No, did you take only a point of maintainability or anything else?
And also section 147, Your Lordship, of the Railways Act.
Yes.
Yes, yes.
No,
146 or
Your
something.
Lordship, as far as section 147, if Your Lordship will kindly see.
Yes, yes, Mr. Banerjee.
147, I know
It
how.
has to be read.
No, just 1 minute.
Yes, sir.
Mr. Nayak, did you take only a point of maintainability and the 147 or something else or anything else?
My lord, my humble submission before your lordship was that
Microphone, please.
relating to section 4 and section 5A. Then, my lord, subsequently it was not maintainable because of the section 9 that was my submission.
But
Before your lordship.
Supreme Court
Now, my lord,
gives,
that
that it is not available.
Beg your,
5A and 9 that has dealt with, this judgment has dealt with.
my lord,
Very well, you say what you were saying. Yes.
my lord, my humble submission before your lordship is this, that the notices under section 4 and 5A was, my lord, issued in accordance with law by the estate officer.
Very well.
Number
So
one.
you're saying that they should have gone up in appeal
They
and
should
not
have
come
gone
to
up-
the writ court. That is what
they
you
should
said.
have gone up in appeal against the order passed by the estate officer. As per this Act of 1971 is the complete code. My lord, that code gives power under section 9 to prefer an appeal before the learned district
Very
judge.
well. What was the other point you raised?
So other point was, my lord, under section 47 of the Indian Railways Act. There is also a provision, my lord, to evict the unauthorized occupants by taking the police force. My lord,
Very
in
well.
this
Yes.
case, my lord, it
Now I
was not
remember.
done.
I remember. Anything else? Anything else? Any other point?
My lord, the third point will be before your lordship is that this entire, my lord, petition is on the basis of facts.
Yes.
And my lord, my humble submission before your lordship is that the mayor, on the question of facts, there it doesn't lie before your dishonorable court.
Very well. You're saying disputed question of facts.
Yes. it
Yes,
is a
yes, yes,
disputed
Mr.
question
Banerjee.
of facts.
Yes.
Lord, 2 points, Malad, that's what we had understood. Malad, 2 points taken. One, Malad, is section 9 appeal, which is clearly covered, Malad, by this full bench judgment, Malad, of the Allahabad High Court.
Yes.
And Malad, the section 9 itself doesn't, Malad, refer to Malad 5A. Malad looks at the act itself, Malad, it doesn't refer to 5A, and that's how, Malad, the Chief Justice, Malad, has, Malad, distinguished, saying that no, you can't give a right of appeal when it is not provided by the statute.
Yes.
Malad looks at section 9. An appeal shall lie from every order of the estate officer made in respect of any public premises under, and says section 5, 5B or 5C or section 7.
Yes.
To an appellate officer who shall be the district judge or district in which the public is situated, or other judicial officer and such. Malad, in the Allahabad High Court, Malad, a division bench had said that appeal. Sorry, Malad. Kindly look at Malad section 9.
Of the 1971, no.
Yes, yes.
1970,
Yes, Malad.
1971 Act.
The Public
Yes.
Premises Eviction
Yes.
of Unauthorized Occupants Act 1970.
Yes.
So appeal, Malad, is not a remedy at all provided under section 9. And Malad, the full bench, Malad, also now makes it clear that you can't also give a right of appeal. So only writ petition, Malad, is the remedy, Malad, to challenge, Malad, anything.
Very
Now,
well.
Malad, here one of the main issues, Malad, will recall, Malad, the notice which, Malad, they give is, Malad, under section 4.1, that the 7th April 2022 notice.
Yes.
7th April, Malad, is section 4.1 notice. And then, Malad, they proceed and passes an order under section 5A. Both are completely different. One, Malad, is eviction of, Malad, unauthorized occupant under section 4 and section 5. And the other one, Malad, is unauthorized construction.
Yes, I remember that point.
So,
Yes.
Malad, there is no connection between these two. And Malad, 147 also, my learned friend has relied upon Railways Act. I don't know why, with the greatest respect to him. Because this, Malad, again, Malad,
What, I don't have that act. What
I'm
does it
just
say?
give a Malad.
It's a Railways Act.
Yes, Railways Act.
Yes,
It is
yes.
again, Malad, completely different. Achha. Kindly see, Malad, this talks about, Malad, a railway land, Malad, being, Malad, trespassed. and the railway servant has to deal with it. Here, my lord, 5A order, my lord, is not under, nothing to do with 147. Let's see, 147 trespass and refusal to desist from trespass. If any person enters upon or into any part of a railway without lawful authority, having lawfully entered upon or into such part, misuses such property, refuses to leave, he shall be punishable with imprisonment for term which may extend to 6 months, or with fine which may extend to 1,000 rupees, or with both, provided in absence of special and adequate reasons to the contrary to mention judgment of this court, so none less than fine. Any person referred to in subsections and such may be removed from the railway by any railway servant or by any other person whom such railway servant may call to his aid.
Yes.
My lord, this has nothing to do with, my lord, 5, my lord, A, my lord, the order which we are impugned here. And my lord, I have shown, my lord, documents where, my lord, my title, I am owner of the land, my lord, it came, my lord, from my grandfather. This property was purchased, my lord, the deed of conveyance, my lord, is also annexed. But I don't want to, my lord, also go into it because they will have to, my lord, show all this for the purpose of, my lord, securing an order against me.
Very good.
And my lord,
Yes.
another very important point, my lord, because, my lord, I've given a judgment of that also. My lord, the notice was issued by someone, hearing was by someone else, and my lord, the order has been passed, my lord, by someone else.
What are all these judgments, Mr.
My lord,
Banerjee?
there are two judgments only, my lord. One is, my lord, that page 6, my lord, will find.
And please give the citations to Mr. Nayak because I have to give him a chance
We have
to
given the judgments also. my lord.
react to these
We have given the
judgments.
judgments.
Yes.
My lord, 2011, two Supreme Court cases, 258, my lord, is only, my lord, on the proposition that, my lord, page 44, my lord, will find, my lord, where, my lord, one person hears and another, my lord, decides can't be. My lord, I've given the relevant paragraphs, my lord, 83 and 84. That's, my lord, a little longish. That's why, my lord, it's become the only two judgments.
Paragraph?
My lord, paragraph 83 and 84 at, my lord, page 44.
Yes.
And which is, my lord, an accepted principle, my lord, of, my lord. It's, my lord, mentioned, my lord, in my notes, my lord, page 4, paragraph 11, my lord, may have mentioned it.
Accepted principle, but happens all the time.
So, sorry, my lord.
Saying it's accepted, but happens all the time.
Yes, my lord, that is correct. One can't, my lord, give a note, someone else hears it, my lord, and
Yes.
but, my lord, I think here, my lord, the main and which, my lord, we have submitted. I don't want to understand. Sorry, my lord.
That is all the demeanor of the witnesses, etc. 83 and 84, you said.
83 and 84, my lord.
Yes, yes.
Even a personal hearing enables also then one person last portion, my lord, pass it out, marginal note E, my lord.
Yes.
Moreover, it was also observed if one person hears, the other decides, then personal hearing becomes an empty format. But that is, my lord, the last of my point. My first point, my lord, is that, my lord, it's a property belonging to me. There's no question of, my lord, anything, my lord, being unauthorized.
Yes.
It's not a public premises, my lord, where the act will apply at all. And that's the first premise, my lord, we came with. It's a jurisdictional issue, my lord, on the question, my lord, that, my lord, whether they have decided. And, my lord, we had given replies to, my lord, both their, my lord, the first notice of 7th April, on 28th April, that's page 58. And, my lord, also, my lord, saying that, my lord, property belongs to us. And where is the proof that this property is public premises? They did not come up, my lord, with anything. On the contrary, my lord, they went ahead. And, my lord, now they said it's unauthorized construction under 5A. And no notice under 5A, which, my lord, we have already, my lord, submitted.
Yes, Mr. Nayak, you come back next week and just for these two cases, and I will make it. I will pass orders.
Any day, your
It's
lordship.
not a very complicated matter, so just take 2 minutes, please.
Yes, I will do it. Any date, your
You
lordship.
tell me when,
Monday.
according to your convenience.
No, it's your lordship's desire.
Very well.
Well,
I'm giving you. You want to come back on 17th, 18th. Sorry, 24th, 25th.
Yes.
Learned counsel appearing for the petitioners has placed two decisions and a note stop, list this matter on 25th April 2023 for a learned counsel appearing for the railways to respond to these two decisions. 25th is fine with you?
Grateful.
Yes.
এটা তো কোন স্যার ইয়ে এটা আমার
Call on the next matter, please.
grateful.
Railways Act ফেরত দিয়ে দাও।
Item number 11.
I am for the petitioner. My learned.
I would like to appear on behalf of the private respondent number 9, my lords.
I appear for respondent numbers 1 to 8.
My lord, 9 is directed to file, my lord, the
Microphone,
affidavit.
please.
My lord, I have been directed to file the affidavit. I have already, my lord, this served the copy of the, my lord, the affidavit.
Were you directed to pay costs?
No, my lord,
Oh.
lordship, last occasion, lordship, no. No direction for pay.
My in the
Private respondent, my lord, is a
in
Very
the
well, yes.
in the affidavit, my lord, they have annexed some in the affidavit, they have annexed number of documents starting from 1992. May I get an opportunity to
Started
deal?
from?
1992. May I get an opportunity to deal with the same by filing reply?
This is an opposition or supplementary affidavit? What have you filed?
Affidavit.
Affidavit in
Yes.
opposition?
So not.
Naturally, you have a right to file a reply.
Objection for affidavit in opposition, my lord, lordship.
Yes, yes. How much time do you want?
10 days time may be given.
My lord, only one issue, my lord. My lord, this matter is being, my lord, kept, my lord, this matter, my lord, relates to, my lord,
This is
partnership.
that two brothers and one sister.
My lord, absolutely, my lord. My lord, the matter could be resolved, my lord, if all the parties approach the oil company, sit and come to amicable settlement. This is a private, this is a commercial contract, my lord, where, my lord, both the parties should agree, my lord. My lord, that's my respect, and this
The
ad hoc arrangement is-
sisters share from 99% to 1%.
no, 52, I think, 52.
52.
1%.
Yes, Mr. Shahara, what
I
is
have
the
no
problem?
difficulties. If the matter is settled, I have no.
I don't want to deal with all these in affidavits. I have to pass a judgment. I don't have the time. Yes.
I have no difficulties. I
Just
can
go
go.
to the oil company and settle the matter.
Kindly adjourn this matter for some time, and in the meantime, we
What's
shall.
sometime? It's you're the one who's come to court.
I am always ready. I have given numbers of notice to my sister. Come and sit and
Because if
settle the issue.
if you reduce her share from 99% to 1%, she will
That is-
naturally be aggrieved.
Kindly consider, my lord.
Yes.
That after marriage, by taking money, he is not disputing. My learned friend is never disputing that this is not a deed. We have not signed. This is forged. The case is that after all of a sudden 20 years, I will not sign.
Because she has suddenly woken up to the fact that she now has 1%
She
share.
has
That's why.
realized it for after 20 years.
Perhaps because
After death of my wife, my husband, my lord, the problem has been created. But because of
That
that,
does not mean, my lord, this is our fault.
that now entire share, nothing has been paid till my lord, since my lord, 1992.
Let my
So I
learned
am
friend.
not claiming. for
Mr.
any-
Shahara, I am telling you, frankly, because I don't want to be unfair, I am against you.
Understood.
I am against
Ask question.
I am against at what you have done. Two brothers, one sister, 99% to 1%. Absolutely, I'm going
But
to.
kindly consider.
So you better go to the oil company and
I'm going.
sort
I
it out.
shall definitely go. Whatever fallen from my lordship, I shall bound by the same. But
Because
at the same
if I
time,
give a judgment, it will go against you. I'm
I
telling
can't,
you.
I know, my lord. But on the same time, my lord, kindly consider, after taking entire money only for sentiment purpose, 1%. That's the original issue, my lord. Now after 22,
Taking money for what?
for giving entire share,
Very well.
my lord,
Mr.
how can this be a matter of
Apart from that, Mr. Shahara, it's completely a private dispute.
absolutely?
Two brothers and one sister.
I am
In any case, even if I want to give a judgment, I have reservations about whether I can.
better, your lordship, kindly adjourn this matter for some
Better for
time.
you, but you better go to the oil company.
My lord,
I am always ready, my
What
lord.
should
I
we fix?
wrote at least 10 letters to my sister. Come and settle the issue. Kindly see, I have annexed all
Very
those
well.
documents.
Yes, how much time do you want?
Lordship will fix a time period within which the territory manager will give hearing to all concerned and let them come to a settlement, or they will take action in accordance with law, my lord.
No, that
This is
cannot be.
pending since
I have a
my
case.
lord.
I have a medical.
My lord, an interim order was passed during Puja vacation. It went on
That's
extending.
issue.
Please,
It went on
You
extending.
can't understand where the court's sympathy lies.
In a favor.
Yes.
So, my lord, it would be better, my lord, this ad hoc arrangement is running since June, my lord. Lordship, let them go to the territory manager. Lordship will fix a time frame within which he will take a decision, my lord, pertaining to this so that it can be resolved, my lord, or whatever is the consequence will follow, my lord.
Yes. What is a good time? 2 weeks, 3 weeks,
My lord, 4 weeks, my lord.
4 weeks?
4 weeks.
Although learned counsel appearing for the petitioners seeks to file a rejoinder to the affidavit filed on behalf of the private respondent, comma, this court is of the view that the matter is essentially a dispute between three individuals and can be sorted out by the oil company. Stop. The view is bolstered by BOL-STERD, bolstered by, also bolstered by the submission made on behalf of the oil company. Stop. Should I dispose it off or what? Keep it pending.
Keep it pending.
My lord,
I told you, keep it
that
pending.
will again give a fresh cause of action, my lord.
List this matter on, give me a date, hurry up. How much time?
4 weeks is time after vacation, otherwise, my lord.
After vacation?
Because
Why you can't sort it out before the vacation?
No, my
he's
lord,
saying 4 weeks time is
my
required.
lord, today we are on.
No. I'm keeping it on 17th May. You
As well,
better sort it out before that.
As your lordship.
Yes, list this matter on 17th May 2023.
In the meantime, respondent number 8, territory manager will take a.
Stop, as suggested
Briefing note.
by learned counsel opinion for the oil company, comma, the respondent number 8 being the
Territory manager, LPG.
territory manager within brackets LPG, close brackets Kolkata, comma, BPCL, is directed to look into the disputes raised in the present writ petition.
My lord.
Stop.
Lordship, the parties should cooperate and, my lord, appear before.
Yes,
my lord.
Direction.
needless to say, comma, the petitioners and the private respondent shall comply with the direction passed by this court and cooperate with the respondent number 8.
Interim order may be extended in the meantime.
I don't think I want to extend the interim.
Otherwise, my lord, business will be closed.
My
Business
lord, I
will-
don't think something will happen.
What? They will close my business. They have already given the notice. I know, my lord, your lordship's views.
You take your sister into the business.
I am always ready.
Let her
I can
participate.
show at least 10 letters from my, I have annexed my petition. No response, no.
Both of you, the brothers, you're not allowing her to enter the
No, this is
company.
not
Why?
an issue. We are always ready and willing.
That is
We are always ready and willing.
I am not allowed to enter my.
Yes, the interim order is extended till 19th May 2023, till 18th May 2023.
I'm getting,
Next.
I'm getting.
Item number 12.
My lord, this is the, I have given my bullet points.
Well, I'm pleading for the petitioner, my lord. We are submitting our detailed notes.
My lord, may I get? My lord, my lord, I have given more or less submissions on the last
This
occasion.
is Mr. Chakraborty was appearing.
Yes, my lord.
My lord, I have made my submissions
Yes.
over there. And only one thing about the blacklisting, my lord, I gave 3 years. Minimum was 1 year, for which there was show cause, everything. Now, my lord, it is true that why 3 years and not 2.5 years or 2 years? Minimum is 1 year.
It sets the minimum mark, but not
Yes,
the maximum.
Not the maximum. I have made it 3 years. I have given some reason why in the show cause that he should be banned because he was removing goods. That's neither here nor there. But if your lordship wants to know why not 2 years, why 1 year? 1 year I have justified. My lord, whatever it is in the new e-auction, I don't want him to participate because he is in breach. And 1 year, my lord, serves if he says why 1 year and why not 2 years, why not, my lord, the order, my lord, does not spell out that. It's true.
What is tippers in your note? Tippers.
Tippers, my lord, these the trucks. Tippers, trucks. And my lord, he said, I had not referred in the show cause notice regarding 33 and 39 breach. My lord, I showed from the termination notice, it refers to the show cause where all these things, I need not, it's not in my note, but that's, he made this argument.
Very well. Yes. Learned
My
counsel.
lord, we have not filed affidavit, my lord, in case your lordship, the judge, you, because writ petition, my lord, the after modification of that order, your lordship can give directives.
Modification of which order?
It is, I am more aggrieved because
The order which was passed ex parte.
No, undertaking, my lord, my learned friend, just before
Undertaking, yes.
yeah, it was
The
till,
vacation bench order.
till 9th January, he meant,
Yes,
and
yes,
it
I
was
remember.
like,
Yes.
that is why.
Yes, learned counsel appearing for the petitioner. Hands up a short note. Stop. List this matter on first May 2023 under the heading for judgment.
ছুটি না হ্যাঁ ছুটি নেই ও আজকাল হয় না আজকে ছুটি
Call on the next matter, please.
Item number 13.
Item number 13, my lord, I am appearing on behalf of the petitioners. Item number 13 to 19, all are analogous matters. Where the petitioner seeks certified copy of the deed from the concerned additional district sub-register, where the additional district sub-register apprehended that forged stamp paper may have been used for the purpose of registration.
Yes, show me similar orders, please,
Yes.
passed by the court. Are you appearing for the state?
Item number 16, I am appearing for the state, my lord.
Show me the affidavit of service, please.
My lord, in item number 13, Mr. Devashish is appearing for the state. He is on leg in code number.
Yes, you appear, please. Yes,
I'm not in the state panel, my lord.
very well. Yes, show me the affidavit of service, please. And you can give his name.
My lord, I prepared a list of documents where I indicated the representative of the state appearing for the state representative.
Show me an order, similar order, please.
Well,
What is the investigation going on?
Investigation is going on against the stamp vendors and the persons connected with them. We are not the party in the proceedings of criminal proceedings. And because of these criminal proceedings going on, the original deed has been kept by the investigation agency.
Yes, you can make your submissions for the state in any of the matters. Yes, microphone, please.
I'm led by Mr. Khalid.
No, I will pass the order, please. You can give his name. Yes. Make your submissions, please.
My lord, one deed has been registered. One deed has been registered, my lord. According to them, the deed has been falsely registered, my lord, and they want.
Mr. Sen, are you appearing for any of the state respondents? Please come and make your submissions. Action করে দাও।
My lord, this type of in 18, my lord, I appear lordship.
From
this,
which to which?
From item number 13 to 19.
Very well.
Now, my lord,
Yes.
often these types of matters, my lord, comes, my lord.
Why don't you just look at the copy of one of the orders handed up? দেখো।
My lord, one order, my lord, my lord, a copy of the order passed on 17 June 2022 by my lord is also with me.
Yes.
Sorry. Oh, এটা please একটা দেখলেই হবে, please. My lord. Similar, my lord, matter, similar facts and circumstances. So
You can give the names of Mr. Galib or whoever else is appearing. হ্যাঁ শোনো এই এটা দিয়েছে ডিড নাম্বার টাম্বার গুলো পেয়ে যাবে এই অর্ডার হবে হ্যাঁ হ্যাঁ দিয়ে দাও। যারা যারা টাইম চাইছে yes disposed of you can give the names of Mr.
Item number 20.
Quickly abolishment.
I am for the period.
affidavit of service
It was heavy. I was given him on last occasion.
yes what is the interim order you want Mr.
I tell you,
Because today I can't pass any ex parte interim orders. That's why I'm asking you.
my application is there. Now they have passed an order since the High Court.
I don't understand who you're referring to.
Hello?
I don't understand who you're referring to. If you say they,
My lord, the district forest officer.
so say that.
The application is pending before the district forest officer. District forest officer passed an order since the one matter is pending before the honorable division bench. Therefore, until the Bhattir comes, we cannot proceed this application. But on the apparently on the face of the record, the honorable division passed this order. So the Bhattir has been given by the honorable court. Therefore, there is no question to not to proceed this
Who
application.
is the answering respondent?
The district forest officer.
Where is the impugned order?
Impugned order, my lord. Page 62.
Yes, where does it say that?
Now, kindly see the last paragraph. Until the last but 3 4 above, until the receipt of the final verdict issued by the Honorable High Court, the application could not be processed. Hence, as per rule sub rule 2 of rule 4, this application is hereby rejected by this undersigned. On next page, this order was passed on 21st September 2022. Now, the next page, the verdict has already been given by this Honorable Court on 20th September 2022. Therefore, passing this order, the Honorable Court passed this order.
May not have been communicated to them.
This was communicated. When I filed the writ petition to dispose of my application.
No, who appeared for the district forest officer at page 63?
When the district forest officer, the Subodip Lahiri appeared.
Can't you understand, Mr. Dotto? At page 63 was the DFO represented. At page 63.
63, yes. Yes.
Very well. Learned counsel is not ready.
63.
Stop. List this matter. On
Only one.
yes, tell me a date. No, I can't ask you so many questions. Yes.
Only.
No. Come back.
No,
Be ready and come back. When? No.
63 order was passed.
Yes. List this matter. You're not even able to understand the questions of the court. Yes. Learned counsel is expected to get ready on the returnable date, which shall be, yes. Tell me a date, please.
On Monday.
On 24th April 2023. Call on the next matter, please.
Item number 21.
At every point, Mr. Dotto, I have to repeat my questions. You will just not follow the court's questions.
Well,
Next.
I
No.
want to make this submission.
No. You can't even understand. I'm asking you
Who is appeal for the district magistrate?
Yes, call on the next.
That's
matter.
why I am.
Item number 21.
I want to make that submission.
No. You waste a lot of time. Next.
My lord, I am for the petitioner in this matter. My lord, in this matter, the petitioner has been running from pillar to post to get the possession of his property rightfully purchased by him by way of an auction purchase. The auction purchase had taken place in January 2019.
What is
11th
the,
of-
it's a 2020 writ petition. What is the interim order you want?
My lord, interim order, I have sought for refund of the entire amount paid by me to the bank. My lord, the bank has not been.
Which prayer?
My lord, it is at prayer A, my lord, number 1.
20 lakhs.
20 lakhs 4,640, my lord.
Yes. Do they know that this matter is returnable today?
My lord, the matter is being listed. It's running in the list. Its
Very
service
well.
was complete.
Since no one appears and we can't pass any ex parte orders, tell me when you want to come back.
My lord, on Wednesday, if my lord kindly allows me a liberty to file a fresh notice upon them.
Yes.
So that
no one appears for the Oriental Bank of Commerce. Stop. Next, list this matter on 26th April 2023 as prayed for. Stop. Learned counsel appearing for the petitioner is given liberty to communicate this order on the answering respondent.
deeply obliged him.
Next.
নামটা দেবেন। Item number 22.
For the petitioner.
Move the microphone, please. Move the microphone, please. Yes.
Now, my lord, the father of the petitioner, my lord, maintained a my lord savings bank account with the State Bank of India. Now, my lord, father of the petitioner expired. Now, my lord, after the death of the father, now, my lord, the petitioner had applied for succession certificate for withdrawal of the amount lying in the bank. Now, my lord, if your lordship would kind enough to come to the succession certificate at page 22, annexure P4.
Yes.
Now, kindly see, my lord, who is the petitioner? Riajuddin Molla, alias Riajuddin Molla, who is the petitioner. Riajuddin Molla is the petitioner before your
Page
lordship.
22.
Yes, my lord, annexure P4, page 22.
Yes.
Now, my lord, Riajuddin Molla is the petitioner in the, my lord, succession certificate case, and Riajuddin Molla is the petitioner before your lordship also. Now, my lord, kindly see, my lord, page 23.
Yes.
Petitioner is entitled to get 3/4 share out of the above total amount that was declared. Lordship would kind enough to come to page 24.
Who is declaring this?
Petitioner Riajuddin, district
No,
delegate.
who is declaring this?
District delegate at Al.
Yes.
Now, my lord, kindly comes to page 24.
Yes.
This is, my lord, the ultimate form, my lord, at the column left hand side at the bottom. Succession certificate is issued in respect of half share of the assets left by the deceased in favor of petitioner, namely Muhammad Riajuddin Molla alias Riajuddin Molla of rupees 2,16,197 and 1/4 share of each of the assets left by the deceased be issued in favor of Rashida Bibi. Only those are the sisters of rupees 1,08,000 out of the total amount of 4,33.97 after returning 1/4 share of another daughter, namely Rehana Bibi, according to Muslim Faraznama, Mohammedan law.
No,
Muslim
who is Rehana Bibi?
My lord, my two sisters, the daughters.
So
they are made parties. We have served.
So you have you will get 1/4.
3/4.
3/4.
3/4.
Why 3/4?
Now, my lord, 3/4 is because Rashida, the respondent number 6,
to giving your share to the petitioner. So that makes it half. Why 3/4 then?
Yes.
And 1/4.
Why?
No, the half, my lord, Riajuddin is getting half. According to Muslim Faraznama, Riajuddin is getting half, and 1/4 of Rashida, that is 3/4.
Yes, so if you are three siblings, why will it not be 1/3 each?
No, my lord, Muslim Faraznama, Muslim law, my lord, the calculations are different from my lord Hindu Succession Act.
Very well, you're the other sister. Who are you?
Bank.
I'm appearing for the bank.
I can't hear you. Microphone, please.
I'm appearing for the bank, madam.
Bank. Where is the other sister who has not given her no objection?
We have my lord tried to serve my lord these my lord affidavit of service track report says item bag. It has been served my lord long back.
I will not pass any orders in the absence of the other sister.
No, my lord, I'm not claiming their share. Only my share, which has been taken in the.
I will have to see that you are entitled to 2/4 of the share, or half of the share.
Well, very well. Whatever Millard has been
Very well,
declared by the district delegate, I will take that only. Whatever may, whatever is.
Not in the absence of the other sister who has not given her objection. No objection. Yes. When did you serve her last?
Millard, after the lordship's order dated 6th of July 2022, we have immediately served, but it says Millard item
Very
back.
well. The last order passed by this court was on 6/7/2022. Stop. The petitioner, as one of the three surviving children of the deceased father, claims three-fourth share of the total amount lying in the State Bank of India. Stop. The petitioner claims that one of the two sisters of the petitioner has given a no objection to the effect that the sister's amount should also be given to the petitioner. Stop. This is included in the three-fourth share. Claimed. Stop. The other sister is not represented before the court. Stop. The last service appears to have been the last service on the other sister, namely respondent number
5.
Respondent number 5 appears to have been made. Respondent number 5 within brackets added respondent. You are Rashida Bibi. Appears to have been made in July 2022. Stop. Next, list this matter. This court is not inclined to pass any orders in the absence of the added respondent number 5. Stop. List this matter. Tell me when.
Kindly gives me a fortnight's time, Millard. I'll serve in the meantime.
List this matter after a fortnight as prayed for. Fresh service may be effected on the added respondent number 5. In the meantime. Call on the next matter, please.
Item number 23.
My lord, I'm for the petition. I'm paying for a short Passover. Kindly, if you can take it up at 2 p.m. My senior will be there.
I am for the state.
Who are you being led by?
Soni Ojha.
Yes, at 2.
Item number 23.
Lordship, I appeal for the petition. This is my affidavit of service. The respondents are served again, Your Lordship.
Yes.
I am aggrieved by non-disposal of my section 14 application pending before the learned district magistrate Howrah since November 2018, Your Lordship.
2018.
Lordship.
Then why did you wait for?
Your Lordship, generally it takes 1 year. Before 1 year, no section 14 application is disposed of. This is the usual practice of the district magistrates. And thereafter COVID commenced and I filed this writ petition in 21, Your Lordship. Since then, it could not be taken up.
What is the time frame under the proviso, second proviso to 14.9?
60 days, Your Lordship.
14.9 is section 60 days.
Yes.
देखिए আমাকে একটা দাও তো একটু
60 days and it can be extended till 30.
বাঁধা অবস্থায় দেবে নাকি বইটা মানে এটা
30 days plus 30 days total. Total period is, Your Lordship. Total period is, Your Lordship, 60 days.
Yes, where is the prayer?
Your Lordship, at page number 9, Your Lordship, of the writ petition. 9 and 10 is my prayer, are my prayers.
Yes, what do you have to say?
My lord, the meeting has been fixed for on 20th April 2023 and the documents which has been, my lord,
20th? 20th was yesterday.
No, 28th April.
28th.
Lordship, kindly have a look to the my lord, memo dated 18th April 2023. Prior to this, my lord, another meeting was fixed on 19th April. That was adjournment was sought for on behalf of the bank because they could not arrange those documents in a short period of time, my lord.
Very well. This is the writ petition has been filed by the secured creditor / respondent bank. For a direction under section 14 of the SARFAESI Act 2002, for a direction on the district magistrate to dispose of the application, stop. According to learned counsel appearing for the petitioner, the application is pending since 2018. Stop. Next, learned counsel appearing for the district magistrate submits that a meeting was scheduled on 20th April. When was the last one?
28th April was the last one.
20th April 2023, which however could not proceed since the petitioner bank.
My lord, on 19th April, it could not be proceeded.
19th April, which could not be proceeded with since the petitioner sought for an adjournment. Stop. The next meeting is fixed on 28th April 2023.
Lordship.
Stop. Next, WPA 13483/2021 is accordingly disposed of with a direction on the district magistrate which Howrah to dispose of the application within the time fixed under section 14 under the provisos to section 14 within brackets 1 within brackets choto 9. Stop. Stop.
Grateful, my lord.
Item number 24.
I appear for the petitioner.
This is my affidavit in reply. Lordship had heard this.
Microphone, please.
Lordship, the petitioner is a finance company who had extended a loan to one of the private respondent. The vehicle was sold and the respondent number one insurance company was the insurer. The vehicle was stolen. Lordship, after stealing, my lord, after the vehicle got stolen, the private respondent, Lordship, Lordship, filed a complaint before the consumer forum. Before the consumer forum, Lordship, the insurance company, they came and said there was a document which was shown from where it appeared that the insurance company has agreed with the settlement and they have agreed to settle the claim for 7.8 lakhs odd. Lordship, on the basis of that submission, Lordship, the consumer forum, the complaint was dismissed, although it should have been disposed of, because the insurance company had settled with the claim. A check was prepared, which was handed over after the dismissal. But since the forum recorded that since it has already been settled, you settle in between yourselves. Lordship, thereafter, Lordship, the check has never seen the light of the day. Lordship, we had been chasing the insurance company because the finance company is supposed to get that check. Lordship, that is why we filed this writ petition. There is a clear admission with respect to our claim that they have settled it. Lordship, they had used an affidavit saying that
They, as in the Newity Assurance Company,
the insurance company, they have used an
settle
affidavit.
the claim of the private respondent.
The claim of the finance company is the writ petitioner with respect to a loan extended to the private respondent. But since we have extended the loan, Lordship, the insurance money is entirely receivable by us. That is why the claim is made by the the finance company.
Very well.
One of the insurance company, they had used an affidavit saying that on good gesture.
So this is
they
coming
had
up after affidavits.
after affidavits has come up. Lordship has heard this, but the insurance company is not appearing today.
Must be last year sometime, because I don't remember having heard this matter recently.
It was in the last year. Thereafter, we mentioned it and it has come up.
Yes. Mr. Ali, you can proceed, but then it's better that you make your arguments in the front, in the presence of your the other side.
The insurance
Who
company.
was appearing for them?
Last order, sir.
You did not appear on the last day.
It was my lord, Mr. Shomallo Ganguly.
Very well. This matter has come up after affidavits. Stop. Tell me when you want. Just
Monday, my lord. I'm ready.
not Monday. List this matter on 27th April 2023. Stop. Council is requested to inform, communicate this order on the respondents. Stop. The last time the matter was heard, was taken up for hearing, was on 21/7/2022, when the petitioners were not represented. Stop.
Can it be at the top, my lord? Since this has been pending for.
Let the others be here, we shall see. Next.
Great.
Item number 25.
25, Lordship, I am praying for not today, Lordship. Learned Advocate Vishwarup Bhattacharya is appearing, Lordship, due to some personal difficulty, could not come to court today, Lordship. Only for not today, Lordship.
What is this matter about, Mr. Sen?
Lord, the petitioner is a person because of a bike accident, he's suffering from 100% disability. Lord, he made an application before Lord, the Disabilities Commission for redressal.
Yes.
Lord, the Disabilities Commission wrote back to the ADM saying that these are the ways in which some relief can be granted. It appears, Lord, the district magistrate's level, this has got stuck. And Lord, there's also that letter is there, and there is also a letter written by Lord, the Joint Secretary of the Women, Child Development and Social Welfare, calling upon Lord, the district magistrate to take steps. So, Lord, what the petitioner is asking for, Lord, I suppose is Lord, expeditious disposal of Lord, this representation for reliefs.
Very well. I'm putting it on Monday. You suggest a date, Mr. Sen.
Whenever your lordship feels not.
Yes, adjournment is prayed for on behalf of counsel appearing for the petitioner. Stop. List this matter on 25th April 2023.
My lord.
Next.
Item number 26.
Speak to appear for the petitioner. My lord, from Gangasagar to Kuchubediya, well, there is a national highway. The private respondent, my lord, 9 to 13, my lord, made an encroachment over the government property. My lord, I made my complaint, my lord, which is, my lord, this my
Affidavit of
representation.
service, please.
Representation.
Affidavit of service, please.
My lord,
Who is the answering respondent?
answering respondent is respondent number 3, my lord, assistant engineer of PWD, my lord, highway authority. And my lord,
So you served them in May 2022?
my
All of
lord,
them?
my lord,
Please serve them again and come back, please.
my lord.
Yes, since the affidavit of service indicates that the respondents were served in May 2022, comma, learned counsel appearing for the petitioner is given leave, petitioners is given leave to communicate this order on the respondents and inform them that the matter will be listed on,
My lord, I feel lord, it's 1 week, my lord. I have no problem.
listed on 28th April 2023. Stop. Next.
I am grateful, my lord.
Item number 27.
I am for the petitioner. Affidavit of service.
I'm for the state respondent.
Affidavit of service. Lordship, kindly straightway, Lordship, may
Mr.
come
Chatterjee,
to P26. This is the order passed by your Lordship.
who is the
page 8.
answering respondent?
Answering respondent, Lordship, will be respondent number Social Welfare Department. That is respondent number 3. Lordship, is covered by the state respondent. State respondent may take it. Public Information Officer.
Respondent number 3?
Respondent
Yes.
number 3. Lordship, kindly come to page 82. That is
You're for the state?
Page-
For the state, my lord.
Page
Page 82.
82. This is the order passed by your Lordship. I'm reading from the last paragraph. WPA 17718 of 2022 is accordingly disposed of with a direction on the respondent number 3, being the State Public Information Officer and Deputy Director of Social Welfare Department, West Bengal, to furnish the information as applied for within a period of 1 week from date as submitted by learned counsel appearing for the state. Now, Lordship, this order was communicated, which is in page number 84 onwards, the communication. Now, Lordship, the answer which I received after passing of this order is annexed in page number 86. Lordship, kindly come. Lordship, got page number 86. It's P28.
Yes.
Query number 1. File bearing such type of such and such dated 27/12/2005 could not be traced out, which was communicated to him via office order memo dated 19th August 2019 and communicated to his advocate Sri Ratan Ghosh by the wide order dated such and such. Enclosing query number 2, copy of the report of record such committee were sent to him with this office memo number such and such. Query number 3, no. Query number 4, no. Query number 5, which I am aggrieved of, no file bearing such type of 558 dated 27/12/2005 could not be traced out as communicated by numbers as stated above, and no steps have been taken to reconstitute it. Now, what I am seeking your Lordship.
Mr. Chatterjee, this doesn't make any sense to me. What are the queries?
Yes,
You will not place the queries.
Yes,
You will only place the answers.
I'll place the queries, Lordship. It's in page number 78. On the basis of which your Lordship was pleased to direct them. Page 78.
Lordship, kindly whether the file bearing memo number 558 SWDO dated 27 December 2005 has been traced out or not. Whether the three-man committee which was formed by order number 817 SWD RTI dated Kolkata
Very well. What does the matter pertain to?
matters pertains to Lordship it's matter pertains to the appointment of the petitioner who is presently working in the department, and he was recruited on the basis of his employment exchange.
Which department?
It's Lordship Social Welfare Department.
So
Lordship.
say that.
Social Welfare Department, and under which he is working. Now, Lordship, he is still working. Now, this file, this committee was constituted for.
So what is the relief you're seeking?
Lordship.
What is the relief you want?
Relief, Lordship, reconstitution of the file which is missing, because they themselves say no process has started for the reconstitution of the file.
Yes, what do you have to say?
That petitioner was a
Can't hear
casual
you.
worker. Petitioner was a casual worker working on 103 days, my lord. 103 days in the year
Can't hear
19.
you.
বন্ধ হয়ে গেছে মাইক্রোফোন
Petitioner was a casual worker working only on 103 days in the year 1994.
That is on the merits. What about the reconstitution of the file?
Blood for the casual worker, no file was maintained, Miller. That is my instruction. And he asked for a regular engagement regularly, absorb him permanently. He would not have accrued any right working
That is
only.
not my case here. Humbly submit. I am under,
kindly
I
see the
have
prayer
invoked this jurisdiction under Article 226 for only for the purpose of reconstruction of the file.
No,
Because it's
permission
your
is
lordship
there, my lord.
jurisdiction
In the
under Right to Information Act 2000.
No, the answer says couldn't be traced out.
Blood
Doesn't
for the
say
casual
you-
worker.
Social work. Look at the answer at page 86. You have not said that he's a casual worker, therefore there was no file. You have said that file could not be traced out.
My instruction is kindly see page para 34, my lord. Para 34.
Which page?
Read petition. Appeal provision is there, my lord. Petitioner was asked to file appeal against the RTI application. Or earlier, on the same cause of action, petitioner moved before the state administrative tribunal, praying for similar relief, my lord, and that was rejected in the year 1919. No appeal preferred against that.
Yes, this is the first stage, Mr.
No, this stage is arising out of your lordship's order. After your lordship's order was passed,
Yes.
on the basis of my application made under Right to Information Act, and my prayer is limited to that. Now, lordship, my learned friend's prayer is that since petitioner has availed any other remedy earlier, that was for his job and maybe on absorption, maybe on other issues.
So why do you want reconstitution of the
No,
file? What
this
will
is
the file
important
show?
because lordship, kindly come to page 53 once and read it with me once. Now, 53, this is a communication from the State Public Information Officer to Jishnu Vishwas. The RTA application by Jishnu Vishwas was answered in this way. In reference to above, it is to state that as the subject matter is very old, dated 2005, in between the period of Directorate Office has been shifted and the old building of Directorate Office has been renovated. It will require some time. Further, from your letter dated 27/11/2009 to the Joint Secretary, Department of Women and Child Development and Social Welfare, it reveals that the file was placed before the Honorable MIC of the department memo number such and such, that is 558, SWDO 2027 to 12/2005. It is difficult to ascertain whether the file was returned to the directorate or not. However, a search committee comprising Sri Mihir Kumar Saha, Deputy Director of Social Welfare, Srimati Sangita Mukherjee, Bengali translator, and Kalyan Soren, HA of the Department of Social Welfare, has been formed to search the documents as prayed for. copy of the order, white memo number such and such has been sent to you. So Lordship, it is not a case that they have, this is a new finding by them. It was missing. They accepted the existence of the file. They formed a search committee for the purpose of tracing out the file. Now, in a subsequent reply, they are saying that file is not traceable. And they say that communicated by number, the stated above that no steps have been taken to reconstitute it. It's contradictory on their part. And that's why, Lordship, I am before you, Lordship, for a direction upon them to initiate the process of reconstruction of the file.
Very good. Yes. The petitioner assails an order passed by the State Public Information Officer, Directorate of Social Welfare, West Bengal, dated 17/8/2022, on an application filed by the petitioner under the Right to Information Act, 2005. Stop. The queries would appear from the application and include whether the file bearing memo number 558/SWD within brackets O dated 27/12/2005 has been traced out or not. Stop. Page 78. The other queries, there are other queries which also relate to the file which was maintained in the name of the petitioner when the petitioner worked in the, where did you work?
Lordship, this petitioner used to work, is working Social Welfare Department. The place of posting is the home to look after, it's a home to look after the old and infirm political sufferer, South Korea, South 24. It's a home.
When the petitioner worked in a home, capital M, capital H, under the Directorate of Social Welfare. Stop. The response, the reply, capital R, of the SPIO reflects that the file bearing the particular number could not be traced out. And that fact was apparently communicated to the petitioner. Stop. Learned counsel appearing for the state submits that the petitioner was a contractual worker and hence no file was maintained against the petitioner. Stop. Next. The state, the SPIO and Deputy Director of Social Welfare Department was directed to furnish the information as applied for to the petitioner by an order dated 10/8/2022. Stop. The SPIO complied with the said direction and passed the impugned order. Stop. The contention raised on behalf of the state that the petitioner is a contractual worker and hence there was no file which was being maintained for the petitioner is contrary to a letter issued by the Directorate of Social Welfare and the SPIO dated 29/3/2019, which states inter alia that the department, that the directorate, capital D, will require time, will need time to search the file, to search for the file, since it is an old matter and the office has been shifted and trifurcated. Stop. This letter further records that the file was placed, this letter further records that reproduces the petitioner's case of the file being placed before the minister in charge of the department by a memo dated 27/12/2005, and also that a search committee consisting of 3 members was formed to search the documents which were prayed for by the petitioner. Stop. Next, hence, comma, this court is of the view that the SPIU may be given, may be directed to reconstitute the file bearing number 558 hyphen SWD within brackets O dated 27/12/2005 within, what is a period?
2015. 2005, Lordship. Sorry.
Within how much time do you want?
Application, my lord.
Within
Within 2 months.
8 weeks from date as prayed for on behalf of the respondent. Stop. Next, intimation, appropriate intimation will be given at the end of the period to the petitioner. Stop. WPA number 217/2022 is disposed of in terms of the above.
Lordship, Lordship was directed to reconstruct the file. Lordship has directed them to reconstruct.
You did not hear what the order?
Within 8 months.
Yes, next.
Item number 28.
For the petition in this matter, my lord. My lord, so for the matter is concerned, my lord, the State Bank of India operates various banking kiosks to various remote part of the districts to spread the banking functions among the public at large. Now, my lord, this whole banking kiosk function is operated through a third party. Now, my lord, the petitioner is one of the individuals who was given to run this banking kiosk. Since 2013, I have been running the banking kiosk successfully. Now, very recently in 2022, my lord, certain allegations arose against me for poor performance, my lord. I duly replied to those allegations because there are certain technical issues for which I could not even perform. Rather, the allegations are not correct, my lord. Without considering the same, my lord, my banking portal was closed. I was not being able to function through the banking kiosk. Now, my lord, suddenly, my lord, a letter was issued upon me, which is at page 36 of the writ petition, which said that you need not to continue any further and you hand over all the documents. Now, my lord, I represented through my learned advocate. I replied to those notices because without giving any hearing, any opportunity, that notice was issued upon me. So, my lord, we checked that because since the banking portal was not functioning, I could not perform. However, my lord, I was not terminated. Only my password was blocked. Now, in the meantime, after filing of the writ petition, my lord, there is a subsequent development. Even there is blocking of the portal, I was directed to function again. So when the
portal as in you're working in the bank?
No, my lord. There's a banking kiosk. The remote part of the state, there are small banking function.
No, who are you? Who is the petitioner?
I'm the petitioner. I was running the banking kiosk of the State Bank of India. So, my lord, once I was told that you have not performed well, it was blocked. Further, I could not conduct.
Now it has again been operational.
No, it has not been. But they have stated that you start functioning. So, unless the block is removed, I cannot function. Kindly take, my lord, page 36
What is the prayer in the writ petition?
My prayer is, my lord, consideration of my representation, because these involve certain technical.
So they will do that.
Yeah, absolutely, my lord. Absolutely, my lord.
Yes, you're for the bank.
My lord, bank had done nothing. Bank had no privilege of contact with them.
I can't hear you.
My lord, may refer to page number 16.
I can't hear you.
Ask him not to do.
Yes.
My lord, may kindly refer to page number 16. Interior village for banking, there is some against commissions under RBI guidelines. Against commissions, people are engaged. Under RBI commissions, against commissions, RBI guidelines, under RBI guidelines, commissions have certain people are engaged against commissions. Now, I have never entered into contact with them. I have never engaged them anytime. My lord can refer to page number 16. It's a private company.
You are NICT. Who are you?
I'm State Bank of India person.
No, who are you?
No, I am the petitioner. Through NICT, my lord, State Bank of India, through NICT functions all these kiosks. Because the NICT authority, what they do, they are the operators, third-party operators.
Very well. So if State Bank of India is saying that they are not involved, how?
No,
what
it is
will the
it is
report
written.
say?
Kindly see page 16.
Yes.
It is the agreement. My lord, kindly see NICT Technologies Private Limited for SBI. They are functioning on behalf of the SBI because SBI delegates and outsources these works to the these NICT authorities, those who conduct the whole technicalities.
Where does it say for SBI?
My lord, kindly see page 16. Just NICT Technologies Private Limited Indoor MP for SBI kiosk banking service. The banking is of the State Bank of India.
Yes.
They are the third-party operators, those who conduct it.
Yes.
And now they have stopped it. Now, subsequently, they have said you start functioning with these details. So, my lord, this involves certain technicalities. My representation may be considered by the State Bank of India, on whose behalf I am running the kiosk. That is my humble prayer before Lordship.
Yes.
My lord, this agreement is entered, my lord, next page, in between the NICT and Porto.
Yes.
This petition. Then, my lord, may come to page number, paragraph 1, on the same page. There is an agreement for 1 year only, in between him and the NICT. Bank was never in the picture.
No, this.
Let me say. Then, my lord, then, my lord, page number, page 19, my lord.
Yes.
The NICT PL shall be free to appoint any other third party as service provider delivery partners, etc. Now they are paying commissions to them. That is coming. Now, my lord, can see, we can come page number 21, my lord.
Yes.
Termination clause. Both the parties, the NICT and them, both the parties have the right to terminate the agreement by serving an advance notice 30 days. NICT and them, State Bank is not there. Then, my lord, without prejudice, then, my lord, penalty for delay, my lord, paragraph 27. NICT TPL shall have the right to terminate the agreement by issue notice without assigning any reason. Now, what they are getting commissions that is in the service delivery system, my lord, what NICT engaged them against some commissions. That is the page number 30, after 30, my lord.
Yes.
NICT pays them annexure A, my lord.
Yes.
Page 31.
Very well. What is the point? Just tell me.
What is that, my lord? We have not in the picture because government of Reserve Bank of India issued guidelines the way back in 2006 and 2010 that banking system can be sent to the interior villages. Therefore, they are permitted to engage some persons in the.
Very well. Yes.
Kindly take page 36 for once. The very claim that bank is not involved, my lord, kindly see. This is the impugned order which was issued upon me, page 36.
Yes.
As per the subject, you are informed that your kiosk ID number associated with State Bank of India, Chichira location, Jhargram is being closed due to the following irregularities request.
Yes.
That much I'm praying.
It is evident from the material placed before the court that the petitioner is seeking to enforce a private contract. Stop. The contract in the present case is one between the petitioner, was entered into between the petitioner and NICT Technologies, Shotero, which is the respondent number which is the respondent number 5, which is the respondent numbers 5 and 6. Stop. The agreement makes it clear that there were only two parties to the agreement, NICT as the first party and the petitioner as the second. Stop. The agreement was for a service delivery partner for operating certain banking kiosks, KIOSKS, kiosks for State Bank of India. Stop. State Bank of India is, however, not a party to the agreement. Stop. Next, the petitioner is aggrieved by blocking of the portal of the kiosk, which has resulted in the petitioner not being able to function not being able to operate the kiosk. Stop. The concerned agreement also makes it clear that there are clauses for termination and other rights of the parties, which the petitioner can well enforce in an appropriate forum. Stop. The writ court is not that forum. Stop. WPA 2319 of 2022 is accordingly dismissed without any order as to costs.
Well, only one humble submission is recorded for SBI. The banking is for SBI only, that much only.
I have said for SBI.
Yes, yes.
Next.
Grateful to your lordship. My lord, it has not been terminated yet. That is my instruction. Not yet been terminated.
Item number 29.
For the petition. Area of service. Grievance. My lord, grievance of the petitioner is this, my lord. In the year 2022, my name was deleted from the electoral roll.
I can't understand what you're saying. Microphone, please. Electoral roll for what?
My name was deleted. I could not cast my vote because my name was not present in that list.
Which vote?
For any vote, my lord, on the panchayat or any Lok Sabha. My lord, subsequent to this, my lord, when in the year 2022 I came to learn that my name was deleted, then I applied for the appropriate authority for the appropriate forum. And my lord, that application I have annexed in the page 18. And my lord, initially when my name was deleted, I came to learn by using the different electoral portal number, my name was deleted by some persons. My lord,
what is the relief you want?
My lord, only this, my lord. The application which I have preferred after this, my lord, filing this writ application, this communication has come from the authority, my lord, that my grievance has been taken into the record. But my lord, I am only thinking, my lord, I came to learn that some of the person is trying to make again not to incorporate my name in the list because of reason that I have been supported by one of the political party and going to contest the election as a candidate, my lord. My lord, only I am appealing to your lordship, my name should be appear in the list, my lord, so that I can at least cast my vote.
Who is the answering respondent?
My lord, that is respondent number 2.
What vote do you want to cast? Now?
Panchayat vote is coming maybe on May or. I'm one of the candidates, my lord. That is
who is the answering respondent?
The respondent number 2, my lord. The State Election Commission, my lord.
Very well. I can't pass any ex parte order today. You tell me when you want to come back. You serve the notice
as
again.
per your lordship's convenience, my lord.
Yes, no one appears for the respondents, particularly the State Election Commissioner, which is the answering respondent. Stop. The petitioner is aggrieved by the petitioner's name being deleted from the electoral rolls of which district?
Malda.
Malda. Stop. The petitioner intends to have her name reinstated so that the petitioner can exercise her right of franchise in the upcoming panchayat elections. Stop. Next, list this matter. Tell me when.
As your lordship's director, my lord.
List this matter on 27th April 2023. Stop. This order should be communicated on the state respondents.
Lordship. My lord, that copy which I've handed over to your lordship, may I get that? I'm grateful, your lordship.
Item number 30.
Milord, this is my application, Milord.
Says Lordship, I have received just this.
Milord, I have served, Milord. I have served everyone, Milord, by email, Milord, as well as, Milord, physical copy.
Email was not opening, Lordship. That is
I
why
can't
have-
understand what you're saying. Microphone, please.
Lordship, I have received the email, Lordship, but the email was not opening, Lordship. Today morning, I have make them a letter, Lordship, to serve me hard copies for Lordship in the.
Respondent number 5.
Lordship, I'm for the respondent number 5, Lordship.
Who is respondent number 5?
Milord, this is a private respondent, Milord.
Lordship, I'm the L1,
Yes,
Lordship, the
L1.
bidder.
I am the L2, Milord. There's a challenge.
Lordship,
to
I am the
tender
L1,
process.
Very well. Yes, you lost your chance. Now you make your submissions, please. Yes.
Milord, this is my affidavit of service. Milord, it's a tender, Milord. I am L2, Milord.
Who is the tendering authority?
Milord, the tendering authority, Milord, is the respondent number 2. Lordship will take the cross title once. It's the
Microphone,
respondent
please,
number
Mr.
2, Hindustan Steelwork Respondent number 3, Hindustan Steelwork Construction Limited, a subsidiary of NBCC India, which is a government of India.
So you want the private respondent's technical bid to be cancelled?
Yes, because Milord, the bid, Milord, why I am the L2? I am the L2, Milord. I am the L2. Milord, private respondent, Milord, bidded as a partnership concern, Milord. Milord, in the tender process, Milord. Nowadays, the documents are all uploaded, Milord. So, Milord, but Milord, all credential, Milord, which has been submitted by the private respondent are, Milord, that on the basis is a proprietorship firm, Milord, of Milord, one Piyush Kumar Patel, who happens to be a partner. Milord, the private respondent was, Milord, registered as a partnership firm in 2020, but work order or the experience of Milord, the proprietorship or some other entity, Milord, of 2017 has been relied upon.
No, these submissions are meaningless without the tender conditions.
Without the
Tender conditions.
Yes,
Which
kindly, Milord,
gives the
takes the tender.
requirements.
Kindly take the tender conditions once, Milord. Kindly have a look at the tender conditions.
What is the urgency?
Milord, work order has not been issued till yet, Milord. No LY has been placed, Milord.
What are the dates? When was the work order to be issued?
Milord, work order has not been issued yet, Milord. Not issued yet.
No. When was the private respondent adjudged as a successful
Yes.
L1?
Yes, kindly, Milord, have a look at. Milord, I just give the date, Milord. Milord, they have been adjudged. I mentioned the matter, Milord. Milord, kindly take, Milord, the last, Milord, page. Which the adjudged.
This is on 31st of March.
31st of March. Immediately, Milord, my junior mentioned, Milord. It got ready. We are before the court, Milord.
31st March, they were selected.
Yes, they were selected, Milord. Milord, kindly have the tender condition once, Milord. It says, Milord, what entities can bid and what are the tender conditions that Lordship will
You are
find,
the
Milord.
tendering authority.
My lord, I am for the respondent number 3 and 4.
Yes.
Milord, kindly have a look at, Milord, page 19 once, Milord. Have a look at page 19.
90.
19, Milord, 90. These are, Milord, kindly have, Milord, A, B, and C. Or, Milord, Lordship starts, Milord, from, Milord, page 18, Milord. Minimum eligibility criteria. The interested bidder should meet the following minimum criteria. Work experience of having successfully completed similar work during last 7 years, initial steps stipulated as the last submission of tenders by NIT.
I can't hear you. Microphone, please.
Milord, kindly now takes, Milord, the next page,
Yes.
which is important. 3 similar work order, each costing not less than 40% of the estimated cost put to tender, or 2 similar work not less than 50%, or 1 similar work not less than 80%. Milord, similar work shall mean annual repair and maintenance work of any government hospital, medical colleges, ESI hospital. In similar nature of work,
And
bidder,
what is the tender for?
Milord, annual maintenance of the medical college. This is, Milord, Srirampur ESI. ESI
Yes, so
Srirampur.
say that, otherwise how will I understand what similar work is?
Yes. Milord, so Milord, ESI, similar, Milord, in medical college, Milord, one has to, Milord, discharge either 3, then 40%, 2, Milord, is 50%, 1 is 80%. That's the criteria. So it has to be discharged by the person who is bidding for the tender.
Yes.
That is, Milord, the criteria. Now, Milord, kindly now takes, Milord, what has been submitted, Milord. This is very important, Milord. Kindly, Milord, now takes, it is also a condition of the tender that, Milord, the financial strength, Lordship will kindly take page 20 once.
The financial strength, that's B, page 20, bottom. The average audited financial turnover for last 3 years shall be at least 40% of the estimated cost put to tender. The requisite turnover shall be duly signed by a chartered accountant with a unique number.
Where are you reading from?
Millard, page 20, bottom.
Yes,
The financial strength, Millard, page 20, bottom.
yes.
In case of companies less than 3 years old, average annual financial turnover will be worked out on a available period only. Now, Millard, self-certification is item number 3. Self-certified copy of the bank certificate issued from a nationalized bank in one number. So the certificate should have been issued within 6 months. So, Millard, this is what is, Millard, stated. Now, Millard, kindly, Millard, take, Millard, 6.0. This is, Millard, the set of documents which are, Millard, necessary. Now, Lordship, kindly now take, Millard, what documents, Millard, my learned friend has, the respondent number 5 has submitted. Now, Millard, kindly have a look at page 85 to 183 are the documents, Millard. 153 are the documents, Millard, which have been submitted. Now, kindly have a look at page 85 first. Kindly have a look at page 85. This is, Millard, what here? These are, Millard, page 87, Millard, is what he has submitted, is without any rubber stamp, page 87. This is uploaded, Millard, on the portal. Now, Millard, next, Millard, page 88, Lordship comes, Millard. It's an affidavit of Piyush Kumar Patel. Millard, the bid is by a partnership firm. I am the proprietor, authorized signatory of Patel Construction, having its head office, registered office as Vivek Nagar, etc., etc. So, Millard, this is been given by the partnership firm who claims happens to be a partner. It can be, Millard, one can, Millard, if wants to argue, Millard, but partnership deed is not on record. Now, Millard, kindly take, Millard, the next page, which is very important, the financial details. Kindly now take the audit report. The, Millard, certificate is at page 98, which, Millard, form C, which was, Millard, should have been, Millard, signed, Millard, by the chartered accountant. The seal is missing. So the form should have been rejected. Page 98.
Yes.
So, Millard, it's not signed by the chartered accountant. This is blank. So, Millard, financial statement, Millard, is, Millard, page 99 by one PK Tripathi and Company. It is certified that Messrs. Patel Construction Company, which is bracket Piyush Kumar Patel, at such and such UP for last 3 years. Now, Millard, it should have been a Calcutta-based company or a West Bengal-based company. This is, Millard, given. Now, Lordship will come the net worth also, page 100. This is to certify Patel Construction Company, Piyush Kumar Patel of, Millard, UP, which is he has given. Now, Millard, it doesn't have the bidder self-certification. None, Millard, these two doesn't have. Now, Millard, kindly take page 101. Audit statement, audit report. Patel Construction Company, proprietor Piyush Kumar Patel. So, Millard, the partnership is bidding, but, Millard, proprietor is given. The partnership is registered in the year 2020. But, Millard, I'll show from the documents, but, Millard, work experience, Millard, of 2017 has been produced. This is, Millard, the breach of the essential terms and condition of the tender. This is, Millard. Now, Millard, they're not, Millard, hence, Millard, GST registration is much after. Now, Millard, kindly take page 104. This is his document which are uploaded. Piyush Kumar Patel, individual. Ahmednagar. Piyush Kumar Patel, individual. Bottom, Millard. Millard, these are the, Millard, forms which he has given, uploaded. Now, Millard, general power of attorney. এটা দেখি লাভ নেই। দেখাও ওটা। Now, Millard, kindly have the registration certificate. This is a GST registration certificate. Because anything of the firm for experience would be, Millard, after this date, Millard. Now, Millard, kindly have a look at page 122. Millard, his GST registration of this particular partnership firm, Patel Construction Company, is 27th of February 2020. page 122.
Yes.
My lord, now, my lord, kindly, my lord, takes, my lord, the next page. The ESI registration of Patel Construction, which is the next page, is page 123. It's, my lord, 29th, issued to, my lord, this particular address. It's, my lord, 29th of December 2018.
So
And
what is the point, Mr. Ghosh?
Millard, point is, Millard, the bid is by the partnership firm.
Yes.
Documents of Millard, one of the individual partners, Millard, have been considered. Secondly, I show the work experience, which is there, Millard. I'm coming to that. It relies on, Millard, experience of the partnership firm who has bidded in respect of a tender of 2017. 2017, this partnership firm was not incorporated, did not have a GST registration. So how it could have been considered? I was coming to that.
Yes.
Now, Millard, the partnership has been registered. Kindly now take, Millard, the important document. Millard, kindly take page 126.
Yes.
This is the PAN number of Patel Construction Company, Millard.
Yes.
The PAN card. Millard, this is, Millard, date of formation is, Millard, 27th of December 2020.
Yes.
Now, kindly, Millard, have, Millard.
So you're saying the partnership was formed on 27 January 2020?
Millard, that is the income tax record showing, and registration, because partnership under the Partnership Act 1932 is a compendium of partners. Now, Millard, kindly take, Millard, its registration, which is page 128, which is, Millard, 24th of March 2021. These are all from the website, Millard. Now, Millard, kindly take, Millard, the experience what he has, Millard, given. This is very important, Millard. Kindly, Millard, now take, the certificate has to be given. Now take page 137. A form has to be filled up.
Yes.
Millard, ARM work, page 137, which is given, Millard. The ARM work, including annual running maintenance work. This is, Millard, the eligibility criteria. One has to fill it up. Annual work, which include electrical, firefighting, civil, etc., etc. ESI certificate was given. Date of completion is 2019. Millard, date of start is 2017. Completion is 2019. Value such and such. Next is construction of GOI battalion, Jabbolpur. This is, Millard, 18th of, Millard, October 2015. And, Millard, it ended on, Millard, date of completion 18th of October 2015. Value of 6 crores and odd. So, Millard, if the partnership is registered, Millard, GST obtained, Millard, of, Millard, a subsequent date, the partnership firm is bidding. Millard, whether, Millard, a proprietor, Millard, who happens to be a partnership firm, his experience, Millard, is this way can be taken, Millard. And, Millard, this is his document, Millard. The certificate is also, Millard, given by ESI Maniktola, which they carried out the work. It also says so.
So, Mr. Ghosh, according to you, the essential condition is that the partnership, which is the bidder, must show experience certificate.
Yes.
A. And B, must show that at the time of entering the tender, it was at the time when the documents were uploaded by the partnership firm, the firm was naturally reconstituted by that time.
By that it was constituted,
Yes.
Millard, 2021.
Yes.
But the documents in support
2017.
of the bid is by the proprietor. Annual return show, Millard, his document.
So it is only on the work experience.
In the work experience, that's the main thing, Millard. Otherwise, you will not.
And that's an
be
essential condition.
That's one of the essential conditions, Millard.
So basically, one point that the person who is showing the work experience, it's only on the basis of the individual and not the partnership.
Not the partnership firm, Millard. So he's
Yes.
ineligible.
Yes.
If your lordship may kindly comes to page 20.
Yes.
Lord,
You're the
clause B.
tendering authority.
My lord.
20.
Page 20, my lord, clause B.
Yes.
My lord, it says merger acquisition of companies in case of a company firm formed after merger and or acquisition of other companies, firms, past work experience and financial parameters like turnover, profitability.
Where are you reading?
My lord, clause B, my lord, if your lordship may kindly
Yes.
comes at the top, my lord.
Yes.
Merger acquisition and companies.
Yes.
Clause B.
Yes.
My lord. My lord, it reads in case of a company firm formed after merger and or acquisition of other companies firm, past work experience and financial parameters like turnover, profitability, net worth, etc. of the merged acquired companies firms will be considered for qualification of such company firm, provided such company firm continues to own the requisite assets and resources of the merged and acquired companies and firms. When we received the documents, we clarified, they submitted the L1 bidder, submitted that previously it was a proprietorship firm which entered into a partnership agreement. Prima facie, we were satisfied. L1, he has been declared as L1 bidders. There are certain other clarifications that we have sought. They would submit it before us. Then only the work order, the award will be issued. So, it is now at the stage of only we have declared L1 bidder because we have found, it is, we are saving 11.24 lakhs of rupees if the L1 is, given the award. They are, the petitioners.
11.24 lakhs. So
4
that's the
lakhs will
difference between L1 and the petitioner.
Yes, my lord. We will be saving. So, prima facie, L1 is 11.24 lakhs lesser than the L2 bidder.
Yes.
L1, the petitioner being the L2 bidder, still continues to work at the ASI Rampur Hospital. So,
Yes.
this is for renewal. This is for fresh continuation of the maintenance works. Tender was issued for 13 ESI hospitals.
Yes.
He has, if I am not wrong, he has been declared as L1 for the Asansol ESI in the same process. Now he is working at the Srirampur. Now he wants to again, obviously, to renew his contract for the next financial year.
The question is not whether the petitioner or for that matter any party has been awarded another contract. Therefore, this one is kind of balancing out. That's not the point. The point is whether the tender conditions have been fulfilled or not.
Our satisfaction, it were fulfilled, proprietorship, partnership, there was a confusion. We sought for clarification. They have submitted documents to our satisfaction. So,
you sought for clarification after the documents were uploaded?
After the documents were uploaded.
Why would you do that? Why would you give that special?
There was this confusion between the proprietorship firm and partnership firm. So we asked for clarification. They have submitted the partnership deed and everything. So after we were satisfied, we declared them as the L1 bidder. So, as of now,
so you saw the documents and then you declared them L1.
Yes, my lord. After,
or you had declared them L1 and then sought for the
clarification. Is the date. The date for declaration of L1 bidder is on 31st. And financial bid, 31st of March. I'm sorry, my lord, 31st of March.
Yes.
And my lord, the technical bid was opened on 16th of March 2023.
Yes.
So after 16th, my lord, we sought for clarifications. We have received documents. Then only, my lord, on 31st, they were declared as the L1 bidder. So this is, my lord, right now it is at the stage of, my lord, declaration of L1 bidder. We have not awarded the, my lord, the work order has not been awarded.
No, why would you say it's premature? Already L1 has been declared. So whether you issue the work, that's a consequential act. Yes.
My lord, prima facie on the documents and, my lord, considering the terms and conditions of the NIT.
Very well. Yes. What do you have to say?
Lordship, I have just received this. Lordship, I have just received these documents, Lordship. On over telephone, I have only just taken instruction, Lordship, from my client, Lordship. That is that it was previously a proprietorship concern, Lordship. Subsequently, it has been converted to a partnership concern, and we have applied for the tender, Lordship. That's what, Lordship, we have came to know, Lordship. I have to take some further instruction, Lordship, regarding this.
Yes,
because
yes.
I have
Partnership, so far as this merger acquisition is concerned, that is not uploaded. My case partnership document that will show Mr. such and such carrying on the partnership firm. It has been acquired as a going concern or whatever by the partnership. The deed itself is not uploaded, So it's an outright case of rejection. I could have understood consideration of B, I would not. If the partnership deed, which is the main deed,
Very well. I'm putting it on Monday. You come back with instructions. All right. Yes. Learned counsel appearing for the petitioner and the tendering authority, being the respondent number 3 and 4, have made their submissions. Stop. The petitioner is aggrieved by the selection of the respondent number 5 as the L1 bidder in a tender floated by the respondent numbers 3 and 4. for annual maintenance works of the ESI hospital, Serampur. SERAMPORE. Stop. Next, learned counsel opinion for the respondent number 5/L1 bidder. The declared L1 bidder seeks time to take instructions in the matter on the ground that counsel did not receive the papers. Stop. On the ground that counsel has not received the papers. Stop. Next, list this matter on 24th April 2023 as per.
There's a condition, Miller, they could have amped the L2. If the documents are not in order, they should have given me an offer to match. I would have matched it, Miller.
Very well. Call on the
Grateful.
next matter.
Item number 31.
Lord,
That
I
I
appear
appear
for the
for the
petitioner in
respondent.
this matter. I'm led by Mr. Abhrujit. I appear for the petitioner in this matter, and I'm led by Mr. Abhrujit Mitra, but he was there, but matter has got called. So, my lord, he had spoken with my learned senior friend, my lord. If it could be passed over for the day, my lord, we shall come back on Monday, my lord. If your lordship.
So there's no urgency, obviously.
There's urgency, my lord. If your lordship, my lord,
What urgency? It's after affidavits.
it's after affidavit.
There's absolutely no.
No, there's my lord, may I then?
Yes, you can start. You can start.
Yes. Before taking your lordship to the documents, may I, in a nutshell, my lord, indicate the brief facts. My lord, what had happened is, my lord, the petitioner had obtained financial assistance from the bank. There has been a default.
Which bank?
From, my lord, the Punjab National Union Bank. Union Bank.
Union Bank.
Yes. So, my lord, what had happened is, my lord, there was a default on the part of the petitioners, and the property which was mortgaged was sold, my lord, in by the bank, my lord, in terms of the provisions of the Securitization Act. Now, the petitioner do not join issues with the sale. What happened was, if the property which was mortgaged was one floor, and the land was mortgaged.
One floor means?
The land and an area, a particular area was mortgaged,
Yes.
which was the constructed portion. My lord, when we find that the sale had taken place, the sale certificate which was issued was also for that one ground floor only, and the entire land was there. But there was a forgery while the deed of conveyance was executed in favor of the successful bidder. And in the sale certificate, there was an interpolation by including 3 additional floors, which were never mortgaged, my lord, to imply that it was a sale for the entirety of the structure, which is ground plus 3-story structure.
Yes.
So,
what action are you trying to say, Mr.
In the writ petition initially, in the first round, in the same writ petition, but it was dismissed on the ground that the petitioners had urged this point before the Learned Debt Recovery Tribunal, and since that application was dismissed, this writ petition cannot be entertained. Challenging that order, we went up before the Honorable Division Bench, presided over by the then Chief Justice. Now, the Division Bench set aside the order and remanded the matter afresh on the ground that that point which was raised in that application was never adjudicated. And it was
by the DRT.
By the DRT, and there cannot be any question of res judicata. What had happened was, a tenant in some other floors had filed an essay before the Debt Recovery Tribunal.
Yes.
In that, my clients, the petitioners herein, had filed an IA in that tenant's essay. The tenant's essay was dismissed with a one-liner, all pending interim applications are dismissed. So there was not an iota of discussion on the case made out by the petitioners or any finding on that.
So instead of going to the DRAT, you came to the court?
No, we didn't go to DRT because of the only reason being that this was not something which was within the domain of the DRT. Why we say so is because the sales certificate which was issued, I do not have any problem with that. I had defaulted, my property is bound to get sold. The problem is what happened thereafter, while execution of the conveyance. In the conveyance, that sales certificate was enclosed as an attachment, where we found that there was an interpolation.
So if your property has been sold, what other rights do you have after that?
What we say by way of this writ petition is that, my lord, if the entirety of the property had to be sold, a notice had to be issued for the balance portions. First, second, and third floors.
Yes.
That was never done.
No, what was the security?
Of the land and
the bank.
Yes, the land and the ground floor. But
yes,
and your lordship will find, I shall show that even in the mortgage by deposit of title deeds in the my lord, schedule, only the ground floor was there. The bank's my lord, notices, possession notice, mentioned only the ground floor. Ground floor as in that area, particular area. I shall show the quantum of the area. The section 14 application before the district magistrate, pursuant to which the bank took possession, was only that particular area. But in the sale notice, it was that particular area. The sale certificate, that particular area. Suddenly in the conveyance, that has changed into three times.
Who made a windfall according to you?
The bank and the
Bank made a
purchaser
windfall.
and the purchaser. What my case is that
Auction purchaser.
Auction purchaser as per 13.2, 13.4 notices, my lord, the sale had taken place.
And the windfall was divided. No. No, you're saying no. That's why I'm asking you. How do you know?
I do not know.
Yes.
But my case before your lordships now in this writ petition is that either the sale for the balance floors should be set aside, or the petitioner should be given benefit for the value of the balance floors. So they can't have the cake and eat it too. So the difference in the quantum is why the bank is still chasing me.
So you're saying that they have been enriched far beyond the secured assets.
Yes. And in the defense, in the affidavit in opposition, is the case of the bank that since the land was mortgaged, so all accretions thereto, the bank is entitled. Firstly, the other floors were not mortgaged. Secondly, even if I take that argument to be correct, I'm entitled to the benefit of the valuation of the balance floors. And the sale notices ought to have included the balance floors. That was never the case. So even if I take the bank's case to be the highest, then also perhaps, subject to hearing my learned senior friend, of course, then, my lord, the petitioner cannot be denuded with the benefit of the valuation of the other floors.
So you want to hang on to the remaining floors?
Yes.
That is the 2, 3, 4.
3 and 4, which were forcibly sold illegally without taking possession. Because the district magistrate order under section 14 permitted the bank only to take possession of the ground floor. So, my lord, what the bank has done is, my lord, even in the sale notice, sale certificate, only one floor is mentioned. Kindly seize the 2 sale certificates. Those are glaring.
What is the relief you want, Mr. Gupta?
Your lordship will kindly have a look at my prayers once. My lord, firstly, my lord, to recall the sale for the balance floors, I cannot join issue with the ground floor. Secondly, if
you're saying land plus ground floor was the secured asset.
Was the secured asset.
Yes.
The bank has also taken one more defense, that the possession remained with the petitioner, and all accretions which the petitioner made, the bank had knowledge, the bank had consented to it, so the bank is entitled.
Possession of which floor?
Of the second, third, and fourth floor.
Remain with the petitioner.
Remain with the petitioner. It was
So bank is saying that there was no need for you to come to the court and file a writ petition.
Bank is saying that, taking refuge of the fact that the entirety of the land was mortgaged.
Very well.
But my case is, I do not join issues with either of the propositions which the bank is seeking to argue.
So the bank is agreeing with you?
No.
Agreeing with your position?
No. Bank is not agree. The bank stand is everything was mortgaged. So the sale had correctly taken place.
So G plus 3.
G plus 3 goes. That is the bank's case. Because the land was mortgaged, so everything there was mortgaged. All accretions to the property belongs to the mortgagee.
Yes.
So that is how, my lord, the bank is trying to, my lord.
So bank is saying that you already have the benefit of the accretions.
Bank is having the benefit of the accretions. That's the bank's case. So even if I take that case to be correct, I have no quarrel with that proposition. Then I should be getting benefit of the accretions. The value of the accretions, which is sold in pro tanto satisfaction of my dues. What the bank is doing, bank gives a sale notice and a valuation of only the ground floor, sells all the 3 floors, adjusts only valuation of a ground floor with me, and claims the balance amount of my NP account from me. There lies the problem. If I would have got the benefit of the entirety, that's
So
the
it's
second.
it's not a double benefit. It's a triple, quadruple benefit,
Yes.
according to you.
Yes. Single benefit the bank is entitled to. I, being a defaulter, I cannot have any issue with that. I had gone before DRT, I had lost that. So I'm not even raising that issue. Sale per se is correct.
Very well. Anything else, Mr.
Yes, may I place the 5 glaring documents of the bank, which shows that everything was only the ground floor. And suddenly in the conveyance, one annexure comes of this sale certificate.
Why do you say interpolation added by handwriting?
By hand.
By hand.
By hand. 3 words. Ground, it was ground plus 3 storied. And another place, each floor. It was 4682. There is an interpolation each floor.
4682 is the floor area.
Is the ground floor area. And it says each floor. So 2 handwritten interpolations plus 3 and each floor. And the bank has taken the entirety of that.
Documents, how much time will you take?
Shouldn't take more than 15 minutes. Showing
15 minutes.
Yes.
You want to do it in 1 day or 3 days?
1 day.
I'm taking the number of floors which you are claiming.
No, 1 day.
1 day.
1 day. Whenever your lordship's time permits, we are ready.
Very well, you come back whenever.
On Monday, Tuesday, any day.
Yes, Mr. Dhor, when?
Tuesday.
Tuesday. Yes, the case sought to be made out by the petitioners is that the respondent bank as well as the auction purchaser have enriched themselves beyond the value of the secured asset. Stop. According to the petitioner, according to learned counsel, according to the petitioners, the secured asset was the land plus ground floor, whereas while the bank appropriate ground plus 3 floors. Stop. The petitioner says that the order of the district magistrate pursuant to which the bank appropriated the building, appropriated the asset, also mentions only the ground floor. Stop. Counsel submits that the bank has interpolated the document to include, to add 3 other floors, 3 more floors to the ground floor. Stop. Next, counsel intends to place the material in support of the submissions made today. Stop. List this matter on 25th April 2023 as prayed for.
I'm great.
Mr. Gupta, just do it in 5 minutes, please.
Yes.
Next matter.
I'm so grateful.
Item number 32.
Yes, madam. But I'm for the petitioner, and very unfortunate that the petitioner is it lady? Is it about 7?
What unfortunate?
Is it about?
I can't understand. My microphone, please.
My lord,
Unfortunate. What is unfortunate?
In this matter, I am appearing on behalf of respondent bank, but I am praying for not today, my lord.
What is the urgency?
But the urgency is this: that petitioner purchased the one shop room from the private respondent in the year 2007.
This means microphone.
In the year 2007. purchased a shop room from a private respondent in the year 2007. And thereafter, he has started his business in the said shop room. One fine morning, one bank authority, Union Bank of India, has came to me and stated to me that this property is mortgaged with the bank authority. Subsequently, suppressing the material fact by the private respondent. So by didn't of a deed, I purchased the said property. And immediate after that, on that occasion, the bank authority trust me and just oust me from my shop room and just keep the lock and key under the said
Very
shop
well.
room.
When was this done?
My lord,
When was this done?
2007, I purchased the property from the private respondent, and 2017, the bank authority has came to me and just said me that this property is mortgaged with the mortgaged with the bank authority.
2017.
Yes.
And you have filed the writ petition after 4 years.
No. I filed an application before the DRT there, and against the DRT passed an order in the year 2020 that has given a direction to the bank authority to to settle up the matter with the private respondent and the petitioner. But unfortunately, after giving such order by the DRT, the bank authority reluctantly and not to take any step about the said order. Now finding no other alternative, just to file this application here. Now the fact remains here, since 2007 and 2017, the petitioner is not running the business, and just most of the approximately most of the loan amount has been disbursed, and this has been realized by the private respondent. But apart from this, only 1 lakh is remain dues. And thereafter, the private respondent made an application before the DRT also, and where the DRT has passed an order that the private respondent has realized the entire amount, only 1 lakh amount is dues. And subsequently, we made an application before the DRT, and DRT has finally passed an order.
You bought the property from the private respondent?
My lord, yes. My lord, there is a nexus between the private respondent and the bank authority.
Yes, you come back on Monday?
Yes.
So there is a nexus between the bank authority and
don't make these submissions without documents. Show me the documents.
So,
on the-
I
on
got
the-
the
Second round of litigation. Prior to that, they have filed.
If you are asking for time,
Yes,
then you
Lord.
get ready and come back on Monday. All right?
Deeply
It
obliged.
is only because of your prayer that I'm keeping it on Monday.
Yes.
Yes.
Yes. A learned counsel appearing for the bank seeks an adjournment. List this matter on 24th April 2023. এটার ওপর দিকে রাখো তো। Next,
Well, we serve the copy upon both the parties, and this affidavit.
the affidavit of service is kept on record. Next. সে তো তিনটে থেকে ছিল তো। তো এখন বলছো ভুলে গেছিলে নাকি? ডাকো।
Jalpaiguri contempt application item number 1.
My lord, I am appealing for the petitioner, my lord. My lord, I am extremely sorry, my lord, because my lord, I am unable to appear physically before your lordship because my lord, I am suffering from fever. My lord, this is a matter, my lord, where your lordship has passed the order on your lordship 20th April 2022. And in the earlier occasion, your lordship directed me to serve copy to the contemner respondent. My lord, I have served. My junior is there, my lord. My lord, she will hand over the affidavit of service to your lordship. My lord, an order has already been passed, which has been communicated to me. My lord, although my lord, I have gone through the order, but my lord, the order is not, my lord, in the true spirit as your lordship passed the order. Whatever, my lord, the order, since the order has been passed and a new cause of actions, my lord, has arisen, my lord. So, my lord, lordship kindly pass the order as your lordship thinks fit.
Where is the order?
My lord, they have communicated me over the phone, over telephone, over WhatsApp, my lord.
So, Miss
My
Shana,
lord,
tell me which date, whatever I need to record an order.
my lord, the advocate, my
my
lord, the learned advocate appearing for the contemner respondent, my lord, online, my lord.
Yes.
Even then, my lord, the order has
It's
been passed.
Lordship, it's order dated 20th April 2022.
No, 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 not that order. That is the order passed by your lordship. The order passed to your lordship, the recent order has been passed by the contemner respondent. That has been passed on 2nd of March.
No, no, 20th April. 20th April 2020.
That is yesterday, passed yesterday.
No, Lordship. 2nd March 2023.
That is what
And
I am
pursuant to-
saying now.
No.
Mr. Bottom, please, if you don't know the fact, don't confuse the court. Please keep quiet. Don't
Lordship,
confuse the
Lordship.
court. Yes, Mr. Yes.
Yes, my lord, pursuant to your lordship's order, my lord, he has been called for the hearing, and my lord, thereafter the order has been passed. That is on 2nd of March 2023. This has been communicated to me through WhatsApp, where my lord, they have
Counsel
rejected.
for the petitioner submits that the alleged contemnor has passed an order dated 2nd March 2023. Stop. Counsel intends to take appropriate actions in respect of the said order. Stop. Next, the alleged contemnor is represented, but counsel is not aware. But counsel does not seem to be aware of the subsequent facts. Stop. Next. CPAN, I'm disposing of the contempt. All right.
Yes, my lord.
Yes. CPAN 13 of 2023. And what happens to the writ petition, Ms. Shanobis?
Writ petition, my lord, writ petition, your lordship disposed of, my lord, directing the respondent.
CPAN 13 of 2023 is accordingly disposed of in terms of the above, with liberty to the petitioner to take appropriate action.
I'm grateful, my lord.
Next.
In item number 40, my lord, the interim order is still today. If your lordship may kindly.
Which item 40?
Item 40, my lord, of the regular list, my lord.
Have I called it out?
No, my lord, your lordship would be has taken up.
Mr. Dotto, you have to wait. Please
Wait.
don't interrupt.
Wait.
Yes, call on the next one, please.
Port Blair contempt item number 1.
Your Lordship, I am for the petitioner. Here, Your Lordship, you kindly see page number 11, Your Lordship.
Yes.
Page
Who is
number
the petitioner?
11. I am for the petitioner, Your Lordship.
Yes.
Your Lordship, here, Your Lordship may kindly see page number 11. Page number 11 is the impugned order. Authorities have kept the appeal pending for
page 11 of what?
Contempt application, Your Lordship.
Page 11 is a pleading, is a part of the pleadings.
Your Lordship, then next page, Your Lordship, after affidavit. I think pagination has not been done properly, maybe, Your
Page
Lordship.
15 is the next page. Yes, the petitioner is directed. The advocate on record of the petitioner is directed to correct the pagination of the petition. List this matter on. Yes, Ms. Nag, when do you want to come back?
Your Lordship, that pagination is correct, Your Lordship. What Your Lordship is having, that is correct. So I will be referring to it. There's no difficulty, Your Lordship, for me. It's done in my paper. It is wrongly done. So I can show it, Your Lordship.
Yes.
So the impugned order, Your Lordship, this is WP annexure P1. That is the impugned order.
Give me the date. It doesn't even bear the annex.
22nd August 2022. That is the order, Your Lordship.
Yes, neither the page numbers nor the annexures are matching.
Your Lordship, I think the second item has been taken. Kindly see, Your Lordship, second item is also there. What is the name of the case, Your Lordship? I think so, because there are two matters, two contempt application. It's CPN 10 of 2023.
কোনটা দিয়েছো তাহলে? Sorry, Ms. Nag, the wrong papers were handed over to me.
Your Lordship, Your Lordship.
Page?
Page number 11, Your Lordship.
Yes.
22nd August 2022 is the order.
Yes.
Your Lordship, may kindly see the last paragraph. WPA 332 of 2022 is accordingly disposed of with a direction on the respondent to dispose of the revenue appeal filed by the petitioners in 2019 within a period of 6 weeks from today. The usual formalities, representation and service shall be complied with. Now, Your Lordship, the order was communicated to the authority on 14th November 2022, which is the next page, page number 12.
Yes.
Despite such fact, Your Lordship, till today the appeal is pending. It's 4 years have passed.
Is the first time it's coming, Ms. Nag?
First time.
Yes, the petitioner is aggrieved. The order in contempt is dated 22nd August 2022. Stop. By the said order, comma, the writ petition was disposed of with the direction on the respondent being the principal secretary within brackets revenue, close brackets, to dispose of the revenue appeal filed by the petitioners in 2019 within a period of 6 weeks from date. Stop. The order was communicated on the alleged contemnor on 14 November 2022. Stop. Next, the petitioner is directed to serve a copy of the writ petition, serve a copy of the application on the alleged contemnor. Stop. List this matter. Yes. List this matter on 12th May 2023. Ms. Nag, you served them after 4 months. So that dilutes your cause of action anyway. Next.
Item number 2.
Your Lordship, I am appearing for the petitioner. Order was passed on 23rd August 2022, which is at page number 23, and direction was given, Your Lordship, at page number 28, that WPA 64 of 2022 is allowed and disposed of in view of the reasons stated above. The respondent authorities are directed to grant 1/30th of the minimum of the relevant scale plus applicable dearness allowance to the writ petitioners from the date of their initial appointment, which shall be given to within 4 weeks from the date of communication of this order. The respondent authorities shall bear in mind the order passed on 14th February 2020, similar circumstances, take steps accordingly. Now, Your Lordship, till today, 4 weeks time was granted. That was granted on 23rd August to the 2022.
When did you give them serve them?
Your Lordship, 21st October 2022, we have served, Your Lordship, because certified copy took some time to obtain the certified copy. And there were holidays also in between. So it took some time for me, but it was communicated on 21st October 2022. Now we are in April 2023. Till now, Your Lordship, they have not complied with
the order in contempt is dated 23rd August 2022.
The other side is appearing.
No, my lords, I have instructions to appear, but I don't have a copy of the contempt petition. If my learned friend can give me a copy, my lords,
I'll give a copy, Lordship.
Which was communicated to the alleged contemnors on 21st October 2022. Stop. Next. Learned counsel appearing for the alleged contemnors seeks time on the ground that the application has not been served on
applications are not generally served.
Stop. List this matter on when do you want the matter to be listed?
12th May, Your Lordship, same date. That matter is taken.
My lords, for my lords, because in this case I'm appearing, my lords, I'm requesting, my lords, if it can be after 4 weeks, my lords.
No, Your Lordship.
No, the first case there is no appeal. No, I will file an affidavit. No, so that I can.
12th May. Next. आगे तक 12th May चलो. Next.
Obligation.
Contempt application item number 199. Daily list.
Lordship, I am for the petitioner, Lordship.
Yes.
The date of judgment was 14th January 2022. And Lordship, the order was communicated on 16th February 2022. I'm the first time before this court, Lordship.
Page.
Lordship, page 12, and Lordship, kindly appreciate page 14, Lordship, the order, Lordship.
Yes, the petitioner alleges contempt of an order passed by this court, of a judgment and order passed by this court on 14/1/2022, which was communicated to the respondents, to the alleged contemnors on 16/2/2022. Stop. List this matter on 12th May 2023. Service in the meantime.
Lordship, I'm grateful, Lordship.
Daily list নিচ্ছে না কেন? list নিচ্ছে না কেন? Call হচ্ছে না কেন? 909 কর।
Regular list last কোনটা কল হয়েছিল? Thirty-two.
Item number 200.
I am for the petitioner, my lord. My lord, page number 25, the impugned order dated, my lord, 30 August 2019, my lord.
Page
25, my lord. No, 24. Start from 24 and relevant pages, my lord, 38. The order.
First time?
Yes, my lord, first time.
What is the can for?
My lord, the petition was filed in the petition was filed in Corona period, my lord. On that occasion, a can application was moved to file the urgent pleadings of urgency, my lord. That is regarding.
Yes, the can is disposed of. Stop. The contempt arises out of an order dated 30/8/2018, which was communicated to the alleged contemnors on.
My lord, page number.
Yes, Kirkirda.
42.
List this matter next on 28 April 2023. Learned Counsel is expected to get ready in the matter. Next.
My lord, one thing, my lord, the order
The can is disposed of.
Yes, my lord. Order, impugned order date is, my lord, wrongly recorded at 2018, my lord. It should be, my lord, 2019.
Very well. Come back on the next day and make that submission.
Yes, ma'am.
Yes.
নামটা দেব।
Yes. Original side, please. This is not the time to mention. Sorry. Come back on Monday.
Just one indulgence.
No. Come back on Monday. Mr. Dotto, which one was your matter? The interim order expiring?
Expires today.
Today. It will be on সোমবার দিন সুদীপ্ত কোথায় গেল ডাকো তো?
এই আমাদের লিস্টটা নেই।
Which one is your matter?
Item number 40.
কি বলছো? এটা কোথায়? লিস্টটা কোথায়?
This was that disposal of biomedical waste matter. Appellate side, item number 40.
Who is appearing for the respondents?
Mr. Nilotpal Chatterjee was appearing for.
Mr. Dotto, you come back on Monday, please.
But we have given a notice subject to your lordship's consideration.
No, you come back on Monday, সোমবার দিনের ওঠা। And it will come under the heading, so it will be called on extension of interim order.
Where?
প্রথম দিকে রেখে দিন। Yes.
I'm grateful.
Item number 2, Square for Assets Management.
Made. This is an application made by the plaintiff. I'm appearing for the defendant number 3.
Yes.
And I'm in the midst of. I have made submissions on 2 days. I'll just tell my lord very briefly what the submissions were.
Yes.
The main contention when my learned friends concluded was that the defendant number 3 is a sub-lessee.
Yes.
I showed your lordship that there was a deed of assignment. So if the property, my lord, in 1965 was leased to one Alipe company.
Yes.
They were later renamed as Oriental Beverages. And in 1972, there was a rectification of the lease allowing assignment. Pursuant to that, part of the property was assigned to Steel Authority of India. That time it was ISCO. ISCO's name has been deleted. Now it's Steel Authority of India. So it was basically an assignment. So the question is that if I was a lessee, and not a sub-lessee, that's number 1. There's no notice of eviction against me. The eviction notice is against Oriental, who has surrendered its portion of the lease. So they are contending, Malad, that in the suit that I am also liable to be evicted.
Yes.
Because the mother lease is gone. But it's not a mother lease, it's been split into 2. That was the first point. But thereafter, my lord, where the application has been made, now what they are seeking is, they are seeking occupational charges at the market rent. So that is not permissible according to us. And that's the point I haven't addressed your lordship. I had addressed your lordship on 2 or 3 preliminary points. One was when the suit was filed, all the trustees who are the owners of the property were not parties. In fact, they tried to add trustees. The application was dismissed. Then in the division bench, they were allowed in the interest of justice to add the parties. Now, and the suit was directed to be heard out. And when they did so, they withdrew their Chapter 13A application. Because when the Chapter 13A was filed, there weren't sufficient trustees on board. So they withdrew the Chapter 13A, but they haven't withdrawn this application. This application itself has been affirmed only on behalf of the plaintiff number 1, who claims to be a fresh lessee of the property, and the plaintiffs number 2 and 3, who are the trustees. So this application per se is not maintainable. On the Trust Act, I showed your lordship the points. Yes. Now, today I will address, my lord, as far as the occupational charges are concerned. I had also addressed another point that if the lease was registered prior to the 1997 Act and the lease rent is less than 10,000, then I am entitled to protection under the 1997 Act. And this will, of course, be a subject matter of the suit, and they have given us no notice. So prima facie, I have a lot of tribal issues which are to be heard in the suit. And their suit as filed was void, liable void ab initio because the trustees weren't there. The fact that later they have been brought in the other trustees, that issue will be decided whether it reverts back to the filing of the plaint or only from that date they can do so. And these applications were made prior to it. Now, my learned friend cited two judgments. So today I want to just distinguish those judgments, and I'll contend, my lord, that they don't help my learned friend at all. Because both the judgments say that if I was a tenant before and the suit is filed till the decree is passed, there's no question of paying occupational charges at the market rate of rent. So if my lord sees the two judgments, first, if my lord takes 2021 SCC online, Calcutta 428.
Yes.
I think a copy has been given.
Yes, yes.
From Pashal.
Yes, I have it, Mr. Ghosh.
Yes. So this decision that was relied upon has held that, in fact, the dispute, I don't know why this was cited, because it says that the plaintiff wanted occupational charges at the rate of rent. So to cite this judgment and say they are entitled to occupational charges at the market rent, and the other prayer is appoint a commissioner who will assess the market rent and therefore direct us to pay that sum. Well, this judgment doesn't help at all. If my lord sees the judgment, it relies on another division bench judgment, which I shall rely on. But I'm just quickly distinguishing the two. Paragraph 16 and 17 were placed by my learned friend.
Yes.
Now, if my lord sees paragraph 16 and 17, the question, while referring to another case, this KK Shah's case, it said, the question referred to the Honorable Chief Justice for constitution of a larger bench was held as follows: whether the civil court can direct the tenant to pay occupational charges, damages, mean profits during the pendency of an eviction proceeding at prevalent market rate in excess of contractual rate. This was the question that was referred to in the KK Shah judgment. I'll cite that. The question was answered by the division bench in KK Shah that the trial court could not pass any direction upon the defendant or tenant or payment of occupation charges at the prevalent market rate during the pendency of the suit on a prima facie basis unless there was an admission on part of the defendant about the existence of the relationship of landlord and tenant and between the parties, and the service of notice was admitted. My lord, as far as Square 4 is concerned, there is no jural relationship with Steel Authority and Square 4. They are a subsequent lessee. And as far as service of notice, I'm saying that no notice was sent to SAIL, it was sent to Oriental. Then, unless it is admitted, the decision did not deal with the situation as in the instant case where the landlord is asking for payment of contractual rent and occupation charges. And I don't know why this judgment was cited, because if they are asking for that we are willing to pay at the contractual rate. But we'll deposit it in court because we don't accept that Square 4 is entitled to such payment. The trust probably is, but that is another matter. Then paragraph 18, in this case, it is an admitted position that the opposite parties are tenants in respect of the property, and they have contended they are entitled to reside in the property upon payment of rent. The tenancy was terminated by a notice invoking sooner determination clause. As has been held in the decision of the Delhi High Court, the court, under exercise of its inherent powers, can direct payment of admitted rent. The decision on KK Shah was on a question whether the court could issue a direction upon the defendant to pay occupation charges at the market rate in excess of contractual rent by way of damages until termination notice was upheld. Well, here the notice has not yet been upheld, so I'm contending that they cannot ask for it. The division bench held that without knowing what the defense is likely to be advanced by the defendant in the written statement, and without there being an admission on part of the defendant about the existence of the landlord and tenant between the parties, the question of payment of occupational charges at the market rate during the pendency of the suit could not arise. So this decision does not help my learned friend. And lastly, my lord, paragraph 20. In this case, the petitioners are not claiming rent at the market rent, but are claiming the contractual or agreed rent as per the lease deed. The rate of monthly rent was never denied by the opposite parties and the agreed rent was paid. So, my lord, for purpose of clarity, my lord, may I cite the division bench judgment that was referred to. This is reported in 2007.
This is KK
Shah. 2017 SCC Online, Calcutta 2123. It's also reported in CHN. No, I've got it marked in my own. Yeah, I'll just say it. So, in this decision, the first four paragraphs are to do with the facts of that case. Eviction suit was filed. They wanted occupational charges at a higher rate. Then, my lord, paragraph.
So, Mr. Ghosh, you're saying that the coordinated bench judgment does not help the petitioner because the petitioners are asking for occupational charges at the market rate.
Yes.
And that one line in paragraph 16 or 17, which says that the larger bench did not go into that issue.
No, Her Lordship referred to a decision of a larger bench.
Yes.
And I'm citing that decision now to show what was the question before
No,
that
KK
larger.
is the division bench.
The division bench.
Larger bench is which matter?
No, not larger. KK Shah was because two learned single judges differed.
Yes.
And it was sent to KK Shah, to the division bench to decide. A reference was sent.
Very well.
So larger bench in that sense.
So larger bench is the division bench.
Division.
Very well.
I replaced 20. So the real question was in the division bench judgment in KK Shah. Can a plaintiff be entitled to claim occupational charges during the pendency of a suit which has not yet been decreed? So, my lord, will come to paragraph 6 onwards. How this matter came up before the division bench. The learned trial judge, by the impugned order dated 20th August, kept the hearing of the plaintiff's application under 151 in abeyance, as the learned judge was of the view that such petition of
where are you reading from?
Paragraph 6,
yes.
Second page.
Yes.
Should be declared after taking evidence in connection with the suit. So the plaintiff had applied for occupational charges at market rate. The learned judge kept it at abeyance. And the legality of the said order passed by the learned trial judge is under challenge in this revisional application. Yes. In this revisional application at the instance of the plaintiff. Then, in the course of hearing of the revisional application, notice of the learned single judge of this court was drawn to a decision of another single judge of this court in the case of Konok Projects. That's reported in 2014 CHN. Relying on the principles laid down, the learned single judge of this High Court in the Konok Projects case, the revisional court was invited to interfere with the impugned order. In the Konok Projects case, it was held that if the trial court finds in an eviction suit that there is absolutely no defense of the defendant and the eviction would be a matter of course, the trial court, by applying principles laid down by the Honorable Supreme Court in Atmaram's case, can pass interim orders for mean profits pending passing of the final decree. It was, however, held therein that the trial court is entitled to put the defendant on terms for occupation of the property on a provisional estimation of mean profits as laid down by the Supreme Court in the Atmaram's case, subject to adjudication of the final mean profits at the time of decree. It was, however, observed that the court should be cautious that the provisional mean profit should not in any case in no case be more than the mean profits. So that was the finding in Connaught projects, relying on Atmaram. Holding such, the direction was given on the defendant to deposit current occupational charges with the registrar till final mean profits were decreed. Then 11. The learned single judge who was taking up the present revisional application could not agree with the principles laid down in Connaught project's case. His lordship was of the view that the condition may be imposed by the appeal court at the time of passing an order of stay of eviction decree, or at the time of staying the execution proceedings in an appeal filed by a tenant or appellant, but such direction cannot be passed in an eviction proceedings if the eviction proceedings is dismissed by the trial court and the appeal is filed by the dissatisfied landlord. It was also observed by his lordship that on the same analogy, if a suit for eviction is still pending and no decree is passed, it is not open to the court to direct the tenant to pay occupational charges till the court passes a decree for eviction. According to his lordship, such passing of a direction upon the defendant for the payment of damages or mean profits is opposed to the definition of tenant as defined under the different rent control legislation. Then his lordship held that section 2H of the West Bengal Premises Tenancy Act clearly provides that the tenant, even after termination of tenancy, shall enjoy all the protections and rights as the contractual tenant. So this is why, my lord, it was referred to the division bench. Paragraph 13, with such disagreement, a reference was sought for the following point. And the point is in 14, where the civil court can direct the tenant, it should be whether the civil court can direct the tenant to pay occupational charges, damages, mean profits during the pendency of eviction proceedings at the provisional market rate in excess of contractual rate. Now, so this is how the division bench took up the matter. Now, if my lord comes to 22, paragraph 22. Now we will have to examine as to whether the interim direction can be passed by the learned court upon the defendant for payment of damages during the pendency of the suit. Payment by way of damages is a payment for wrongful use and occupation of the suit premises. So, for passing a direction for payment of damages by the defendant, the court must first of all decide as to the nature of possession and or occupation of the defendant in the suit premises. Such determination, in our view, depends on various factors, such as existence of relationship of landlord-tenant between the parties in respect of the suit premises. If I may pause here for a moment, I am not the tenant of Square 4. There is no relationship with us. Then 2, legality of termination of such tenancy by the admitted landlord by service of notice upon the admitted tenant under 106. If it is found that there is no jural relationship of landlord and tenant between the parties, the termination of tenancy by notice under 106 will be bad and ineffective. Again, even if the relationship of landlord and tenancy is found to exist between the parties, still then valid termination of the tenancy depends upon the legality, validity, and sufficiency of the notice. If it is found that the notice under 106 of the Transfer of Property Act is invalid and or insufficient or illegal for any reason whatsoever, the court cannot pass a decree for eviction against the defendant in such a case. In that event, the tenant will continue to be a tenant under the landlord and his tenancy will remain unaffected even by service of the 106 notice. Then paragraph 27. So 25 and 26 say that in that case, the defendant has still not filed its written statement. My lord comes to paragraph 29. Such being the position in law, we are unable to agree with the views expressed by the learned single judge of this court in the projects case, that's Connaught projects, that even the trial court can issue directions upon the defendant tenant to pay occupational charges at the market rate by way of damages in absence of any provision of law. Even direction for deposit of damage with any officer of court is not permissible, as we have already held that such direction can only be passed after the issue as to the legality of the possession of the defendant in the suit is finally decided in a suit. Though Civil Procedure Code was amended by several states by introducing a new order, being Order 15, Rule 5A in the Code of Civil Procedure, dealing with the striking of defense of the lessee in a suit for eviction filed by the lessor, but such provision is absent in our state. So, the other case my learned friend cited, which I shall show my lord presently, there it depended on Order 15, Rule 5A.
Justice Maheshwari?
Yes.
Yes.
Yes. Yes, Justice Maheshwari. So that was on that provision which is not applicable in Calcutta. So that case is also irrelevant for our purposes. Yes. Well, 30, if I may please. This conclusion we draw for the reason that if ultimately it is found that the tenancy is not governed by the Transfer of Property Act, or there exists no relationship of tenant and landlord and tenant between the parties, or the termination of the service of notice under 106 is illegal and invalid, the court cannot pass any direction upon the defendant for payment of damages.
So, Mr. Ghosh, you are whose lessee? You say that you are not a sublessee. That was your submission on the last date.
That the lease was given to LAP. LAP assigned a portion of the lease to me. It was given by the Malliks, the trust. A portion of that was assigned to me in 1972. And I've been paying rent, so I am a lessee under the Malliks.
Very well.
And thereafter, my lord, after it was assigned to us, we paid. The agreements I'll show, my lord. We paid for the construction of this building.
So what is your relationship with the plaintiff?
No, with the Square 4, I don't have any relationship. The Square 4 has come in subsequently. Well, after the period of the lease expired, I continued in possession. The Steel Authority's contention was, and is still, that we were Thika tenants because the building had been built, the structure belonged to us. That was the basic. That's the basic thread that runs through our written statement. So that is a point of fact which has to be decided in the suit. That is a separate matter. Well, we are not on that. Well, then I had told my lord that what would be my status? My status would be as of a monthly tenant. Because after the expiry of the lease, well, the lease itself was a registered lease which was registered before 2001, when the 1997 Act came into force, and the rent is below 10,000. So I had shown my lord the provisions. I'll show that again. So even if I'm a tenant, if I was a if my lord holds that I have come under the Tenancy Act, then also till the suit is decided, I am entitled to pay only the last paid rent. And if I'm not, this judgment says that till it is decided whether my occupation is wrongful or not, I have to pay only up to the last paid rent, as it were. So that we are willing to, but they are asking for a commissioner to assess the mean profits now without having the suit heard. And there are other points that the lease that was given to Square 4 was signed only by 2 trustees or 3 trustees out of the 7 trustees. So that lease itself is bad at law. And they had got a concurrent lease. They got the lease before our lease expired. And for the balance period, they've got a separate lease. Now, I am not their tenant. So that's why they made the trustees a party, but they didn't make all the trustees a party. Now that mistake has sought to be.
If you say that you're a monthly tenant of who?
Under the Malliks, by operation of law.
Yes.
So my paragraph 31, my lord, because this Atmaram's case is really on the basis of which this application has been made, because in Atmaram, the decree had been passed. to stay the execution at that stage. Under Order 41, the Supreme Court said that, yes, you have to pay market rate of rent. You can't occupy somebody else's property without paying any money. But if my induction was valid, then my lord, I don't have to pay more than the occupational charges. I'm stopped paying because I contended I'm a Chika tenant. Even if that is, I can always run an alternative case that if I'm not.
You can stop paying with that kind of contention.
The lease expired by efflux of time in 2015. I continued. Then the suit was filed. When it was filed, it was defective. Then later, after 3 or 4 years, it has been sought to be corrected. But I placed that order of Justice Shonji. So then the division bench said that the suit is liable to be dismissed, but it would only mean that they'll file a fresh suit. So they were given the right, and this point was left open for the suit, whether it will take effect, whether it was void at the time of its inception. And when this application was made, this is an old application. It has come up in the list, so they have pressed it again. But they withdrew their Chapter 13A application because they admitted that it was defective, because all the trustees were not on record at the time they made that. And this application has not been amended. It still shows that there are 2 trustees, and the verification also is on behalf of 2 trustees. That also by a constituted attorney. There was also another point I took, that this lease that has been given by the trust to Square 4 is more than 20 years, and Section 36 of the Trust Act says that without permission of court, you cannot give a lease more than 20 years. So the lease itself, so the person who's asking, his status is in doubt. The suit is in doubt whether it was valid at the time it was filed. Then, Manoj, this application certainly is not maintainable. And the last order that was passed by the division bench, adding these trustees, it was made clear that the suit should be heard out. Now, instead of having the suit heard out, some of the tenants have surrendered, some have admitted, they have got decrees against the other occupants of the building, and they are proceeding against them. And now they are trying to proceed against even the Steel Authority. But the direction was that the suit will be heard out. Manoj, may I just place this, Manoj? The paragraph 31. In Atmaram's case, the Honorable Supreme Court held that the condition can be imposed upon an appellant for allowing him to enjoy the benefits of the stay order during the pendency of the appeal. Such conditional order can be passed by the appeal court in exercise of its jurisdiction under Order 41, Rule 5 of the CPC, where it is provided that the appellate court may, for sufficient cause, orders stay of execution of the decree subject to furnishing security. Then Order 41, Rule 5 also authorizes the court which has passed the decree to pass an order of stay. Such power can be exercised by the court after passing the decree, but not before passing the decree. Then, as such, we answer the question under reference in the negative by holding that the trial court cannot pass any direction upon the defendant tenant for payment of damages during the pendency of the suit.
That is all, Mr. Ghosh?
I have to deal with my learned friend's other case, and then I have to cite those cases formally to my lord to show that if the trustees were not on record, 1 in the suit, 2 in the lease that they have done, I have to cite those judgments to show that.
Mr. Ghosh, you give me the citations and the paragraph numbers.
Yes.
I will read the case.
So now may I just in 5 minutes at least try to distinguish.
I have understood your submissions. Distinguish what?
Only two decisions were cited by my learned friend. First was the Justice Shorka's judgment, which I placed, and that judgment relied on KK Shah. I have placed KK Shah. It's completely in our favor. Now, the other one is 2021 on SCC Online, Calcutta, 428. I'm sorry, no, 2022. I'm sorry, 2022 SCC Online, Supreme Court, 829.
This is Justice Maheshwari's.
Yes.
Yes.
Now, here the issue was under Order 15, Rule 5A. That order doesn't apply to West Bengal. This was a special, it was amended, the CPC was amended for the purpose of that particular court. I think it was Punjab. May I just place the 2 or 3 paragraphs? The present appeal arises out of a suit for eviction and for recovery of arrears of rent and damages for use and occupation, filed by the plaintiff against the defendant, wherein by an order dated such and such, passed by the trial court, striking off the defense of the defendant for failure to pay the deposit of due rent, which was approved by the revisional court but set aside by the High Court. The Supreme Court set aside the High Court
Very
judgment.
well. Just show me the paragraphs by which you want to distinguish. That's all.
Well, the
Yes.
Supreme Court set aside the High Court judgment and upheld that Order 15, Rule 5A is applicable. It's there because that rule says that if a suit is filed against a defendant as a tenant, if he doesn't put in the money, his defense will be struck off.
Very well. Which paragraphs? You just tell me the paragraph numbers, please.
25 and 26.
Yes.
Now, if I may start from 24.
No. Mr. Ghosh, I don't allow anybody to place paragraphs. I always read the cases myself.
Yes. So paragraph 24.
Yes.
25 sets out this rule.
Yes.
And 26 explains the rule. And then from 36 to 41. 45. That's the whole judgment.
36 to 41.
45.
36 to 45.
Yes.
Very well.
And it was held that in that case, it was a good case for striking out the defense. I can show from the Code of Civil Procedure that this doesn't apply to the High Court. This Rule 5, it doesn't apply to West Bengal itself. Order 15.
Very well.
And my
Anything else?
only other point my lord will note about this, the Justice Maheshwari's judgment is, there also it was the rate of the rent to be deposited was at the last paid rent, or the current rent, as it were, and not occupational charges at the market rate. Now there is, my lord, I'll prepare a note and bring it on the next day, my lord. But if there are 2 other points that I haven't addressed, my lord.
I remember. One is
there is a claim for taxes.
Yes.
Now the taxes claim, there are several judgments we have shown. We are paying the KMC taxes. There's an appeal pending before the KMC has to reassess. There's an order of the appeal court, my lord, that they have to reassess. We are pursuing that. So we don't have to pay the rent to the municipal taxes to the landlord.
Very well. Mr. Ghosh, get the note on the next day and don't place the note. I will read the note, conclude on the next day in 2 minutes.
Yes.
In 2 minutes. And Mr. Mitro, you are appearing for? Sorry, you had told me last time, but auditor dakao to last auditor.
Number 8.
8.
Oh, sorry.
I am defendant number 8.
8. Who are you supporting, Mr. Mitro?
I am defendant number 8.
Who are you supporting?
Our case is different, my lord, because we have already delivered a possession of the portion in our occupation. Already, and plenty was taken.
Pursuant to an order of court, pursuant to a decree.
No, in fact, sorry. We offered to give them possession. The plaintiff would not take possession. We have to make an application in court. Single bench pass an order, yes, to deliver. Matter what they took matter in appeal court. Ultimately, appeal court pass an order, yes, delivery a possession of your flat, 2 flats, 2 floors rather.
Yes, I remember.
Then that is one thing, but they have got taken possession. And second, Milord, my point would be that between the plaintiff and my client, I am a sublessee. That is the case. There is no privity of estate or privity of contract between the plaintiff and defendant number 8. Therefore, no right to claim rent or any mean profit as against me. Their right and liabilities are against defendant number 1, OD and beverage. who was the lessee of the plaintiff.
Then why did you hand up why did you want to offer your flat to the
We're a
plaintiff?
government semi-government company. We did not need the flat any longer. We had to give up.
I thought my learned friend, my lord, really had nothing to say in this application because, my lord, there's already an application which, my lord, has decided with regard to, my lord, the assessment of, my lord, as to how much he should pay for the period of occupation. And, my lord, that is now pending, my lord, before the division bench. They preferred an appeal.
And are you not pressing the application against me?
No, apna to order already achi hoga na.
No, that's a mess here. That was the third point I'm going to make. In the claim which they made in this application, that claim is all the obtain another order from your lordship for payment of that amount.
How can
double payment asking for?
We have not made.
And
My lord,
that
we
is-
are only on sale, my lord, who's occupying 75,000 square feet. I don't think, my lord, my
We are
lord,
not.
apna to order achi sir.
No, we have given up.
But we'll show the order, my lord.
Very well. Mr.
Why I couldn't follow it?
Yes.
What wrong have I done?
I'm not pressing anything against you. There's already an order. That's what I'm saying.
No,
Mr. Ghosh, yes, when we do produce that 2-page points. Mr. Ghosh, if you cannot produce it in 2 pages, then no notes at all. I will pass the judgment according to my own understanding of the matter.
It was next week, then on the following Monday.
That is the system which I follow in my court for all counsel across the board. 2 pages, not more than that.
My lord, you'll hear me after Mr. Ghosh. Hear me after Mr. Ghosh on Tuesday or whatever date. Whatever date.
10th. Duto week hoye berigal.
I can't understand. Are you not using the microphone because you're scared of being refused? Yes.
First May is next Monday. First May is next. Monday, first May is next
Monday week. I was.
Monday week. Which is first 2-page note.
But I have 7 judgments more to cite. I'll put them in the note.
In the note
citation.
with the paragraphs.
Yeah.
Yes. Heard learned counsel appearing for the respondent number 3 / sale SAIL sale. Stop. Counsel seeks to file his short points before the matter is taken up on 1st May 2023. Stop. List as counsel prays that the matter be taken up on that date. Stop. List this matter on 1st May 2023.
Grateful.
But will my lord, pleasure to hear defense number 8 after hearing defense number 3 on the next date of hearing till I come ready, Miller.
Yes, I can hear you, Mr. Mitra, but for a limited
After
amount
it
of time.
completes.
For a limited amount of time.
Good.
Yes. And you let me know what is the fate of the appeal, because if there are overlapping submissions, then I may not need to hear you.
The appeal of that is pending.
Yes, your appeal.
That's right. Appeal word.
Your appeal from the direction, my lord, giving, my lord, what, my lord, rates would be
That
given.
was judgment upon admission. Judgment of my lord, judgment was completely in my favor, in my client's favor. But the order has gone against. So my lord, appeal has been filed. Appeal has been hearing concluded.
They have also filed a cross appeal.
Very
Yep, they have filed a cross objection, cross appeal that has also been heard. But that is relevant only for the purpose of showing the claim made against me in this into application is covered by the claim made by them in that other application. That is an additional point. They cannot get double payment.
I have not asked any of this.
Very well. Yes. Call on the next matter,
claim.
please.
Give up the claim. I think.
Item number 3, Journal of India Limited versus Sarasa Towers.
Now there are 2 applications. Well, I'll tell my lord what has happened. My lord, there was one property, half of my lord, which was owned, my lord, by Dunlop, my lord, which has gone into liquidation, half, my lord, owned by me. My lord, there was a restrictive covenant, my lord, so far as the, my lord, property, my lord, owned by Dunlop was concerned. My lord, there was a covenant that, my lord, it's going to be sold to me. If they, my lord, it's going to be sold at all.
Yes.
My lord, I made an application in liquidation and I, my lord, obtained an order saying, my lord, that when it is put up for sale, then my lord, whatever the highest price is got, I will match that price, and my lord, I should get the property. This is an order which was subsisting. Now, my lord, when the advertisement was made, another my lord, company called Eyelid made an application saying that no, according to them, there was an agreement for sale in 2006, which was entered into between Dunlop and them for the purpose of purchase of this property. And my lord, they obtained, my lord, really, my lord, a sort of, my lord, a status quo, my lord, with regard to, my lord, when the sale was concerned.
Yes.
And this application, my lord, will find, my lord, the order which my lord was pleased to pass. Because I, my lord, want to, my lord, purchase, my lord, this my part of the property, so that, my lord, I can, my lord, the CA 83 is, my lord, their application, and my lord, my application is CA 199.
Yes.
My lord, Justice, kindly look at, my lord, order a copy. The two orders. My lord, if in CA 83, if my lord looks at page 15, this is the order, my lord, which was passed on my application.
Yes.
Other side, kothay? My lord, oh, sorry, my lord.
Yes. You were Salazar?
I'm my lord Salazar.
Yes.
Page?
Yes.
I'm sorry, my lord. Page 15, my lord, of that affidavit, my lord, will find. This is an affidavit in opposition filed by me in CA 83. Page 15, my lord, should be an order of 3rd February 2021.
Yes.
This I'll just quickly, my lord, run through the order, my lord. This application has been taken out by one Salazar, which is, oh, achha.
Yes.
This application has been taken out by one Salazar Towers Private Limited, which is 50% owner of the property known as King's Court, situated at 46B Chorangi Road. Other co-owner of the balance 50% one Dunlop India, which is presently in liquidation. Applicant relies on documents to show that it has a right of preemption as regards the 50% of the property owned by Dunlop. Otherwise, if Dunlop and presently, if the official liquidator who is in custodian of the assets and properties of Dunlop intends to sell the said 50% shares in the property, first offer has to be made to the applicant. Dunlop has huge debts. It has innumerable creditors, secured and unsecured. It is in public interest that if a property of Dunlop is sold, the same should be sold through public auction so the highest possible price can be fetched for the benefit of its creditors. Official liquidator should set on motion the process of sale of the property in question. Once offers are received from the intending purchaser, official liquidator and the court would know the highest price obtainable for the property. If the applicant, that is me, can match the highest bidder, then the applicant's claim should be considered favorably in view of the right of preemption.
Yes.
That exists in its favor. Needless to say that it will be necessary for the official liquidator to first obtain valuation report of the property in question from a recognized valuer before he can proceed any further. Official liquidator will be entitled to appoint the valuer for the purpose of valuation. Then, my lord, this order was considered, and my lord, the time was extended by my lord, an order of page 17. My lord will find that.
Yes.
My lord, order 6 September 2021. And no appeal, my lord, from that other, my lord, first order of, my lord, 2021, February 2021. Then report of the valuer pursuant to an order dated 3rd February passed by learned single judge that this court is filed in court today, kept on record, appears from the record that the aforesaid order was passed on an application taken as such. Then must see learned counsel appearing for the applicant, namely Salazar, submits, officially directed to proceed with the sale of the property and received offers from intending purchasers. Salazar will given liberty to match the highest bidder once the offer is received. In view of the fact the valuer's report has been filed in court today, CA Sansat should be listed on 24th. Approved, the official legal shall be at liberty to make necessary newspaper publication in the meantime for receiving offers for sale of the property in question. This was my lord's order. Then my lord, Eyelid came in, my lord, which is CA 83. And my lord, they came and relied on, my lord, some letter, my lord, from Dunlop saying, my lord, this property was sold to them, or my lord, there was an agreement for sale in 2006. And my lord, now an order has been obtained, my lord, because my lord, quite naturally, my lord, thought that this should be examined.
Yes.
Now, my lord, this Eyelid, very interestingly, Eyelid, my lord, this applicant, my lord, in CA 83.
Mr. Rupak Ghosh was appearing?
Yeah, absolutely, my lord.
Yes.
Absolutely. And my lord, it's a sister concern of, my lord, Dunlop itself. They have common directors. And all those, my lord, documents, my lord, I have disclosed, my lord, in my affidavit. If my lord finds, my lord, in my affidavit, which my lord is considering, my lord will find, my lord, that page 19.
Yes.
Let's see page 9, same.
Yes. Yes.
Malad, page 19, 19, malad, it will be malad a document malad from the register of companies. Malad sees at the top, Eyelid Mercantiles Private Limited.
Yes.
And malad sees malad the name of the directors, Ritobroto Adak and Shamsundar Dhan. And these two same gentlemen.
Yes. Yes.
Malad, I'll show malad that. And now malad kindly sees page 20. I'll show malad how they malad part of malad this Dunlop group. Page 20 malad is a annual return malad of annual report malad of Dunlop. Malad will find the year 2010, 2011, and malad will straight away kindly come to page 61.
Yes.
Malad sees page 61 on the left hand side, the small malad Roman 8A3. Malad sees 8A3 associates to group companies.
Yes.
And then malad kindly see page 61 on the right hand side, item 65 malad is Eyelid Mercantiles Private Limited. In the middle of the page, malad will find item 65 malad in that group.
Yes.
65 malad is Eyelid Mercantiles Private Limited. And at the top also malad, item 40, about malad 5 lines from the top, malad will see Dadar Properties and Finance Private Limited. There malad shareholders of Eyelid, majority malad, in fact 100%, I think 100%. Majority shareholders are malad Eyelid Mercantiles.
Yes.
So malad, it's a self-dealing malad where malad there's, and I'm sorry malad, just to complete this, page 87. Malad financial statement malad of Dunlop malad will find Dadar Properties and Finance Limited malad is malad, it starts at page 86 malad, which is malad Eyelids from AOC, where malad Dadar is shown as malad the holding company, page 87.
Yes, I've seen that.
Malad has seen that. And then malad page 100, 100 malad will find 99 also malad is the Dadar Properties malad showing malad it's a holding company of Eyelid, page 99. From MGT 7 malad, file malad with the register of companies. Eyelid Mercantiles at the top malad will find, and malad full name of shareholder malad is Dadar Properties. Then malad page 100 is malad that gentleman Ritobroto Adak malad, who was director of malad, will see all other associate companies of Dunlop, right malad from the beginning. Number 2 is Dunlop Visa Services.
Yes.
Then malad Ruya Agro.
What is the point, Mr. Banerjee?
Point is malad that two things. First of all, malad, they rely on malad an agreement for sale in their reply to this, to say that there was an agreement of sale entered into between Dunlop and them in 2006.
Yes.
We are now malad in 2021 when the matter came up with regard to this property, according to them. So malad, first unregistered agreement for sale, even if we were to assume that that is a genuine document, even we were to assume, malad doesn't give malad any right to them to malad claim that property. So they have no right in respect of that property, where malad I have been already held to malad have a right of preemption, which I want to buy at the market price after it's sold. That's first submission. Second submission, I'm showing malad Eyelid itself malad is a group company. So it's self-dealing. Eyelid, Dadar, everyone is group company malad. Now Dunlop's property gets malad purportedly sold to its group company for malad, they say malad 8 crores or something like that malad in 2006, which malad should not be believed by court. That is malad what my second submission is. But I'm on the first submission malad, they have no right, title or interest in the property. So malad, my order which malad has been passed by court on the 2nd of February 2021, that should subsist. Official liquidator malad should advertise the property now. They're already advertised it once. Whatever the highest price they will get, market price, I will match it. If I can match it malad, it will come to me.
And Eyelid came to stay that process, saying what?
Saying malad, this is the application 83, saying malad, they are entitled to the property. Malad, this is page 83. Malad, they wanted recalling of the order of 6 September, which malad was pleased to pass.
Notice and execute the return.
And malad, kindly see malad, their prayer page, this CA 83. I don't know
Yes.
how, my lord, they said directing the official liquidator to disclaim the undivided half share of the property. Then they say execute and register deed of conveyance. That's prayer B. And C, my lord, is notice dated 9th September be quashed. And my lord, E is ordered at 6 September 2021, which my lord I showed, my lord, where my lord directed that the official liquidator should advertise now and get the price. That should be recalled. So, my lord, I am saying, my lord, there's no basis of making this application at all. They've not been able to show, my lord, how, my lord, or whether, my lord, at all, how, my lord, the property belongs to them. So, the interim order, my lord, which they obtain, my lord, that will have to be go and their application will have to be dismissed. That is my, my lord, submission. Because there's no basis.
Very well. Yes. Who is for eyelid?
Lordship, I am for the official liquidator, your lordship, in this matter.
And official liquidators filed an affidavit, my lord. They have really, my lord, not supported eyelid's case at all. They have not said, my lord, that the property was, my lord, belongs to the company itself. That is, my lord, their case also.
Very well. Learned counsel appearing for Salazar Towers, being the respondent number 2 in CA 83/2021, which is an application filed by eyelid mercantiles, has made his submissions. Stop. Counsel has placed documents to show that that Salazar has a right of preemption in respect of the said property and has a declaration to that effect. Stop. Counsel has also placed an order passed by a coordinate bench on 3rd February 2021, which records that the property of Dunlop, being the company in liquidation, is required to be sold and fetch the highest possible price for the benefit of the creditors. Stop. Counsel further submits that counsel also shows places documents to show that eyelid and one Dadar, D-A-D-A-R, Dadar what?
Properties.
Yes, Dadar Properties are group companies of the company in liquidation, of Dunlop. Stop. Next, counsel accordingly seeks confirmation of the order dated 3rd February 2021. Stop. Next, no one appears for eyelid/applicant. Stop. Do you have an application or you are the respondent number 2?
No, I have a CA 199 on which the order was.
That is in the list. Yes.
Item number 3.
Salazar also has an independent application. Next paragraph, Koro, being CA 199.
Yes, 19.
199 of
2019.
2019. Stop. Next, what have you prayed for in that, Mr. Banerjee?
Well, that's on which one of the order was passed. One of the 3rd February order was
Very
passed.
well. The order dated 3rd February 2021 was passed on this application. Stop. Next, list this matter on. Tell me, Mr. Banerjee, I will ask you to communicate this order on eyelid.
Well, next week, if I'll tell you only one line of my submission of urgency. This property is not in a very good condition. So we also want to repair it. So if we get the other half, if we are successful.
Where is this property?
Well, then 46 Chorungi. 46 beach.
Arecta submission okhane add kore dao. The council submits that the property in question, comma, which is at Chorungi, 46 Chorungi Road,
46B.
comma, 46B, capital B, Chorungi Road, comma, is not in a good condition and requires to be sold as soon as possible. Stop. Next, list this matter on, tell me when you want it.
Next week, my lord, if possible, my lord, I don't know if Monday, Tuesday, Wednesday, or my lord, after that 3rd, 4th, 5th May.
I'll keep it on 28th.
No, 28th, my lord, I have some difficulty. I'm so sorry, my lord.
They will,
May, my lord, except for 2nd May, any day, my lord.
yes, list this matter on 3rd
I'm grateful.
May 2023.
I'm extremely
as
grateful.
grateful. Yes,
And we'll intimate, my lord, this order, my lord, to
yes,
the other side.
this order shall be communicated on eyelid.
We'll do that, my lord. I'm so grateful.
Yes, follow the next one.
Item number 5, Double of India versus out of the hotels.
Lordship, in this matter, and for the applicants and for the official liquidator, I am led by Mr. Tilok Bose, your lordship. Item number 5 and 6 are analogous matters, your lordship. So I'm just praying if a date can be fixed for hearing of these applications.
What is the prayer in the application?
Lordship, this is an application for fraudulent transfer, your lordship.
For what? For
Transfer.
what fraudulent?
Transfer. The properties have been fraudulently transferred. For this application has been
Transfer to who?
transferred to the other creditors, your lordship. So that is the reason, your lordship. This
What other creditors? You don't have a respondent in the application.
Lordship, respondents are not appearing today.
I'm asking you who the respondents are.
Lordship, that pardon me, lordship. Today I have the papers are not proper with me, your lordship. That is
Very
the
well.
difficulty.
Learned counsel appearing for the official liquidator is not ready. Stop. List this matter on when is Mr. Bose here?
Lordship, today he has just left the court. সেটা যে কোনো দিন বলেছে।
List this matter on 28th April 2023.
5 and 6, your lordship.
একই order হয়ে পড়েটা।
Item 6.
Double sister double.
Thank you.
Same order in 6.